Good afternoon, everyone. Thank you for joining us this afternoon for the board's first permit appeal hearing. I am Sheena Brooks. I will be your board clerk for the first half of today's hearing, and Evelyn Nuno will board clerk for the second half of the hearing. Today, we are joined by the following Board of Environmental Safety staff persons: Swati Sharma, our executive officer; Greg Forrest,
recording in progress;
Linda Ocampo, the senior staff engineer; and Evelyn Nuno, the board clerk. I would also like to introduce and thank today's support team, DTSC OEIM staff, who assist with all of our technical needs: Arvin Agolto, Isabella Asman, and Jason Rayleigh. DTSC communication staff, Adam Calvillo-Kane. He helps with the audio and visual setup, including the cameras and our YouTube video editing. California State University Sacramento staff, who assist as our Zoom facilitator and registration, Gabriella Cinquini and Sue Woods. And from Cal Interpreting and Translations, we are joined by our two Spanish interpreters, Jeanette Hernandez and Leticia Reyna. From Cal Recycles AV Services, who are currently live streaming today's hearing, Josh Levesky, Abe Myers, and Joaquin Murrieta. Today's permit appeal hearing is being live streamed and recorded, and by your continued participation is acknowledgement that you are being recorded. Today is November 29th, 2023 at 1:13 p.m. and the hearing is now called to order.
Thank you, Sheena. Will you call the roll of the board, please?
Thank you, Madam Chair. Jeannie Rizzo.
Present.
Sushma Bhatia. Georgette Gomez. Alexis Strauss-Hacker.
Present.
Lizette Ruiz.
Present.
All members are present. A quorum is established. I will now review some logistical items for today's hearing, which we are conducting in person, as well as offering remote options for public participation by phone and Zoom. For those of you joining us on Zoom, I would like to instruct everyone to select their preferred language options so that you will be able to fully participate in today's hearing. To do so, everyone needs to select the interpretation icon on your Zoom toolbar, which is located at the bottom of your screen. Here you will see three options. Please select your language preference by selecting either English or Spanish. If you select Spanish, you will be placed in the Spanish interpretation room. Please note, if you do not see the interpretation icon, you may need to update your Zoom application. For participants who have joined in person and would prefer to participate in this hearing in Spanish, hearing materials are located on the registration table, and we also have headsets located on our interpreter station located on the table towards the back wall. Please make your way to the station and a staff person will assist you. For those of you in the room, due to the building's low internet bandwidth, we ask that you not connect to the community center's Wi-Fi. Please either use your mobile.
I cannot hear you at this moment. Give us a second.
Thank you.
We can hear you now.
Okay. So for those that are joining in person, do not use the community center's Wi-Fi. Please either use your mobile data or mobile hotspot. Additionally, if you're following along on Zoom, please ensure that both your speaker and microphones on your devices are muted.
Sheena, I know.
If anyone experiences connectivity issues with Zoom, you can call in for either English or Spanish. The phone numbers are provided to you now on the slide.
Recording in progress.
And they will also be provided in the chat. Okay, so at this time they lost internet connection, so I will pause until they restore that.
Hey, Sheena, I think I will take over for clerking for right now as we figure out the sound issue. As we figure out the sound issue. So from where Sheena had left off, again, for those on Zoom, my name is Evelyn Nuno. I am the board clerk. Following up after Sheena Brooks. She had left off from what we heard for participants who had joined in person and would prefer to participate in this hearing in Spanish. Hearing materials are located at the registration table outside towards the hallway. Please make your way to the station for a staff person to assist you. For those of you in the room, due to the building's low internet bandwidth, as you can tell, we ask that you do not connect to the community center's Wi-Fi. Please either use your mobile data or hotspot. Additionally, if you will be following along on Zoom, please ensure that both your speaker and microphones on your devices are muted. If anyone experiences connectivity issues with Zoom, you can call in for either English or Spanish. The phone numbers are provided to you now on the slide. Excuse me. They will be offered to you on the slide soon, or in the chat, and they are also posted on our website. So hopefully we will now hear from one of our interpreters to provide these instructions for us in Spanish.
Hi, yes, thank you. I will do my best despite the technical difficulty. Muy buenas tardes a todos que están juntándose en esta junta esta tarde. Les voy a dar un poco de instrucción. Esperemos que me puedan escuchar bien. Tenemos un poco de técnica, problemas técnicos. Entonces, lo que les quería avisar un poco es de que si usted se quiere juntar a la junta en español, usted tiene la opción de poder asignarse sea al inglés o al español. Usted va a poder mirarlo en su pantalla. Abajo de la pantalla, usted debe de ver un icono que dice el español o en inglés, ya sea lo que usted escoja, si viene siendo por la plataforma de Zoom. Debería de tener el escoge de lenguaje. También, eso sí está solamente por la plataforma de Zoom, pero si usted está en persona y quiere escucharlo en español, tenemos equipo que está encontrado atrás, en una mesa atrás de la pared, que está en la mesa de registración para poder obtener equipos para poder escucharlo en español. También si usted está en persona y quiere juntarse a la junta por la plataforma, no use el internet que está disponible en el lugar. Usted debería de usar su propio dato de teléfono o el hotspot que le llaman para poder juntarse a la junta. También otra cosa, si usted quiere juntarse a la junta, sea por teléfono solamente, aquí está la información al frente donde usted puede llamar, juntarse a la junta en el español. Y después de que se junte ya ahí, ya puede escucharlo en español. También si usted no mira las opciones, van a estar puestas dentro del chat o también pueden encontrar toda la información dentro del sitio web de esta junta. Bueno, que tengan buena junta. Thank you. Back to you.
Thank you so much. I will now review some logistical items for today's hearing, which are conducted in person, as well as offering remote options for public participation by phone and Zoom. For those of us joining on Zoom, I would like to instruct everyone to select their preferred language option so that you will be able to fully participate in today's hearing. To do so, everyone needs to select the interpretation icon on your Zoom toolbar, which is located at the bottom of your screen. Here you will see three options. Please select your language preference by selecting either English or Spanish. If you select Spanish, you will be placed in the Spanish interpretation room. Please note, if you do not see the interpretation icon, you may need to update your Zoom application. For participants who have joined in person and would prefer to participate in this hearing in Spanish, hearing materials, as I mentioned, are located at the registration table. Again, due to the building's low bandwidth, please use mobile hotspots, to be able to have this Zoom connect through everything. Yeah. Oh. It's oh, I see. Excuse me, sorry for the repetition. So meeting materials and logistics, evacuation info. Please look around now and identify 2 exits closest to you. In some cases, an exit may be behind you. In the event of a fire alarm, we are required to evacuate this room. Please take your valuables with you. The drinking fountain and restrooms are located directly across the hallway of this room to your left. The board will take a 35-minute break around 3:25 and a 15-minute break around 3:30 p.m. Agenda times may fluctuate to accommodate agenda items, and hearing materials are available at the registration table at the room in the hallway, and they can also be found on our website at bes.dtsc.ca.gov. Closed captions are enabled, and you can move the caption display or turn it off altogether. As some of you may recall, Zoom hackers interrupted one of our board meetings earlier this year. So as an extra precaution, we are taking several measures to protect everyone's virtual space and networks. We will use the Q&A function on our as our chat function to ensure that harmful spam links are not shared with our virtual attendees. The Q&A function will be reserved for those attendees that are experiencing technical difficulties or are unable to make verbal comments. Please clearly state at the beginning of your comment, please read aloud, and a designated staff person will notify me. To ensure that all our board members are fully present and focused on today's presentations and discussions, they are not reading or following along in the chat. All participants will remain on mute until a Zoom host unmutes them once recognized for comment. The video screens shared will be of the board members, board clerk, and presenters. Okay, now bringing everyone's attention to slide 5. This is the format of today's hearing. Once this logistical overview is complete, our board chair will provide her opening remarks. Item number 3, Linda Ocampo, our senior staff engineer, will give a 20-minute introduction of today's appeal. Item number 4, we will hear a 20-minute presentation from the appellant. Following their presentation, the board will have 15 minutes for any clarification requests of Earth Justice. Following Earth Justice, DTSC will provide us with a 20-minute presentation. And following their presentation, the board will have 15 minutes for any clarification requests of DTSC. For item number 6, we will hear a 20-minute presentation by Ecobat. Following their presentation, the board will have 15 minutes for any clarification requests of Ecobat. After that, next slide, yes, thank you. Which would take us to 3:25 p.m. We will take a 35-minute break and reconvene around 4 p.m. for public comment. We have allotted 90 minutes for public comment, depending on how many people have signed up to comment. We will allocate 3 minutes per comment. We will be utilizing comment cards for this agenda item. So if you have not already signed up to comment, I have some here at this table. They're also located outside at the registration table. So you may come up and take a comment card and turn it into myself, or just up here, or to the registration table outside. For item number 8, each party is allocated a maximum of 10 minutes for their closing remarks, including rebuttal, if any. The order in which the closing comments will be called is Ecobat, DTSC, and then Earth Justice. Before taking the last break of the day, item number 9, we will have final Q&A from board members for a total of 30 minutes to ask final questions of staff and presenters. We will take a final 15-minute break at 6:30 p.m. and we'll reconvene for item number 10 at 6:45 for board deliberations and a vote. We expect to adjourn at 6:45 this evening. Okay, to make a public comment, we welcome the many residents and industry and community organizations that are joining us today in Hacienda Heights for our very first permit appeal hearing. Item number 8, public comment will be held at approximately 4 p.m. As you have seen in our recent email notifications, we are using a new public comment sign-up system to create a more orderly process of identifying public commenters in advance. Sign-up is not required, but is strongly recommended to ensure you are added to the commenter list and proper time allocation can be determined. Thank you to those who have signed up in advance. For those of you who wish to comment during public comment, but were not able to sign up prior to the cutoff, please complete a public comment card, which is located again here and at the registration desk in the hallway. Turn it into me, and in order in which I receive the comment cards, we will determine the call order. After we have called on the sign-up list, of course, for those of you joining us on Zoom, can I please get a show of hands how many of you plan to comment during item number 8? Okay, seeing none, I will follow up when it comes time for public comment. I'll acknowledge each comment by first and last name as displayed on the sign-up sheet in Zoom. I apologize in advance if I mispronounce any names. If you have joined our, oh, I'm sorry. My sheets are out of order. Okay, sorry, continuing. These are just instructions on how to provide public comment. So again, there's the Q&A function, there is the comment cards. If you would like to express your comment in writing, you may submit it via email to besinfo@bes.dtsc.ca.gov. If you're experiencing technical difficulties or are unable to make verbal comments, you may use the Q&A function. Please clearly state, again, at the beginning of your comment to please read aloud, and a designated staff person will notify me. For your convenience, we will see a timer located on the screen. You will hear a chime sound when there are 30 seconds remaining, and then another melody when 3 minutes are up. The time allotted will be doubled for participants expressing their comment in Spanish to allow for translation. If you are commenting in Spanish, please let us know at the start of your comment. And that concludes the introductory review for today's hearing. I will now hand it over to Chair Rizzo for item number 2.
Well, welcome everyone. That was fun, wasn't it? Did y'all have a good time? Took notes. We all were going to remember everything you said, Evelyn. And I'm sorry for Sheena. She was very willing to join us remotely. So I want to welcome to board members and the public, those of you in person, the parties that will be presenting today. For this hearing, which is focused solely on the temporary authorization requested by Ecobat, formerly Quemetco, and approved by DTSC, which is appealed by Clean Air Coalition, represented by Earth Justice. This is not a hearing on the final operating permit for Ecobat. That is anticipated to be issued sometime around year end. We will limit the scope of this hearing to the temporary authorization of 2 pieces of equipment that Ecobat has requested. The parties in this hearing are, and I invite you to raise your hand so people know who's sitting where. For the appellant, Clean Air Coalition of North Whittier and Avocado Heights, represented by Angela Johnson-Mizaros of Earth Justice and colleagues. The permittee, Ecobat, formerly known as Quemetco, represented by Matt Williamson of Minot Phelps Phillips and colleagues. And the permitting division of the Department of Toxic Substances Control, represented by Division Chief Wayne Lawrence, Environmental Scientist Sam Coe, Assistant Chief Counsel Anna Catherine Benedict, and Senior Counsel Leah White. Hearing officers are the 5 appointed members of the Board of Environmental Safety, all present here today. I want to further acknowledge our Board of Environmental Safety staff members who've played a critical role in shepherding the process of this appeal. Linda Ocampo, BES Senior Staff Engineer, who'll be presenting shortly. Greg Forrest, BES Staff Attorney, who will raise his hand as our legal advisor and guru of law. and Swathi Sharma, BES Executive Officer, along with our support staff, Sheena Brooks and Evelyn Nuno. Per SB 158 legislative mandates passed in July of 2021, the hearing officers for this and all future permit appeals are the 5 appointed members of the Board of Environmental Safety. As you know, the final board appointments were made in February of 2022, and that marked the permit appeals transfer of authority from DTSC staff to the board. We fully recognize that everyone attending today has been patiently waiting for the board to hire staff, to be fully onboarded, and prepare itself for this important responsibility. As with other key mandates and in compliance with Bagley-Keene requirements, the board formed a working subcommittee on permit appeals, Lizette Ruiz and Alexis Strauss-Hacker, supported by our staff attorney and our staff engineer and our executive officer. Workshops were held and the board executed its emergency regulatory authority to revamp the process and procedures to both streamline and create full transparency and accountability for the decision we will make today. This took time and a tremendous amount of effort, and I want to thank all who contributed to our thinking, to all the members of the public and facilities and community members who attended our workshops. And I want to thank, they all contributed to our thinking and the final adoption of our regs, as well as to the time it has taken to fully review and prepare for this hearing. Today will be the first permit appeal hearing held by the board. In January, we will take up the second appeal, which is Lighting Resources, which has appealed its own permit issued by DTSC. Permits and any subsequent appeals have consequences to the facility and its essential operations, the community potentially affected by those activities, the department as it strives to meet its mandate to protect public health and the environment, and more broadly, to the expectations we set for the operation of permitted facilities going forward. We take this very seriously and are committed by our own operational and governance guidelines. For those of you who haven't read them lately, they're all up on our website. And now I've lost my place. Okay, yes. To be fair and impartial, to hear all sides of the issue before us, not to come in with presumed responses to anything, and everyone has really done that. I will say I'm really pleased with the way everyone has approached this. And we want to hear all sides, and that's the 6 people at the tables and the public and the community. So that's very important for us to know where all of this sits in the bigger picture of protecting health and the environment for the people of California. While we know that members of the public have challenges making time to attend public hearings, and for some, daytime is impossible. For others, evenings don't work. Weekdays are hard and weekends are harder. We schedule this from 1 to 7 in a sincere effort to bridge timeframes and allow for maximum participation for all to witness our vote and reasoning for our ultimate decision. And of course, as you heard, the Zoom is recorded and everyone will be able to watch it on Saturday mornings. All board and staff staff members of BES were provided with the essential documents related to this appeal, as well as to the administrative record. These documents have been posted on our website and will remain publicly available. We will conduct this hearing with absolute adherence to the agenda, the order of presentations and the time allowed for each presenter, public comments, and for the board's deliberations. For many of you who've attended past meetings of ours, this is unlike some of our more informal segments at board meetings and general meetings and workshops. We will not indulge cross-talk or ad hoc rebuttals. All parties have been apprised of the time limits and each segment of the hearing. We've allowed time for closing comments by one representative of each party, the appellant, the facility, and the department, as well as ample time for public comments. You heard that from Evelyn. So if you are thinking about making a public comment, it would be helpful to us to grab a card so we have a sense of how many people will be wanting to make public comments at that point in the hearing. As noted and worth restating, this hearing will deal with one issue only: the approval by DTSC of a temporary authorization granted in July 2022 to Ecobat and appealed by Clean Air Coalition of North Whittier and Avocado Heights, represented by Earth Justice. Copies of the agenda are available, and to recap, here's the order of the day. Linda Ocampo, our staff engineer, will provide an introduction, which will be instructive about the process, and you'll understand better how we proceeded to go through our process based on her presentation. Copies of the agenda are available, and then after Linda comes, the appellant, the department, which is DTSC, and the facility. You heard from Evelyn. Each will have 20 minutes for their presentation, followed by 15 minutes of clarifying questions from board members. After a break, we'll open it up for public comment. Depending on the number of registered commenters, we'll have a minimum of 3 minutes. I know maybe our posting didn't get that accurately, but it'll be a minimum of 3, and depending on the number of public comments, it could be more than that. It could be up to 5. Our own protocol and regulations call for 3 to 5. There was just a little glitch on that one. We use the standard that we use for our general meetings, but there will be 3 minutes. After a break, we will open it up at that point for the public comment. Closing arguments based on questions, comments, each party at the hearing will then be allowed another 10 minutes for closing comments. And we'll do that again in reverse order: Ecobat, then DTSC, followed by the appellant, represented by Earth Justice. Board members will then have an opportunity to discuss, to deliberate, and to ask any critical questions that they may have of presenters and/or staff. Our executive officer, Swathi Sharma, will facilitate that segment and direct the questions appropriately. Only the person questioned may answer. That's pretty standard. We're not having 5 people stand up for the same question. So Swathi has a big task to be sure that the question is directed as the person intended. Then we'll take a short break because we'll all need it, and we'll reconvene for any final discussions or clarifications that the board has with the staff. I will then conduct the voting process, a call for motions, and we will do that until such time as a majority of 3 of the 5 board members concur. That's our quorum. There's 5 of us. We need 3 people to vote up or down on this appeal. Once we have a final ruling, the final order will be prepared by the staff attorney. And as we've said, it goes into effect immediately, and we will provide that up on our website with a narrative rationale for how we arrived at that. As you know, all of our meetings are recorded. There are transcripts. There will be minutes of the meeting, and there's ample opportunity to gather the information that we need to augment the final order besides the decision. So that's welcome. That's my welcome in setting up the stage. So within 2 weeks, this is what I forgot. Within 2 weeks, a summary document with that rationale and the transcripts will be made available on our website, and they will then become part of the administrative record, right? They are now part of this whole effort. So I want to thank you for your interest and engagement in this process. And this transition of permit appeals to the board as part of the larger reform was driven by stakeholders' interest and concern. And so I just want to remind you that this SB 158 is in response to community and other stakeholder concerns around the process not being as transparent as it could be. In the past, permit appeals were dealt with by a permit appeals officer within the department and issued. we're having an open hearing. We've had open workshops. So we hope that that process and making this hearing then available online ad infinitum will help everyone appreciate the fact that it is an open, transparent process. So on that score, we'll now turn to Alexis Hacker to address an emergency request that we received less than 24 hours ago. So Alexis will address.
Thank you, Chair Rizzo. Yesterday, Earth Justice, on behalf of the Clean Air Coalition, filed a motion to strike to exclude some content in today's presentations by DTSC and Ecobat. Appeals of temporary authorizations, as we're hearing today, have some procedural differences. A 3-page brief is filed early in the process and doesn't involve filing a full petition, as would occur in the appeal of other permit decisions. The administrative record was made available to the board and the public. Rules of evidence do not apply in this setting or to appeals of other permit decisions. The ability of board members and the public to refer to material which gives context and allows for a fulsome discussion without bringing in other issues is critical. Some of the slides, such as photos, are not in the formal administrative records certified earlier, but aid in the board members and the public's awareness and understanding. You may note that some PowerPoint slides are for demonstration purposes only and not to introduce any new issues on appeal. We provided today's presentations in advance and are bringing this issue forward to you in the interest of transparency. The chair and I have conferred and decided to deny the motion. Each party will continue, as she had announced, to make its 20-minute presentations and then have the additional 10 minutes to make final comments, at which time they can comment on the materials presented today. I return it to you, Chair Rizzo.
Thank you. I think now we're going to hear from Linda Ocampo.
You know, my pull punched thing, I don't know what happened.
Okay. All right, good afternoon, Chair, and everyone present, both in person and remotely. Today we're hearing the appeal of DTSC's permitting decision to grant the temporary authorization for the Ecobat facility, formerly known as Quemetco, as introduced by Chair Rizzo. The appeal was filed by Earth Justice on behalf of its client, Clean Air Coalition of North Whittier and Avocado Heights. Now, before I get into the presentation, I'd like to first clarify that the intent of this presentation is to highlight the appeals process undertaken by the board. Specific details on the issues raised in the appeal and responses will be discussed in the presentations to follow. Now, in the agenda for today's presentation, we have, I'll first go over the content of the hearing packet. Next, we'll shift over to an overview of the regulations governing the granting and appealing of temporary authorizations. Following that, we'll look into the key events and developments leading up to this hearing. And lastly, we'll go over the board's appeals review process and decision to be included in the final order. The hearing packet contains key documents to help with today's proceedings. It includes the agenda to help navigate through the various segments of the hearing. Also, our clerk and chair will be leading us through every segment of today's hearing. The packet also includes the written statements submitted from the appellant and opposition statements from DTSC Permitting and Ecobat. The presentations to follow will be centered around the arguments and responses outlined in these statements. We have also included a draft version of the final order that will be used to memorialize the board's decision on the appeal. And I'll just repeat again what Evelyn, the chair, had mentioned. The digital copies are available in the chat. There's a link that's been dropped in the chat. They're also available at the registration table. All right, so before I get into the regulations, I'd like to first provide a summary of the actions leading to this appeal. In June of 2022, Ecobat filed a request for a temporary authorization to implement the dewatering project. Now, this temporary authorization constitutes a modification to the existing 2005 operating permit. It is not associated with the renewal permit discussed in previous public meetings. On July of the same year, DTSC permitting reviewed and approved the request. And in August, Earth Justice, on behalf of Clean Air Coalition, referred to as the appellant from now on, appealed this decision. In agreement with the new regulations adopted by the board, the appellant refiled the appeal on June 30th of 2023. All right. So now we'll get into the regulations for issuing temporary authorizations. But first, I want to set the stage with an understanding of what permit modifications are. Permit modifications are changes a facility can make to the existing hazardous waste permits. These modifications are classified into different categories, for instance, Class 1, Class 2, and Class 3, based on the scope of changes. Essentially, the greater the scope of the change, the higher the classification number. So how does a temporary authorization fit in the context of permit modifications? A temporary authorization is a short-term permitting tool designed to expedite the implementation of certain Class 2 and Class 3 type modifications that meet the criteria. Now let's get specific to the regulations for temporary authorizations. As we'll see here, the regulations facilitate this expedited process. For instance, DTSC may grant a temporary authorization without prior public notice and comment. This is meant to streamline the approval process compared to the lengthier process for permit modifications. In some cases, a facility may request a temporary authorization before submitting a Class 2 or Class 3 permit modification request. This is a strategic approach to enable the facility to expedite the changes while their modification for permanent changes is under review. The temporary authorization is limited to a term of 180 days as it's designed to address time-sensitive conditions or provide short-term solutions. Now, DTSC's permitting is required to make a decision as quickly as practical to ensure a faster turnaround compared to the permit modification reviews. And given the flexibility and advantages offered by temporary authorizations when granting, the department must ensure that A, the activities comply with the environmental standards of Chapter 14, which are the standards for owners and operators of hazardous waste facilities. DTSC must also find that B, the temporary authorization is exempt or meets the applicable CEQA requirements, and C, that the temporary authorization is necessary to achieve one of 5 listed objectives before action is lightly taken on the modification request. Now I'll try to attempt to break this down, especially C. The objectives are essentially time-sensitive conditions that need to be addressed. For example, the objective is to facilitate timely closure or corrective actions, to enable temporary storage of hazardous waste, preventing disruptions on waste management activities, responding to changes in waste management, and protecting human health and the environment. Now, the phrase before action is likely taken on a modification request refers to a critical timeframe consideration. But for better interpretation of the purpose of temporary authorizations, we often turn to the federal rulemaking documents. Now, because California regulations on temporary authorizations mirror the principles outlined in federal rules, at times the nuances in the intent and purpose of temporary authorizations are drawn from comments and EPA's final rule on permit modifications dated in 1988. This is helpful to gain insight into the practical meaning of phrases like before action is likely taken on a modification request. And I raise this primarily to shed some light on the origin of the interpretation of phrases like this that are used in the appeal. Now, the public participation requirements are shaped by the permit modification process. The key difference between a temporary authorization and a permit modification process lies in the level and extent of public involvement. With a temporary authorization process designed to address urgent and time-sensitive conditions, the emphasis is on informing the public rather than engaging in a public participation process. The permit modification process, on the other hand, requires a more extensive public participation process, as we can see here. This involves engagement with the community to gather insights and concerns. Now, based on the differences, the regulations for temporary authorizations attempt to strike a balance between promptly addressing time-sensitive conditions and community awareness. And now, when the urgent conditions are absent, the regulations allow for greater community engagement that can help identify potential issues or considerations that might not be immediately evident to regulatory authorities. This in turn contributes to a more informed decision-making process. Now, what does it take to file an appeal for decisions on temporary authorizations? Effective May 1st of 2023, the board adopted the new permit appeal regulations that replaced previous under section 66271.18. Any person may file a petition to appeal DTSC's decision on a temporary authorization. The petition for appeal must be filed no later than 30 calendar days after DTSC's permitting decision. Now, a notable change here is a reduced briefing period. Unlike the previous appeal process, the board does not issue an initial order in this case. Rather, the appeal is decided by the board at a public hearing. These changes were made in an attempt to streamline the appeals process for temporary authorizations. From this point on, I'll go over the specific activities related to the appeal of the July 2022 temporary authorization. Again, to reiterate, on June 2022, Ecobat submitted a temporary authorization request to advance the dewatering project. On July 22, 2022, DTSC approved the temporary authorization. The approval was issued for both the installation and operation of the dewatering system. In light of the information provided in the request, DTSC found that the activities of the dewatering project were necessary to facilitate other changes to protect human health and the environment before action is likely taken on a modification request. And that is one of the 5 key objectives of the regulations. Now we'll look into the chronological sequence of events leading to this hearing. The appeal process was initiated with the appellant filing the initial appeal in August 8 of 2022. This also marked the beginning of the stay of the effectiveness of the temporary authorization. Now, at this point in time, the appeals process was put on hold until the new regulations came into effect on May 1st of 2023. These new regulations require the refiling of all existing appeals, including this one. And before refiling the appeal, the appellant requested the administrative record used to support the approval of the temporary authorization. On May 30th, DTSC provided the administrative record to the board. The administrative record primarily consisted of documents associated with the request and approval of the 2022 temporary authorization. The record also included documents related to the request, approval, and appeal of the 2021 temporary authorization, which decision was later vacated by DTSC's appeals officer in a response to the appeal. On June 30th, 2023, the appellant refiled this appeal. By July 28th, DTSC and Ecobat submitted opposition statements, and also on the same day, the appellant filed a motion to complete the administrative record Per the appellant, this motion aimed to include all relevant information related to the 2022 temporary authorization approval. By October 5th, the chair and vice chair granted the appellant's motion to complete the administrative record with respect to 6 documents and signal the certification of the record. In preparation for the hearing, the board also sent out public notification mailers to the contact list maintained by DTSC's public participation units. And that leads us to today, the hearing to decide on the appeal. Now we'll go into the board's review process for reaching a decision on the merits of the appeal. The review process was kicked off by evaluating the written statements to identify the issues raised and relevant standard of review. Next, factual claims were verified by examining the administrative record, including the files added through the appellant's motion. Now, as it relates to evidence, the Standing Order 2302 adopted by the board currently limits evidence to materials within the certified administrative record. The board will complete its evaluation process today by assessing the information provided during the presentations and public comments. Board staff will also participate as needed to support the board in the evaluation. Now, after carefully considering all factual claims, interpretations, and evidence presented today, the board will decide to grant or deny the appeal. The decision will hinge on whether DTSC's decision to grant the temporary authorization rests on facts that are clearly erroneous. So what will unfold after the board's decision? Should the board decide to grant the appeal, the temporary authorization approval is reversed and set aside. Conversely, if the appeal is denied, the temporary authorization becomes effective for a period of 180 days. This is, of course, contingent upon the board's determination that DTSC's decision was sound and in compliance with regulations. The board's decision to grant or deny will take effect today. Now, given that this is taking place at a public hearing, the rationale behind the board's decision will be formally incorporated into the final order at the closing of this hearing. And a finalized version of the final order, along with the minutes and transcript from this hearing, will be issued within 30 days from today. I know it was mentioned 2 weeks, it was 30 days from today's date.
Thank you for that correction. Thank you.
And this concludes the board's staff presentation. Thank you all who joined us today, and I'll turn to the chair.
Thank you, Linda. And today now we will hear presentations from all 3 parties involved. And I think there'll be a clock. I don't know if there'll be a clock, but we can be the clock if it doesn't show up on the website. So we are now going to hear from Earth Justice, representing Clean Air Coalition of North Whittier and Avocado Heights. Welcome, Angela Johnson-Mazaros.
Thank you. I could just have a second to set things up. Okay. I'm old enough to know you just have to take a minute and set yourself up. I'm ready.
We couldn't hear you.
Enough to know.
I'm old enough to know that you just have to take a moment and set yourself up.
Absolutely.
Okay.
It's 2:01.
Thank you. Good afternoon, Madam Chair and members of the board. I'm Angela Johnson-Mazaros, appearing today on behalf of the Clean Air Coalition of North Whittier and Avocado Heights. I'll refer to them as CAC going forward. This hearing today is about a single facility, and it is also about so much more. Our client sent us here today to demand integrity in DTSC's permit modification program. 16 months ago, CAC challenged permitting's decision to approve a facility's second request for a so-called temporary authorization to operate certain equipment it has already installed in its facility. A temporary authorization is a permit lasting for no more than 180 days that the department may, not shall, grant if and only if necessary for certain listed objectives before action is likely to be taken on a modification request. This permitting decision, like all DTSC decisions, must not be contrary to the law and must be supported by evidence in the record. Here, permitting's decision is neither. Today, permitting asks this board to embrace an interpretation of the temporary authorization regulation that is at best ill-advised. At its worst, it's catastrophic for public participation, transparency, and the integrity of the permit modification program. Permitting approved Quemetco's request in a short letter, not even 3 pages, in June of 2022. Permitting wrote, essentially, that a permittee can make significant modifications to its facility, quote, without the delay associated with the permit modification request, public comment period, and final decision, end quote, when the modification would allow a facility to, quote, better and more safely manage its waste. Because the normal permitting process, quote, could take between 6 months and a year from start to finish. Permitting's decision is unlawfully flawed for 3 reasons that I'll describe in more detail in a moment. Those reasons are, first, it does not align with the plain language of the regulation. Honestly, what modification request doesn't meet the standard that permitting proposes here? Permitting has proposed an interpretation of the temporary authorization request so broad that it swallows the whole of the permit modification rule. Second, permitting's determination that a temporary authorization was, quote, necessary before action was likely to be taken on a modification request is not supported by evidence in the record. In fact, the record shows that permitting had taken action on the modification request for the exact equipment at issue here before this temporary author request was even submitted. Third, DTSC's permit appeals officer has already rejected permitting's earlier effort to do exactly what it's doing here. When permitting approved Quemetco's first temporary authorization request, the appeals officer found that, quote, a temporary authorization should not replace a timely permit modification request, since the facility has been placing hazardous waste containing free liquids on the floor of the containment building since at least 2001. Permitting's temporary authorization is not and cannot be based on proper understanding of the law and the facts that are before this board. It is based on a clearly erroneous interpretation of the law and a clearly erroneous finding of fact. Additionally, permitting has exceeded the reasonable bounds of its discretion in approving Quemetco's temporary authorization request. We respectfully request that the board grant CAC's appeal and enter an order vacating and setting aside permitting's decision and direct the permitting division to deny this facility's second temporary authorization request. Now for more detail. First, permitting's interpretation of the temporary authorization process is not supported by the text of the regulation. The regulation requires an explanation of why the temporary authorization is necessary. But we suspect that all of us can agree that the goal of DTSC's permitting approvals is always to achieve environmental benefits that lead to better and more safely managed waste. And we suspect that all of us can agree that a permitting decision that bypasses the normal permit modification process, which involves at least a 60-day public comment period and the development of a full final decision by permitting, will always take less time than when those activities are bypassed. The regulation clearly seeks something more than permitting's bare assertion that the Class 2 permitting process takes more time to complete than the temporary authorization process. To further clarify this point, the board can take a look at the US EPA, which we know you've often looked at in the past to facilitate your decision-making on other issues. And while DTSC's regulation is not identical to EPA's in important ways, EPA's discussion of its rationale for adopting its temporary authorization regulation, an adoption that came prior to California's adoption of its own conforming regulation, can provide helpful context for understanding DTSC's regulation. There, US EPA explained that it recognized that it would be helpful to create a system to modify RCRA permits, which are usually written for 10 years of operation, without requiring a process akin to a full permit application needed for new RCRA permits. Basically, both EPA and DTSC's regulation allows the permittee to seek a permit modification using the Class 1, 2, 3 system, which has been noted here today. The less potentially impactful the change, the less public participation is required. No, I'm good. Yeah. The rule also gave EPA the authority to grant authorizations without prior public notice and comment for activities that are necessary for facility owners and operators to, quote, respond promptly to changing conditions, end quote. Put another way, EPA sought to make a process that would allow what it called rapid action when required to protect human health and the environment. The state of California adopted its own conforming regulation in 1991. The regulation did not, as permitting suggests, create a system that grants permitting authority to bypass the regular permit modification process whenever the modification request provides an environmental benefit. This is true even when permitting describes the purported environmental benefit as significant. Rather, it provided an opportunity to authorize changes necessary to respond rampantly to changing conditions. An example may be helpful here. Let's imagine there was a big fire that resulted in a large volume of hazardous waste that needed to be processed at a specific site. And let's imagine that to address this new material, the facility needed to increase its container storage capacity by 25%. That change would need a Class 2 permit modification. Finally, let's imagine that those containers would need to be on site for 120 days just to process that material. In this scenario, the temporary authorization process could allow DTSC to grant a temporary authorization to add that capacity to facilitate the treatment of that hazardous waste. Or maybe the containers would be needed there for 3 years. A temporary authorization would facilitate the facility's ability to begin processing that waste while it applied for and received a Class 2 permit modification. In this example, taking 6 to 12 months for permitting before the containers could be used would impede rather than facilitate the protection of human health and the environment. But this example is entirely unlike what has occurred here. In fact, here, Quemetco has been dumping lead-bearing material onto the batch house floor for decades. The need to address the excessive liquid that Quemetco dumps onto its floor is certainly important. But the mere fact that a modification is important, as are all Class 2 and Class 3 modifications, does not mean that the facility should be allowed to shortcut the regular permitting process. And permitting provides no reasons justification for why that should happen here. The regulation clearly requires a rationale beyond merely stating that to do so would allow DTSC to continue its mission, as permitting has asserted here. Quemetco's explanation why its second temporary authorization request should be approved is also very telling. In its application to permitting, Quemetco points out that CAC's appeal of its approved Class 2 permit modification and the, quote, long delays in the processing of these appeals, end quote, has meant that, quote, Quemetco has, in large part, not been able to operate the dewatering equipment to date. Quemetco now boldly asserts that, quote, only a temporary authorization would allow Quemetco to facilitate these proposed changes to protect human health and the environment, end quote. The application goes on to explain, quote, indeed, the delays caused by these appeals, or alternatively, the attendant delay in any processing of a modification, have led to circumstances where implementation of the dewatering project has become a matter of urgency. Board members, I cannot stress this enough. Getting around delays caused by an appeal is not an allowable use for the temporary authorization process. Second, permitting's determination that this temporary authorization is necessary before action is likely to be taken on a modification request is false. The regulations language is clear. A temporary authorization can be granted only after finding that it's necessary before action is likely to be taken on the modification request. Indeed, this requirement played a prominent role in DTSC's Permit Appeals Officer's January 2022 decision vacating permitting's first temporary authorization approval. The PAO actually emphasized this specific phrase to stress its importance. Nonetheless, in an action completely contrary to the language of the regulation and with blatant disregard for the PAO's decision, permitting approved this authorization after it had already taken action on a permit modification request for the exact equipment that's at issue here. Nothing makes it more clear how utterly baseless the claim is that this authorization was necessary before action was likely to be taken than the fact that the action had already been taken. There is absolutely no dispute that Quemetco requested a Class 2 permit modification for the exact equipment at issue here. And there is absolutely no dispute that permitting approved that request. But permitting and Quemetco want you to pretend that the approval never happened because Quemetco withdrew its permit request. This is nonsensical. First, what does it mean to withdraw a request that's already been approved? But second, and more importantly, Quemetco's withdrawal cannot and does not change the fact that permitting's action had already occurred. Or put another way, the withdrawal cannot and did not change the past. It only impacted the future. And Quemetco's withdrawal had two consequences. First, the board decided to dismiss CAC's appeal of the Class 2 permit modification approval as moot. And second, if Quemetco wants to operate the equipment that is now the subject of this appeal, it needs to restart its permitting process. But none of us, not even Quemetco and not permitting, can change the past. The fact that Quemetco does not have an approved Class 2 permit modification today is not because permitting failed to act. Rather, it's because Quemetco decided to withdraw its request. This board must refuse to ignore the plain facts before it. Third, DTSC's appeals officer has already rejected permitting's previous effort to do exactly what it's doing here. When CAC appealed permitting's requests for the exact equipment at issue here, the appeals officer vacated the approval. Permitting Quemetco asks the board to understand the decision is finding merely there wasn't a technical deficiency because Quemetco and permitting didn't include an explanation for why the authorization was necessary. But Quemetco ignores the finding that the officer made. That finding that, quote, a temporary authorization should not replace a timely permit modification request. Only one thing has changed between the time that the PAO made that finding and today. Now we know that permitting can, and in fact did, take action on the equipment at issue here, and it does not, and this decision does not meet the requirements of a temporary authorization, and this board cannot find otherwise. I'm going to conclude by highlighting 4 key dates and 4 key dates and 3 high-level messages. The permitting process here has been long, and it's easy to get lost in some of the details. We urge you to focus on 4 key dates. April 19th, 2021, February 23rd, 2022, April 9th, 2022, and June 24th, 2022. April 19th, 2021 was when permitting approved Quemetco's first temporary authorization request. This approval completely excluded the public, including our client, from participating in the permitting request, despite CIC's long and sustained engagement related to Quemetco's operations. Quemetco's assertion that there's been extensive opportunities for public comment ignores this fact. February 23rd, 2022 is when permitting approved Quemetco's Class 2 permit modification request for the equipment at issue here. And June 9th, 2022 is when Quemetco submitted a second temporary authorization request, even though permitting had already approved its Class 2 permit request on February 23rd. And June 24th, after submitting this second request, is when Quemetco withdrew its Class 2 permit request for this same equipment. DTSC's regulations requires that a temporary authorization may be issued if and only if it is necessary to achieve specified objectives before the action is taken on a modification request. This process is meant to facilitate agency action when circumstances require an expedited permit modification. Here, permitting's interpretation of the role of the temporary authorization process is not supported by the plain language of the regulation and therefore is clearly erroneous as a matter of law. Further, DTSC's determination that this temporary authorization was necessary before action was taken on a modification is clearly erroneous as a matter of fact, since permitting had taken action on the Class 2 modification. Finally, DTSC's permit appeals officer rejected the previous effort to issue a temporary authorization for this exact equipment and found explicitly that, quote, a temporary authorization should not replace a timely modification request since the facility had been placing hazardous waste containing free liquid on the floor of the containment building since at least 2001. The decision that this board is called to make today is critically important. Deference to DTSC staff does not mean that you can or should set aside your own ability to think critically about the information that's being permitted here today. I'd be honored to answer your questions.
I think we do all of them, right, in order, or do we ask our questions now? Sorry. I was so engrossed in your presentation, I lost track of the order of things. Thank you, Angela. Okay, so do we have questions from the board for Georgette? Any questions? Okay, Alexis.
Thank you for preparing the presentation. I am mindful, since this is our very first permit appeal, and the first such time it's being done in a public setting, how important it is that we come to a just conclusion here and make that decision known today. The standard for the board to go one way or another is that something is clearly erroneous. And as we track through the presentation you made and the sequencing of the first and second temporary authorization and so on, what is the clearly, what stands out to you and your client as the clearly erroneous element here?
So the clearly erroneous standard has two pieces. Clearly erroneous is a finding of, as a matter of law, and clearly erroneous as a finding of fact. And we believe that both are in play here. So the clearly erroneous finding of law or conclusion of law is that the temporary authorization process can be used when a facility has a modification request, regardless of whether or not it is required to rapidly address a changing situation or some other such standard that requires it to happen quickly. And the clearly erroneous finding of fact is that this decision wasn't necessary before a permit modification could be made because DTSC had already made a permit modification, had already approved a permit modification. I'm sorry, because DTSC had already approved a Class 2 permit modification for the exact equipment that's at issue here. And then there's the add-on point about an abuse of discretion. And DTSC permitting has abused its discretion by refusing to interpret the law and the facts in a way that is in accordance with the information that's in the record.
Thank you for helping me with that. It's, I don't want to put words in anybody's mouth here, but as I went through the materials and prepared for today, as we look at the two key pieces of equipment associated with the dewatering operation, my understanding is they have been installed but not authorized to operate. Is that your understanding as well?
Yes, it is.
And that at some point in the tormented sequence of events over the last many years, at some point, would your client and you represent that these pieces of equipment properly authorized need to be part of the operation, that you don't object to the equipment per se, you object to the manner in which this comes before us?
Although this is not part of the record, and I don't necessarily want to have a whole conversation, a side conversation about that, I will note that we have submitted extensive comments in the permitting process where we pointed out that this equipment that's being installed cannot and will not meet the objectives that DTSC has stated for it. So purportedly, this equipment is going to be used to dry this material, and that's going to be important moving forward. Am I getting into the weeds? This is a response to your question. So purportedly, it's going to be used for this purpose of drying that material, and that's going to be important for what needs to happen to the underlying floor. But if you look at the permitting process that's happened and the way this has been set up, we believe two things. First, the draft permit, which we've already commented on, will allow Quemetco to completely bypass using that equipment and still go along with this process and allow it to dump material on the floor today, just like it has in the past. So that's not helping. And secondly, we believe that this equipment is a piecemealing step on its way to remove the requirement that it completely redo the underlying floor in its batch house. And so for those reasons, we have strong objections to this equipment as a solution, as a purported solution to the problem that DTSC has identified at the facility.
I appreciate that you and I were asking a question of a larger scope than is before us today, but I appreciate your explanation and we'll keep those separate.
Thank you.
Thank you for that, Alexis. That floor has been on my mind as well, so I'm sure we'll hear from everybody about that piece of it. And I think your reference back to the permit appeal officer, DTSC's And for those, again, who may not be as familiar, in the past, a person not related to the permitting division elsewhere in DTSC is designated by the director as the permit appeal officer, who then reviews these. So the permit appeal officer at DTSC, who's not part of the permitting team per se, they have different people that they tag for that big job, works with attorneys. And in that instance, Carl's statement in denying the temporary authorization, you started to elaborate, and I wish you would a little bit more. What, if anything, is different now than was different in when that temporary authorization was requested? And I know DTSC will address that because they've expanded theirs, but from your perspective, because you've read all the briefs as well, how is it not different enough? How is DTSC's explanation of the difference meet you? Where does it meet you? So if you could elaborate on that, that would help me. Thank you.
I'm just turning to the permit appeals officer's decision so that I have it here in front of me. And if you have it in your binder, it is at tab 27. I'm sorry, it's at tab 28.
Okay.
I don't know, I have tabs
Okay,
because that's the way I do it.
Yeah.
Document 28.
28, right, okay.
So the question that was before the permit appeals officer was whether or not it was proper to use the temporary authorization process to permit this equipment. And there, the the permit appeals officer found basically two things. That permitting and permitting and Quemetco had failed to state clearly a rationale for why this needed to go through the temporary authorization process. And I'll just note that based on the entire application packet that had been submitted, it wasn't that they said nothing about it, but what they said was this needs to happen fast. And the permitting appeals officer rejected that. The second thing that the second thing of relevance here is that the permitting appeals officer on page 8, starting at line 8, said, considering that the facility has been placing hazardous waste containing free liquids on the floor of the containment building since at least 2001, Quemetco has not explained why a temporary authorization is necessary for the addition of the new equipment, the new miscellaneous units. A temporary authorization should not replace a timely permit modification request. That's still true. They've still been placing this material on the floor since 2001. They still should be submitting a timely permit modification request. And in fact, because as you know, this happened in January 2022, Quemetco did submit that request. So we don't have to speculate, as the permit appeals officer was doing then, about how long would it take. We know how long it would take because they did it. They went to the process and they made that determination. And that is still true. So, you know, as I tell my children, you can't change the past, you can only change tomorrow. And the same thing is true here.
I understand. So that the class 2 permit mod, which was withdrawn, was also appealed.
It was.
And so when they talk about timing, and I will ask them this as well. So permit mods take longer than temporary authorization, right? Yeah. Full-on permits take longer. A mod 3 takes even longer than a mod 2 because it's got public engagement component to it. So we recognize that we don't have the authority to change that. We can certainly make recommendations about that down the line, but we will hear appeals however they come, whether it's a temporary authorization, a mod, or a full-on permit, and really can't direct how it should have been done. We can only respond to what's in front of us in terms of why not go through the whole appeals process on the mod 2. So that's the part that's confusing that I'm hoping that all three parties will address, because that's the part that timeline, which you've all got in your slides somewhere, is the one that throws us off a bit, that says, how did this happen this way?
Well, you don't have to direct them to go through the process.
We can't, right?
You can't, and you don't have to.
We don't have
because
the
they
authority.
have.
Right.
They've already done it.
Right.
It's already happened. You don't have to send them to do a thing because they've already done the thing. So what you can do is you can interpret the regulation based on what it says on its face in its plain language. The temporary authorization can be granted if and only if it's required for action before a decision on a Class 2 permit modification request.
Right.
They've already done a Class 2 permit modification request and it's already been acted upon.
I understand. Thank you for that. I think we're close to time on key questions. Sushma has a question. Please do.
Thank you. Can you hear me? No.
I think you have to maybe hold it for a couple of seconds.
Okay.
Oh, is it working? Okay.
Okay. Thank you, Angela. I appreciate in your opening, you talked about how the issue in front of us is one of integrity in the permit modification process. So in that spirit, my question is your assertion that if this issue had gone through a permit modification process, then your clients would have had the opportunity to engage with DTSC and Quemetco to shape a different outcome?
Well, I can't claim what the outcome would be because that's outside of my control. But we would have hoped to influence that process through our participation. I think that that's baked into the rationale that DTSC comes to this whole entire permitting process. DTSC has public participation because not only because it's objectively meaningful, but also because they are looking to see what information is available. They are engaging in a process that requires critical analysis and multiple parties participating in that. So, and what I'll add to that is they did go through a Class 2 permit modification for this equipment. Our clients did participate in that process. It was adopted, but it was granted by DTSC. We appealed it, and subsequently to that, Quemetco withdrew it, arguing that they were doing so to address, they can attribute it in what they want, but what they argued was to address issues that were raised in our appeal. So our clients' participation in that process did, in fact, have impacts on the determination. And we believe that the comments that we've made in this last round of permitting also will have an impact on the outcome of that.
So fundamentally, I'm hearing you say that community engagement looks different in a temporary authorization situation versus a permit modification. In permit modification, when your client was provided the opportunity to participate, they did. In the temporary authorization situation, you were noticed, but you didn't have the opportunity to participate.
Exactly. No opportunity to participate. We just received a notice that it was happening. And so we participated in that first temporary authorization process by appealing it. And the permit appeals officer granted our appeal because our claim was correct.
Thank you.
Thank you.
All right, thank you. And Lizette, you have a question now? This is Lizette Ruiz.
Just to be clear, you believe that the ability for the public to participate made a difference in the outcome of the public participation through the public participation process of the Mod 2? And if so, in what way?
Yes, we believe that it did. We believe that public participation made a difference for the for the permit process. I think you're asking only about the Class 2 process now. So in the Class 2 process, there's two bits to this. First, public participation, transparency, and engagement of frontline communities who are impacted by things that happen into their community is in and of itself an important objective that should always be included, if not centered, in decisions that are made by state agencies about important things like the management of hazardous waste. So for principles that are far larger than simply the outcome on this permit, participation by the community is critically important. The second bit is the outcome of the actual determination, the actual permit that was before it. So through our participation, we were able to raise a number of issues. We were able to identify a number of concerns, and ultimately the Class 2 permit decision was withdrawn rather than continue through the appeals process. You'd have to speak to them about how they made that assessment. But what they said in their papers was it was because of our appeal. Thank you.
Okay, thank you. I think we're at time, and I think all of us have, Georgette, I'll give you last chance. Okay, thank you very much for that. We'll see you again later in the hearing. Okay, so now is it just the two of you presenting? Okay, so next up will be, pardon? Okay, since we have a lot of new guests in, very happy to see you all. Thank you for coming. We ask you to turn your Wi-Fi off. We're having a really hard time with access, so please don't use Wi-Fi. If you can use a hotspot, if you've got another device, that would be great. But the less traffic on the Wi-Fi, the more likely we are to see all the presentations and not be interrupted. So thank you. And again, thank you all for coming. All right, now Wayne Lorenz, who is the permitting division manager, and Leah White, senior counsel. Welcome. What did I say?
Thank you, Madam Chair and members of the board, for the opportunity to speak and present to you today. My name is Leah White. I'm senior counsel for the Department of Toxic Substances Control, representing the permitting division. I'm joined today by Wayne Lorenzen, the permitting division manager, who will be speaking later in this presentation. Today, we'll be presenting DTSC's permitting division's arguments about why DTSC's issuance of the July 22nd, 2022 temporary authorization was proper, should be upheld, and that this appeal should ultimately be denied. So I'm going to go through briefly our presentation overview and the key points we'll be discussing. As has been touched on earlier by other presenters, we will be discussing the standard of review. And what the standard of review is the burden that must be met in order for the board to be eligible and able to uphold the appeal that has been brought forward today. Next, we will be talking about the temporary authorization equipment itself and explaining what the two miscellaneous units proposed in the temporary authorization are supposed to do and why they provide valuable functions. Third, we will be discussing what a temporary authorization is and its unique functions in contrast to a permit, and walk through how it works as a tool and why it was appropriate in July of 2022 and why it may not be applicable in the current facts of today. Fourth, we will be discussing the historical permit appeal compliance issue, which has been discussed earlier from the previous DTSC permit appeals officer decision before the inception of the board. And finally, in conclusion, we will be discussing why all the facts present today support DTSC's decision that it made in July of 2022 when it issued this temporary authorization, and ultimately that this appeal should be denied. So as I mentioned, the standard of review lays out when the board can reverse a decision DTSC made. And in this case, the board's own regulations specifically lay out that the standard of review is set forth in California Code of Regulations, section 66271.72 C1. And in that spot, it states that only when there is a clearly erroneous finding of fact or conclusion of law can the board find that DTSC's decision was in error and that the appeal can be upheld. This is in line with California law and how many other boards across the state view decisions of this nature, and that deference is given to staff that have technical expertise and are able to provide guidance to the agency that made the decision. And so boards are able to use their expertise and rely on them by giving that deference. So in this case, that would be DTSC's permitting staff. This is also evident in the board's own rulemaking package. There was discussion about what standard should be applied, and there was discussion about the fact that a deferential standard was deliberately chosen to acknowledge the DTSC's permitting staff's deep technical knowledge because of the highly complex and technical nature of the permitting regulatory scheme specific to the hazardous waste. So under a clearly erroneous standard of review, it's recognized by the Supreme Court and US v. US Gibson Co. that a finding is clearly erroneous when the reviewing court is left with the definite and firm conviction that a mistake has been committed. In other words, there can be no doubt in the board's mind that permitting was wrong and made a mistake. And that's the standard of review we're operating with today at today's hearing. So unless Clean Air Coalition, represented by Earth Justice today, can show that a mistake was made, the default decision in any appeal is that DTSC's decision should be upheld and the appeal should be denied. Clean Air Coalition bears the burden of showing that the clearly erroneous finding of fact or conclusion of law occurred. If they cannot make that demonstration to the satisfaction of the board and give conviction that a mistake did occur, then the clearly erroneous standard can't be met and the permit should be denied. So in the circumstances today, looking at the temporary authorization that we are discussing for the appeal, the key takeaways of looking at this is that DTSC's decision was reasonable, it was supported by evidence, and it was not clearly erroneous. The fact that DTSC was looking at its decision, it's important to remember that this decision occurred in July of 2022. And as there has been previous discussion, that circumstances outside of this actual temporary authorization and anything present now is less relevant. And the decision that was made at the time back in the summer of 2022. Clean Air Coalition hasn't been able to find fault with any of these key issues. And so based on the applicable laws and facts, their appeal is unsupported. So now I'm going to transfer it over to Wayne Lorenzen, and he will be speaking on the temporary authorization and equipment further.
Thank you, Leah, and thank you, Wayne.
And thank you, Leah, Chair Rizzo, members of the board. I'd like to show some pictures to give everyone some context about the equipment and the temporary authorization, the compression auger and the centrifuge. This is not a picture of the equipment installed at Ecobat, but it might be useful for some who would like to know what a compression auger is and what it does. The purpose of a compression auger is to remove liquids from wet materials by compressing them and separating the liquids. Imagine coffee grounds from your coffee maker or a French press going through this equipment on the slide. The screw conveyor, the spirally thing, applies pressure to the ground, sending it through this upper area where the holes surrounding the shaft allow the liquids to escape. At Ecobat, instead of coffee grounds, of course, we're talking about the contents of shredded car batteries, which is a hazardous waste. Ecobat runs a machine that shreds car batteries and then separates the shredded plastic casings from the shredded contents of the batteries. So the plastic casings would not go through this, but the shredded contents of the inside of the batteries would. That material has liquids in it, including battery acid. Ecobat requested authorization to send that material through a compression auger, such as this one, to remove the liquids from the material before they pile it up on the floor. This slide shows a graphical depiction of a centrifuge, only meant to convey the concept. Your dryer at home or your salad spinner in your kitchen are good examples of centrifuge equipment that many of us routinely use at home. Materials with liquids such as washed clothes or freshly rinsed lettuce are spun in a container like a clothes dryer or a salad spinner to apply centrifugal forces to the material, which allows liquids to be separated from the solids. Ecobat requested authorization to send that same material, the shredded battery contents, through a centrifuge to remove the liquids before they place it on the floor. Both pieces of equipment remove liquids from the shredded battery contents. This slide shows the specific equipment that DTSC approved through the temporary authorization, which is the subject of this appeal. And these are not so great pictures, but they do show the actual equipment inside of Ecobat, and they're offered for demonstration only. They're not offered as evidence. The equipment on the left is the compression auger, and the equipment on the right is the centrifuge. The purpose of this slide is to show you the actual equipment installed at Ecobat. These are around, the compression auger is 20 feet long, just to give you an idea of dimensions, and the centrifuge is about 5 feet long. Although both pieces of equipment were installed before the appeal and the stay was issued, these are not currently operating. This equipment cannot operate, in fact, without authorization from DTSC, because they are both used to treat hazardous waste, which is the shredded battery contents. These are a couple of pictures from inside Ecobat's containment building. And again, these are also offered for demonstration purposes. These come from inspection reports. They're not offered as evidence. The containment building has a footprint, just so you have an idea of how large this building is, of 26,000 square feet, which is just a little less than half the area of a football field. In these pictures, you can see piles of the shredded battery contents and liquids seeping from the bottom of the piles. DTSC cited Ecobat for violations in this building associated with the batch house floor. The ground you see in these pictures is the batch house floor. DTSC directed Ecobat to fix this floor by submitting plans for DTSC approval to replace it. DTSC also directed Ecobat to remove the liquids from the floor until the floor is replaced. Ecobat submitted the request to operate the compression auger and the centrifuge to minimize the liquids in these piles, and DTSC approved the request in the temporary authorization. This is a clear improvement to the operations and a clear benefit to protect human health and the environment. And I just have a little bit to say about temporary authorizations. What are they? I'll go into a little bit of history of them. Temporary authorization, as Chair Rizzo indicated at the beginning of the meeting, is not the permit renewal decision, and it has nothing to do with the permit renewal decision. US EPA developed temporary authorizations as a tool for issuing authorizations quickly for changes to improve the management of hazardous wastes. In the Federal Register, US EPA explains their rationale for approving the tool by saying the following. They say, agency-issued temporary authorizations are intended to allow facilities to respond rapidly to changing conditions and to enhance the environmental protection at the site. There are allegations before you that DTSC was attempting to circumvent the public process by issuing the temporary authorization. And I just want to read you an excerpt from the Federal Register from September of 1988, when US EPA took public comments before adopting this temporary authorization tool. US EPA said, one commenter was generally opposed because of a lack of public comment and hearings. EPA disagrees because the use of temporary authorizations is allowed only for specified purposes, which are intended to improve the management of hazardous waste or respond to a critical situation. So DTSC used this tool as it was intended to be used to approve equipment that addressed enforcement actions within Ecobat that were designed to protect people and the environment. We made the right decision here. It was clearly not erroneous. And I'll move on to the second bullet point about US EPA delegation. US EPA delegates the authority to make these decisions and issue temporary authorizations on behalf of the federal government. US EPA delegates that authority to DTSC's permitting division, and we take it very seriously. We are responsible to the federal government and hold ourselves accountable with that delegation. States, such as California, are authorized to develop their own rules and regulations, but they can never be less stringent than the federal regulations. In California, we do have our own regulations, and they are different. One pertinent example is the appeals process for temporary authorizations. US EPA considered requiring an appeal period for these authorizations, but when they finalized their rules in 1988, this is what they wrote in the Federal Register. Agency-issued temporary authorizations are intended to allow facilities to respond rapidly to changing conditions and to enhance environmental protection at the site. Because swift action is essential for these authorizations, and since they will only allow operation for a maximum of 180 days, unless a permanent permit modification has also been requested, EPA believes that appeals procedures cannot be integrated into the temporary authorization process without undermining the fundamental purpose of such authorizations. This is important because we do have an appeals process in California, but the effect of our authorizations cannot be less stringent than the federal regulations require. Federal regulations are clear on the provision for temporary authorizations. They set clear boundaries. They require a fixed term of not more than 180 days. They don't refer to restrictions on the permittee. They instead place restrictions on the body issuing the authorization. They use the term director, which means the director of the delegated state agency or an authorized representative, which is permitting. This is what the federal regulations require. It says, upon request of the permittee, the director may, without prior public notice and comment, grant the permittee a temporary authorization in accordance with this subsection. Temporary authorizations must have a term of not more than 180 days. And EPA provides some context for the rationale in the Federal Register. They say, it is not appropriate for these decisions to be postponed for up to a year and a half. For these reasons, today's rule does not allow extension of a temporary authorization for a Class 2 activity except through the Class 2 procedures that are leading to an agency decision on the modification request. That is why our temporary authorization was fixed for a 180-day period. There is an urgency to address the batch house floor issues and the liquids in the waste piles you saw in the earlier slides. The path to provide further authorization for the equipment would be through a permit decision. either to process a permit modification for the current permit or issue a draft permit decision. That is why we are prioritizing a draft permit decision for Ecobat. The upcoming permit decision will address both of these issues, whether we deny the permit application or issue a draft permit for public comment. And based on the boundaries established for those authorizations, it would be unlikely for us to issue a new isolated authorization. We are focused on the permit decision. But we're not here today for a permit decision. We're here to provide you with considerations for your decision on the appeal about whether permitting's authorization was clearly erroneous. This is the text of the relevant part of the regulations for making a decision about the temporary authorization. I've added the check boxes that DTSC has to meet, and your staff brilliantly has already gone through this, so I'm going to cut to the chase to the third section in C5. There are 5 objectives listed there, but in C, yes, we found with certainty that the temporary authorization would be necessary to facilitate other changes to protect human health and the environment. Why? Because authorizing the compression auger and the centrifuge most certainly protect human health and the environment by removing the liquids from the shredded battery contents before they are even placed on the floor. And most certainly our authorization was in place before we could take any action on a permit modification or a permit decision at that time. This is the only piece of the criteria that is at issue today. In order for the appeal to be successful, you must find that DTSC made a mistake here. I submit to you today that no mistakes were made. This is a clear benefit that protects people, and we made this decision without error. The board should deny the petition for appeal. And now I'll turn it back to Leah for a quick 1-minute wrap-up.
So I want to touch base really quickly about the historical permit appeal compliance. When there was a permit appeals officer and the initial temporary authorization that they reviewed before the inception of the board. And I think it's just really important to be clear that DTSC did comply with that order in the issuance of the temporary authorization that we are discussing today. The permit appeal officer's decision solely focused on a procedural issue stating that there was the insufficient explanation as to why the temporary authorization was necessary, and DTSC remedied that issue. And in its July 2022 order, it summarized the order and explained the importance of the equipment and why the rapid response was needed.
Thank you, Leah. I think we're,
yeah.
I think we hit time.
But I understand.
We'll catch you on questions. Okay. Board members, any? We'll start down there. Georgette or Sushma? Okay.
Thank you, Leah. Thank you, Wayne. Leah, you started by talking about how deference is given to staff with expertise in interpreting how to apply the standard. Can you spend a minute or half a minute talking quickly about what is the expertise specifically?
Sure. So DTSC staff and DTSC permitting staff specifically are, scientists that have extensive background and training specific to hazardous waste and the management of hazardous waste in a variety of areas. There's engineers, there's geologists, there's all sorts of different branches of science of expertise. So when I was talking about deference, I was talking about the technical staff, but it's also just giving deference to the agency as a whole, recognizing that staff at DTSC or any other agency has that expertise that they are developed and they are hired to provide that service to the state of California and provide that opportunity for you as the board here or any other board to rely on.
So what I'm hearing you say is that DTSC has expertise in evaluating, say, alternatives and best available control technology, but they may not necessarily have the expertise in deciding whether or not community engagement may be helpful in driving or shaping the outcome.
Well, I would say that a temporary authorization, as was discussed before, there's a very different standard applied for public participation laid out in the regulations. And we as an agency are obligated to follow what's in the regs, which don't, besides a public notice, have a requirement for a temporary authorization. I'm not sure if that answered your question.
Thank you.
Liz, do you have anything? Georgette? Oh, you're not done? Okay. All right, you guys.
Okay, I have one more question. I think this might be for Wayne. Can you speak a little bit about when you would deny a temporary authorization?
Certainly. Yeah, when the criteria are not met, it would not be denied. Temporary authorizations are meant for clear. It's almost like a no-brainer, like, yes, we want to give you this authorization so that you can improve the management of hazardous waste at the facility. It's got to be a clear benefit to improving operations. Otherwise, it doesn't meet the criteria for the fifth element in there.
So
there
you
are
have
other, yeah, then we would deny. If it wasn't a clear benefit, then we would deny.
So you have denied temporary authorization requests in the past?
I didn't come prepared to. I don't have that history on me. We don't get a lot of temporary authorization requests. They're rare, but I don't have that knowledge in my head right now about our history.
Okay. Sorry, I have one more question. We've heard a lot about, I think from you, about the purpose of the temporary authorization mechanism and how it was created to enable rapid response to changing conditions. Can you help us understand what was the need, what created the need to act now, given that the situation was in place since 2001?
I mean, well, our enforcement team went in and found violations in that building. The batch house floor is something that's still an issue today. It needs to be remedied. And that's why we're focusing on the permit decision. Both they're kind of coupled together. The temporary authorization gave a way to quickly allow the facility to remove those liquids from the piles before they were even placed on the floor in that batch house.
Okay, so the aqua standing liquids were on the floor since maybe 2001. 2016 was when you did the enforcement activity, but the temporary authorization request came in 2021 first and then 22. What happened in 22 that created this need for a rapid response?
Well, I mean, the need to get the liquids off of the floor. There are the enforcement and the settlement agreement stuff that's not a part of this appeal hearing, but there were a lot of elements during that time that we've had a lot of public meetings and public input on. We've been engaging with the public on providing information about what we were doing during those periods of times and what we found. And so I would say that the sense of urgency in 2022 was to get those liquids off of the floor in a quick way. I mean, that's the whole purpose of a temporary authorization. We recognize that a permit modification is necessary for a permanent change to an existing permit, but that takes time to go through. And that's the beauty about the temporary authorization. It allows a quick solution while you're figuring out the other permit modification request.
So what I'm hearing you say is, since the enforcement activity visit in 2016, there's been a sense of urgency, ongoing urgency. But in 2021 or 22, a solution became available? Like, what happened? Or the permit holder came with a request and you were like, yes,
well, yeah.
Want to act now?
I mean, there was a lot of enforcement activities taking place during those times. So for permitting, the opportunity that came up for this problem was that Ecobat submitted a request to include authorization for equipment that would address the violations that were ongoing at that time. I hope that's responsive.
Georgette?
Sorry, this thing is really heavy to move. I'm gonna follow on the questions because I'm not clear. 2016, there's a violation. There's public comment that there's community engagement from 2016 to 2022 that created this emergency. That's 6 years that
So
you all
I mean,
took
just to be clear, DTSC didn't initiate the temporary authorization. Ecobat requested the temporary authorization from DTSC as a way to resolve violations associated with the batch house floor.
Understood, but you granted that process as a temporary process. I'm still trying to understand that. And that's one of the reasons that it's being challenged, the temporary aspect of this whole situation versus the regular path. So I'm just trying to understand that, and I'm not hearing anything that.
So the regular path would have been, and would need to be now, a request for a permit modification or a decision on the permit renewal application. Both of those things address both issues, the batch house floor and the liquids on the batch house floor. At that time, in July of 2022, we were not prepared to issue a draft permit renewal decision. And so a temporary authorization was appropriate at that time.
Because you were not prepared to do it?
Well, I mean, it gave us the
rationale?
opportunity to allow them to operate the equipment and get the hazardous liquids off of the floor to protect the community and the environment. That was the purpose of this. But now we're prepared to make a permit decision. And so it is not appropriate, it wouldn't be appropriate now for a temporary authorization because we're ready to go out with a permit decision that addresses those issues. I hope that makes sense.
It doesn't. I'm sorry. So why not 2022 create that process as a regular? I'm not understanding. Is it because you weren't prepared staff-wise?
I think part of it, Wayne, feel free to jump back in, is the permit renewal process there's a lot of technical detail and it takes quite a long time internally on DTSC side and all of that. So I think what
does that mean? It takes time. Time is time, but what does that mean? It takes a year, 2 years, because it took 4 years to conclude there's an emergency and we should take this temporary process.
Yeah, I mean,
So is it more than 4 years?
It didn't take us 4 years to conclude that because there were ongoing enforcement violations, right? I mean, it was ongoing enforcement activities. The point of the regular process taking a long time is that we follow rules associated with reviewing permit modifications. We don't just get to make up the rules. There are procedures in place, there are practices, there are certain elements that we need submittals for permit modifications from. All of that material takes a long time to process. Class 2 mods usually take around 6 months, at least 6 months to process. Class 3 mods can take many years.
Okay. And then I'm just trying to understand. So the DTSC's appeals officer that concluded this, right? And one of the on one of the reasons was, and I'm going to read it again. I think Angela read it earlier, but considering that the facility has been placing hazardous waste containing free liquids on the floor of the containment building since at least 2001, Quemetco has not explained why the temporary authorization is necessary for the addition of the 2 new miscellaneous units. Therefore, a temporary authorization should not replace a timely permitting modification request.
So
I'm still not moving beyond that. What's different?
Maybe I can explain one thing and then I'll give it to Leah to explain the appeals officer piece. But A containment building is designed for businesses to do this, to take piles of with liquids in it and place it on the floor. That's what a containment building is. There are clear standards for containment buildings that Ecobat has problems with. That's why there are problems with their batch house floor. But a containment building allows businesses to place piles of waste, hazardous waste with liquids in it. That's what they're designed for. So I mean, I hope we're not creating the impression that that is not an allowed procedure. It is not allowed for Ecobat because they have violations for their batch house floor. That's why it's inappropriate. And then for the appeals officer.
Following your question, Georgette, and referring to where Angela had pointed to in the order. So that's in the discussion where the permanent appeals officer is talking about it. On the next page, on page 9, there's conclusion for appeal comment 1. And in that spot is really where the ultimate conclusion is reached by the permanent appeals officer, which was what I very quickly touched on in my slide of saying that the denial and the reason that the permanent appeals officer invalidated that temporary authorization was because they said there was an insufficient explanation provided as to, you know, the nature and why there was an urgency. And so in the temporary authorization that we're talking about now, the new one, that was addressed in DTSC's decision. And as part of that, we really tried to summarize this order and that it did comply. And we specifically called out providing that explanation to help try to make it clear for, you know, everyone involved, the facility and the public. Does that help? Okay.
Yeah. Thank you.
Yeah.
Yeah, I have a couple of questions myself. Just going back on the urgency of getting these liquids off of the batch house floor. This is due to, you know, the various notices of violation. Is installing this equipment the best way to do that? In your opinion, is this why you guys approved this temporary authorization? Did you guys deem, or was there discussion about any other way to meet that that goal?
I mean, so there are probably a number of different ways that you can address removing liquids from those piles, right? There's other pieces of equipment that you could use. There's other technologies. But what was submitted to us as a request from Ecobat was a request to allow them to operate that equipment. We can't tell Ecobat, you need to give us an application to do this, to install this piece of equipment. That's not how requests for authorization work. They come to us and they ask us if they can operate certain pieces of equipment, and then we make a decision about whether yes or no, it meets all the standards in Chapter 14, it's appropriate, it protects human health and the environment, and then we make a decision about whether to approve it or deny it.
So there, in theory, there could be different ways to do this.
Absolutely.
And what I'm having a difficult time understanding is why then just take the first idea that comes to mind. Why circumvent the public review process when there can be that discussion about whether or not this is the best approach?
Because for us, this was it was clearly a benefit. This was a clear improvement of managing the waste at the facility. To get the idea of, you know, the liquids in the piles is the problem, because the liquids eventually seep out of the piles. If you have a pile of wet clothes, you're going to get liquids all over the place, right?
And so I have a lot of questions even about that, about this equipment, the validity of the equipment. Why was the equipment already installed? Is it common practice for that to already be done without going through this process?
The equipment was installed after we issued a temporary authorization. There was a period of time where the authorization was in effect until an appeal was filed and it was stayed. So they had authorization to install and operate that equipment for a short period of time.
And so considering that the equipment's already installed, and I know we're not talking about the settlement agreement, but why wasn't the equipment included in the settlement agreement? If because to me, you know, there's an understanding that there's already some sort of release or possible release beneath the batch house. I don't understand how that release will be remediated with equipment already set there.
Okay, yeah. So the batch house floor, that's a bigger problem. The batch house floor, this doesn't resolve that problem. This just gets the liquids off of the floor. So in the enforcement activities, the violations that were cited, enforcement told them to fix the batch house floor and provided a pathway to do that. And then the second thing they did was to tell them to resolve the free liquids, manage the free liquids in the containment building. So there are two different issues. The two pieces of equipment here did not resolve the batch house floor issue. That's a much bigger issue, and that's why we're prioritizing the permit decision.
And so, and I guess that's a question that I'll have for Ecobat in the future, but was there a concern brought up of, you know, equipment failure? Like what if, you know, is there a plan B for this equipment to not work and for the continuation of, you know, possibly having more liquid accumulate?
Yeah, good question. I mean, if they're operating the equipment, they have the authorization to run the material through it. But if quite honestly, if the machines were not operating, that's where we're at today. Those liquids are being piled up on the floor in that containment building. And that's why those pieces of equipment resolve the issue. Are they, I don't fully understand the question about if they break. I'm trying to think through that. Can you elaborate on the question a little bit more?
I'm just having a hard time figuring out what the secondary containment would be for these pieces of equipment. I understand that through the settlement, there is a mandate through court to provide secondary containment in that floor.
Okay. Yeah.
And so I'm having a hard time understanding how this equipment will change any design for that secondary containment.
It doesn't. This equipment is outside of the batch house floor. So it takes material from a process before it goes onto the batch house floor and removes the liquids in a different area.
If that equipment fails to work, what's to keep them from piling up
So that area also requires secondary containment, which is different from the batch house floor containment. The two pieces of equipment are not associated with resolution of the batch house floor in any way. The batch house floor needs to be fixed, and that's why we prioritize the permit decision.
Do you want to have a quick question?
Could we turn to an item in the administrative record, the DTSC issued letter of July 22nd to Mr. Raycroft, signed by the hazardous substance engineer, Clarissa Kozraviani? Okay. Let me know when it's timely.
We have it.
As we've become more familiar with the process for temporary authorizations, I was going to ask, if you look at the last paragraph on page 2 to address this specific issue and the way it continues on to page 3, this appears to be where DTSC strives, and I'm not trying to put words in your mouth, but is this where DTSC strives to address the shortcomings pointed out in Carl's earlier letter, where this is where the strength of the rationale is to be found?
Yes, including the paragraph above the one you cited, because it discusses
So
the
for
permit.
those who don't know what we're talking about, Alexis, can you just for the rest of the public?
We can put up a slide if you give us a moment. I'll pose my question while we do our audiovisual magic here. I was learning as we became more familiar with this process that really there's sort of a two-part test in deciding to grant a temporary authorization. And I was looking to this letter to be sort of the strength of that argument. And I was wondering if it was specific enough to meet that criterion number 5, for instance. You know, tell me what you think. And if those in the audience would bear with us a moment, we'll get that up.
Gabriella, could you please show slide number 5?
So, I mean, just while that's coming up, I think I would say that the language in this letter goes to the findings from DTSC's permit appeals officer in a way to try to resolve that finding that they made at the time that we didn't include a justification in our notification about why it was necessary. And so this specifically may not include all of the rationale required for section 5 in that piece, but it goes to the notification principle. So the officer found that we didn't provide adequate justification in communicating that. So I think there's a distinction about what we found to meet 5, C5, and what we communicate. This goes to what we communicate.
Yeah. Do you want to ask a question?
No, I'm going to hold for the second session.
Okay.
Because we're over time. But
okay.
You want to follow on?
Wayne, earlier in your presentation, you had inferred that given the department's emphasis on coming to a final permit decision for the facility to replace the 2005 permit or deny, that you felt that a temporary authorization was almost, and I'm not making up the word, but it's all but irrelevant. Mm-hmm. And so if the board were to act and to say there is not a temporary authorization in place to approve the appeal, it would be rather consistent with what the advocates for the Clean Air Coalition are saying, which is to not have the temporary authorization, albeit for different reasons. So is there less distance between these two parties that neither of you thinks that at this point in time, a temporary authorization is the right vehicle going forward?
Yeah, I mean, I think we would ask that you consider not the consequence of the action, but the finding about whether our action was appropriate at the time. I don't think we believe that you need necessarily uphold the consequence that a temporary authorization goes into effect, because our authorization had an expiration date in it that we have to take the position that it's a fixed term. As I went through, the federal regulations require a fixed term, and that's what our position is. So I would just ask that you look at not at the consequence of the action, but whether we made a mistake or not. I think that's the fundamental question.
I understand the legal standard here. I just felt that there was a point in time. I'm not sure if you are still on track for that important permit decision next month. But given how much time has elapsed, it occurred to me that there wasn't that much distance between what two of the parties were saying. That's it for now.
Okay, thank you both so much, and thank you all for indulging a little bit of extra time that we'll make it up. I'm sure we will. Okay, so now we are going to hear from the representatives of Ecobat, Matthew Williamson from Minot, Phelps, and Phillips. Welcome, Matt.
Thank you, Chair Rizzo. I think it's close enough. And members of the board, I have the pleasure of going third. And so I have a lot of this material has been covered a little bit differently than what I had put together in my presentation. So I will try to scooch through slides that have already been covered, keep this within the 20 minutes. I wanted to, before we started, because it was just being discussed, make just abundantly clear to the board and to avoid any confusion on this topic. Ecobat does not intend to change its commitment to replace the entire batch house floor with a new floor system and leak detection system, regardless of what happens with the dewatering system, whether it is approved. We have made the commitment to DTSC permitting. We have had discussions about it. We have even proposed amending our settlement to put that commitment into the settlement. So I want to take that issue and hopefully take it off the table. This is not something that we are trying to do through the dewatering project, is minimize our commitment to completely replace the floor system in the containment building. So I want to start quickly because we kind of jumped right into the dewatering appeal process. Take a step back and talk a little bit about Ecobat as a company. I don't know that anybody has actually said what Ecobat does. I think most of the board members know, but Ecobat is the sole lead acid battery recycler west of the Rocky Mountains. The vast majority of what we recycle are used car batteries. So when you drive your car and your battery goes dead, in California, it almost certainly is going to end up at Ecobat. Ecobat it's a critical role that Ecobat plays in California. We have millions of spent lead acid batteries that are generated in the state every single year. And if Ecobat isn't here to responsibly recycle those batteries, they end up almost certainly being exported out of the United States to countries that have little to no environmental standards that regulate their recycling of lead acid batteries, with a pretty bad history of impacts to communities in those at those locations. And the other thing we've seen in where there isn't a supply to meet the demand for recycling of these batteries is they end up getting illegally disposed of in landfills or just dumped on the street. This is something that we've seen the legislature take an interest in the last decade or so. It certainly is not, everybody doesn't agree on the solution, but there is a consensus that is building on the importance of California to be able to manage California's hazardous waste. And so I've included a recent quote from State Senator Ben Allen, who's very involved in, toxics and hazardous waste management, in an article that he provided a quote for earlier this year. And the dewatering project, as we heard from DTSC, and as they concluded in this temporary authorization approval, it provides a clear environmental benefit. It is really indicative of Ecobat's commitment to ensuring that its operations not only meet but exceed its environmental regulatory requirements. Since 2008, Ecobat has invested well over $50 million at its City of Industry facility to improve its emissions control. This is just one example of this type of commitment from Ecobat. The benefits of these investments are significant. So on an annual basis, Ecobat recycles well over 10 million car batteries. It ends up producing over 240 million pounds of recycled lead every year. And of that 240 million pounds of lead, there's typically around 5 pounds of lead emissions from its facility. So that is an absolutely tiny fraction of the total lead it's recycling that is being emitted. And that is a tribute to its huge investment in air emissions control. And it's way below the strict limits that the South Coast Air Quality Management District has created for lead acid battery recyclers. It's actually about 80% below. And I also wanted to acknowledge how important these type of environmental improvement projects are in dewatering. We have folks from management all over the country that have come in to support Ecobat's dewatering project. We have a number of employees that have come out today to support Ecobat. We also have Teamsters who represent the 250 employees at Ecobat who've come out today to support this program. This is not something that just is, the environmental lawyer and the EHS guy at Ecobat get together and try to come up with things that we can do. This really is a company commitment to a culture to ensure that we are operating in an environmentally responsible manner. So I think it was Wayne started walking through a little bit of the process by which the dewatering equipment is going to work. And I wanted to kind of step back a bit because to provide some additional details that Wayne left out of his discussion. The way that these batteries get recycled is they first go into what is called the battery wrecker. It is a giant crusher that crushes the battery materials. All of the outputs from that battery crusher go into what is called a sink float tank. The plastics float to the top of that tank. The lead bearing material sinks to the bottom of that tank, and the acid from the battery mixes in with the liquids. That lead bearing material that sinks to the bottom of the float tank currently is transferred directly to the containment building, where it is piled up, and so that the liquids can gravity drain out of that material, and the floor is then sloped to a sump where that liquid is then transferred to a water treatment system at the facility. And I have a picture here, again, similar to what DTSC provided, showing the way that the liquids flow across the floor in the containment building. Now, as Wayne alluded to, this building has been subject to enforcement, and we have reached agreement with DTSC where we have agreed to entirely replace the entire floor with an entirely new leak detection system and an entirely new secondary containment system. And that's going to be done as part of our permit renewal. And so going back to this process flow diagram and talking about what the dewatering equipment does, is it comes in between the sink float tank and the containment building. And so rather than taking this lead bearing material that has a pretty significant liquid volume and placing it into the containment building for that liquid to then drain across the floor, this lead bearing material, we call it wrecker material, is put through the dewatering equipment, the compression auger and the centrifuge, where that mechanically removes the liquids from the wrecker material prior to going into the containment building. So you do not have liquid draining out of these piles onto the floor of the containment building. Again, going back to our picture at the previous, you'd have the same piles, but you would have dry concrete that would be in this picture. And so as DTSC had discussed, there are clear environmental benefits to removing this liquid. First, this containment system under the floor is, while we think it's compliant, we obviously have disagreements with DTSC on specifically the leak detection system. Removing the liquids essentially eliminates any risk of liquid leaking out of the building into the ground, impacting soil beneath the containment building and potentially impacting groundwater. That was part of DTSC's finding in their temporary authorization and support for their decision. Other benefits to this equipment, because we're removing more liquid from the wrecker material, we're reducing the amount of sulfuric acid that ends up getting fed into our furnaces. So we see a fairly significant reduction in SO2 emissions from those same furnaces, another clear environmental benefit. And then the third one, and related to the reduction of liquid content in the wrecker material, is the fact that we can then turn down the temperature of the furnaces as we're beginning the process of refining the lead. And turning down the temperature in the furnaces is going to lead to less gas need and less greenhouse gas emissions from the facility. Again, in their appeal, the Clean Air Coalition does not dispute these benefits. So given the fact that we have a clear example of an environmental benefit project, what are we here for? The issue here is really quite narrow. And I am totally happy to answer any questions you have at the end. We'll cover any topic, but I think it is really important that we remember that this is a very narrow issue that is being raised on appeal here by CAC. And the question is, was it clearly erroneous for DTSC conclude that the dewatering project is necessary to facilitate the protection of human health and the environment before action is likely to be taken on a permit modification request when DTSC approved Ecobat's temporary authorization request on July 22nd, 2022? We have talked about the standard of review. I'm going to go through this super quickly, but again, we have to remember that we're talking about a clearly erroneous standard of review here. Leah talked about the rulemaking packet that the board provided that talked about deference and the reason we give deference to DTSC to interpret the rules and the technical aspects of this. One of the things I heard from CAC in their presentation was a discussion about legal interpretation of what necessity meant and a disagreement on the way that that DTSC had interpreted the regs and a discussion of some federal rulemaking and an invitation to the board to make their own interpretation of the regs. That's not the question that we're being asked here today. And the standard of review here requires you not to come up with your own interpretation of the regs, but to ask yourself, was DTSC's interpretation of the regs clearly erroneous? And I think the answer here is a very clearly no. And again, as DTSC has already talked about, and I will certainly go over, their conclusion was not clearly erroneous. When they, in their July 22nd approval of this temporary authorization, they identified, excuse me, they identified the method in which the dewatering project protects human health and the environment. As Wayne said, and as the approval makes clear, this is not a close call. It is a very clear environmental benefit. Again, we're removing all of the liquid off of the floor in the containment building. That is a significant improvement to our management of waste in that building. And then DTSC also provided the explanation of why that change was necessary. And I really want to get into some of the questions that you guys were asking. And I think there's some very good answers around why that necessity arose in the 2021-22 timeframe. The 2016 enforcement that began on the containment building floor led to a long series of discussions with DTSC enforcement and permitting about what Ecobat was going to do to resolve DTSC's position on the batch house floor. This is a complex system. It was not a, aha, here's our answer. It took many years and many rounds of discussions and many submittals on the part of Ecobat that I was involved with. I think we had at least 4 or 5 different proposals for how we were going to modify this floor. That took a very long time and the involvement of a lot of engineers and technical folks, reviewing, commenting, coming up with design plans. And so that process all took a very long time. And it wasn't until 2019 and 2020 till we even had an understanding of what the redesign of the floor was going to look like. And at that point, we understood this was going to take a long time to permit. It is a very complex permit, as Wayne was talking about. A class 2 or class 3 permit can take well over a year to get done. And in fact, this is going to take even longer because it's being done as part of the full permit renewal. And so because that was taking so long, we started to look at other ways that we could start to address the liquids on the floor in the containment building. And one of those ways was, you know what, we can do something in the interim, which is remove the liquids from the floor in the containment building, eliminate the risk that there's a release from the building down into the soil. And that was the dewatering equipment. And so that's where that necessity came. It was, aha, we've got a fix. Let's move quickly on this. Let's get the liquid off the floor as quickly as we can. And let's do that through a temporary authorization. I mean, as the timeline showed, we did a temporary authorization and then we submitted the full permit, class 2 permit request, right? And it's hard for me, and we'll get into it a little bit further, assuming I have time, to sit and listen to CAC argue that, well, you got a class 2 permit mod. That was approved. And it's like, well, I would have loved to have operated under the class 2 permit mod, but CAC appealed that approval and knew that the board was in the middle of making rules that was going to be at least a year-long process, and that approval was going to be stayed for at least 12 or 14 months. So we were sitting there looking at this saying, we can't operate we're not gonna be able to operate the dewatering equipment. Liquid is still going to be flowing across the floor of the containment building. So our solution to that was, let's just draw down the approval that's not going anywhere anyway. It's been stayed by the board. We'll address CAC's issues that they raised on appeal, and then we'll resubmit this all in order to keep this process moving along. I also wanted to address one other point. We have talked about what the standard is for approval of a temporary authorization. Again, it's the finding that there's necessity to realize the benefits of an improvement that will change to protect human health and the environment. So two findings, I'll put in the necessity and that action is going to benefit human health and the environment. I did want to address the concern that CAC raised that this swallows the rule and will take over all permit modifications. That it just simply is not true that all permit modifications involve an improvement to the way environmental health or human health of the environment. For example, adding a new treatment unit at a facility, increasing the capacity of a facility, changing the way waste is managed, allowing a facility to store or treat new waste streams. There are tons and tons and tons of things that a facility does through modifications that would not be subject to temporary authorization. So I wanted to address that quickly in my comments as well. So I'll go through this quickly because member Strauss-Hacker was talking through the July 22nd letter. But the first thing that DTSC found and needed to find in order to approve the temporary authorization was that they explained how the dewatering project was going to be a change that protected human health and the environment. I'll read it. The purpose of the miscellaneous unit is to eliminate free liquids from the hazardous waste that is stored on the floor of the containment building. The presence of free liquids requires the containment building to operate with containment and leak detection system that, if failed, could potentially result in hazardous liquids coming into contact with groundwater beneath the facility. And skipping down, the removal of free liquids from the containment building results in a significant environmental improvement to the storage and treatment of the record material, minimizing the risk of release from the containment building and resulting in a clear benefit to human health and the environment. So DTSC addressed the first prong of its finding needed to grant the temporary authorization. I will then turn to the necessity prong. And we've already talked about the language that DTSC included, showing that this change was necessary before action was likely to be taken on a full permit mod request. And again, DTSC concludes that approving Quemetco's temporary authorization request is necessary before action is likely to be taken on a modification request, because the environment improvement to be authorized allows DTSC to continue its mission of protecting California's people, communities, and environment from toxic substances, et cetera. The addition of the miscellaneous units above will allow Quemetco to better and more safely manage its waste without the delay associated with a permit modification request, public comment period, and final decision, which could be between 6 months and a year from start to finish. And I think that is also really important reasoning to understand, and we've had some discussion about this permit renewal and how that interplays with the temporary authorization. Is what we're talking about happening at the end of this year, although it's likely to get pushed at a minimum into next month, is a draft permit decision. That is not a final permit decision. There is then going to be a lengthy public comment period, a response to those comments. And so we're talking about a very long time, certainly another 6 months until we get a final permit decision. So the exact same justification that DTSC provided here for providing a temporary authorization previously is 6 months and at least until a final permit decision still applies today when we're talking about the full permit renewal. So really quickly, because I know I'm running out of time. There were 3 kind of specific arguments that CAC made in its briefing. And the first argument, which we've touched on briefly, is essentially that the appeal officer previously said that in no circumstances is dewatering appropriate for a temporary authorization. And that's just a mischaracterization of the appeal order. Leah already read that out to us, and so I'll skip that part. But what the appeals officer said is you completely skipped that part of your reasoning when you supported the temporary authorization, and you needed to provide something. DTSC has now provided that something. I also want to touch briefly on the Class 2 argument, this previous Class 2. I find it hard to sit and listen to the argument that CAC raises on that front, given that Ecobat voluntarily withdrew its previous Class 2 approval in order to proactively address CAC's arguments, and they're now arguing that that should be held against us. I think that's conduct that should be encouraged and not used to punish folks. And I'll finally say on that front is in partially granting, but mainly denying CAC's motion to augment the appeal record, the board, in fact, ruled that the previous Class 2 was completely irrelevant to this entire temporary authorization, essentially for those same reasons, is that it was withdrawn, it never became effective, so it's just not relevant to the temporary authorization. And I will pause for comments because I now am quite over time.
Thank you. Board member question.
I think we're close to wrapping that for you.
If I could cover one more topic,
one more topic quickly. We're out of town. Okay, we're over. Okay.
I'll make it in my response.
I know it will. Right, exactly. So my question goes to you withdrew the mod 2, decided not to do a mod 3, which was the argument that was made, right? Instead, you're working on the core permit.
That's not correct. So this is another interesting one, is we had submitted a Class 2. Once the board, we knew the board was back to, we have rules, we had a timeline, we all remember the meetings that we had. We submitted that Class 2 saying, we can do this now again. We'll get an approval. If it's an appeal, we'll know there's an appeal process to follow. So we got that Class 2. We were close to an approval, and then CAC came in and argued, no, that Class 2 needs to be treated as a Class 3. And so that has now been pushed out. That timeline is maybe indefinite, but that's pending. We have a Class 2, now Class 3 permit mod request sitting with DTSC that they're not acting on.
Okay, because the main permit is being acted.
Exactly.
Okay, so essentially, that's on hold. And now we're looking at the main permit, and we're talking about 180 days for a temporary authorization, and the likelihood that the draft permit, public comment, all of that, you're going to hit the 180 days probably before that happens. So
yes.
Okay. And so then what happens then? Do you ask for another temporary authorization?
So the regulations, the regulations allow, and part of our Class 2 pending Class 2 request is an extension for an additional 180 days. And that is what is allowed under the regs, is if you have a Class 2, or in this case, it's going to be a Class 3 that is pending and hasn't been acted on, then DTSC can issue an extension for an additional 180 days.
And if the Class 3 mod then goes into effect, because the regular permit isn't, so you've got a Class 3 sitting in the bank, right? Yes. In case the permit doesn't get approved in the 180 days. I'm just asking.
Yes.
Then you're going to rely on the Class 3 as a reason to get an extension on the temporary authorization, correct?
Well, I think that now that it is a Class 3 provides an additional justification for extending. Yeah, but it's not our decision. It's
no, I'm just trying to understand the possibilities. Yeah. Class 3 does require more public engagement.
Yes.
As does a general permit.
Yes.
So both of those have a different scenario that we would all be dealing with and yes, or maybe not an appeal. Well, I mean,
yeah. I mean, the public engagement question is a good one. And here I go weaving this in. With the pending class 2 request, we already had a public comment period. There have been questions submitted. DTSC is preparing response to those. We will then have another public comment period with the class 3. So there is right now ongoing public engagement on this project.
Well, public comment and public engagement, some of us would say there's a little bit of a difference in that. You know, public engagement is a little more of this than public comment in writing. So,
yeah.
So I'm just trying to get clarity so I understand, because the questions have come up for us about, is that 3 still live? Is it not live? So you answer
to be clear, on a number of occasions, and I have personally invited public engagement with CAC and others on this project, and there has been no response to those invitations.
Well, and we're really happy to help with that.
Okay, I would love your help.
Okay, I'm going to turn to other board members. Okay, go ahead.
Thank you. In the administrative record, I saw a reference to a sister facility outside of California.
Yes.
Where the same or similar unit dewatering system has been installed. Can you tell us when that unit was installed?
I do not know off the top of my head.
Or can you tell us more about when the solution of the dewatering unit became available?
It was all very quick in sequence. The reality is that in our other states that we operate in, Indiana and New York, this is not treatment. So we do not need to go through a permitting process. We can just install the equipment and it starts operating. In California, we have to go through the permitting process. So it was within a very short window of, hey, this dewatering equipment works well. But in California, we have been stuck in this permitting limbo for now 3 years. So we don't have it operating. But it wasn't like 2016, we installed the equipment in Indiana, and then 5 years later, it was California. It was very boom, boom, boom.
Okay. So So is it accurate to say that within the year when the solution became available, you installed it outside of California and were looking to seek or temporary authorization to install it in California?
I think that's correct, yes.
Okay. My second question, we talked a lot about the unit itself, but we're not actually debating the merits of the unit. I think we're actually debating the process.
Yeah.
And if we say that rapid response is required, then we're also effectively saying that community engagement can be impacted because this calls for a rapid response. So given that you've applied both for temporary authorization and permit modification, you've already used the permit modification mechanism and it's the course of its time. Do you have anything further to add in terms of why the temporary authorization still is the right mechanism for this dewatering unit?
Without temporary authorization, the earliest that we will be operating this equipment is probably late 2024 into 2025. So if this appeal is upheld today, liquid is going to continue to be stored on Ecobat's floor in their containment building, and we do not have a permitting path forward that will get us an ability to operate this equipment until at least a year from now. And that is just a result that I find to be just difficult to swallow, because again, this is such a clear environmental benefit. And we welcome, and part of what I would ask the board, and I didn't get to in my presentation, is if there is a need for further public engagement and further refinement to these approvals, let's do that. The board rules allow for the board to keep jurisdiction of this issue and to fix any deficiencies that they found so that we can get this equipment operating. And as you heard permitting say from DTSC, if we walk out of here today and there's a denial and I submit another request for something, they're not going to act on it. And so we just don't have any way to get this equipment operating. And I know I sound like a broken record. I've said this to you guys a number of times, but one of the reasons we were so excited about the board and we were drafting SB 158, we were excited about the board, is having some help with making permitting more efficient. And this is just, it has become so inefficient. And it's been so many years for an environmental improvement project. I think I feel strongly that this appeal is meritless and should be denied. But if that isn't the outcome today, we need help keeping this process moving forward so that we can operate this equipment, which really does benefit, the community, the environment, and we need to get everybody there.
I understand.
I have one clarifying
Yes.
question. So I just heard you say that if this appeal is denied, then or granted, then earliest you can operate this unit is late 2024-25. But that is because you previously submitted a permit modification request that you then withdrew. Is that correct?
Well, I mean, that request would not be, even if we hadn't withdrawn it, it would still be in appeal today, right? That appeal would have been part of this same timeline because it would have been dismissed and then refiled when the new rules, and we would be on this parallel track. Looking back, I wish that my advice to my client hadn't have been to dismiss it. But I think that we were acting in good faith and said, we'll proactively address CAC's arguments in order to keep this process moving forward and hopefully avoid the need for further disputes like this.
Sorry,
Georgette.
That's okay.
Just one question in this line. So I can't remember the date. I don't know if it's June or July 2022. When,
is that the approval? Yeah, July.
When the request for the temporary.
Request was June, approval was July.
June. If you would have submitted a regular process, June, not requested temporary, where would we be now?
The same place.
It was your decision to have it be a temporary process.
Yes.
Versus a regular process.
Yes.
Where would we? I mean, if we would have gone the regular route,
we would be in the same position, right? Because there was no path forward for challenge permit actions while the board was creating rules, right? Challenge permit decisions were being stayed indefinitely until the rules were being finalized. So we were in a very unique and very challenging situation where we said we could have submitted a class 2 back in June. That would have been approved, and then that would have been appealed, and then a stay would have been entered until May, or it would still be going today because that appeal wouldn't have been completed yet, right? The class 2 permit mod appeal process is going to be about 9-10 months from start to finish.
The appeal process is based on the fact that it was done through a temporary.
No, our class 2 was appealed. Our previous class 2 was appealed.
Okay. Thank you.
Yeah.
So I just want to clarify, the class 2 was appealed in part saying it should have been a class 3.
That was part of their argument.
So, and there's a class 3 sitting in limbo somewhere.
Yes.
Right?
Yes.
So had it been a class 3 and the process would have moved, I don't know if it would have been appealed.
But that was only one of the arguments. The other argument was that we're trying to eliminate our need to replace the containment building floor, that there wasn't secondary containment within the battery record where these units are. There were 10 arguments in the appeal.
Which could have been addressed, right? Could have been addressed.
Well, we attempted to address the previous arguments, and every time, I hate to use this analogy, but it is starting to feel like a game of whack-a-mole where each round we try to address the arguments, and every new round, new arguments come up. And
Okay. Last board questions, Liz?
Can you elaborate when you talk about your good faith in withdrawing? What do you mean by that?
When we resubmitted our request, we included attachment 6 in the request, a chart that summarizes, hey, here I don't know if it's 5 or 7 arguments that were raised in the appeal, and here's how we have addressed each of those with citation to where in the record. So we attempted to proactively address each of CAC's arguments. Rather than fight, we just said, fine, we don't need to disagree about this, we'll just address it. We think it's something that's easy to address. or it was based on a misunderstanding to begin with. So I think that's good faith. I don't know if you disagree, but
I'm just having trouble kind of not mirroring that to this temporary authorization. And how a lot of those wouldn't be applicable to this situation.
Sorry, I don't understand that question.
How do those concerns not apply now?
We also addressed all of those concerns in our temporary authorization. We're going to address all these 6 concerns from the CAC appeal, all went into the temporary authorization request as well. Mm-hmm. So we're not trying to like sweep things under the rug. All we're recognizing is the class 2 and now class 3 process takes a really long time. And this is a really good, clear environmental benefit. So a temporary authorization will allow us to operate this equipment on a shorter time frame. Again, it's 180 days. That is the trade-off. They're not going to give us permanent authority to do this. The trade-off is that you then don't have to go through that full public participation. But again, I want to put that into the context. We have had 2, going to be 3 public comment periods or public meetings and public comment periods on this. We have had a ton of engagement. There has been a lot of discussion. This is the 3rd appeal of the issue. We've tried to address all of the arguments raised on appeal. So, and CAC acknowledged in their comments that has impacted, and we have actually addressed, and it has impacted the way that this permitting process is going forward. So there has been engagement. There's been a lot of engagement.
So that's
and that has improved. Yeah.
Why wasn't that important when this temporary authorization was first initiated?
It is important, and it continues to be important. I don't want to give any impression that the temporary authorization process is something that makes public engagement any less important. That's why, as a part of the process, you have to then submit a full permit mod request, and you do the public engagement as part of that full permit mod request. This is just allowing you to operate that equipment in that initial phase where the full permit mod request is still being processed.
But it's after the fact that the public engagement is.
Okay. Well, no, you go. Actually, I don't have a question for that. I think I've already asked mine.
Mr. Williams, I was trying to track it's not in the purview today for us to decide this issue, but it's hard to understand what are the next actions over the coming year that will happen as a result of the settlement agreement, and then what will happen with the permitting decision to follow. I'm assuming that it's the main permitting decision and not a class 2 or class 3 decision. And I don't know how the decision before us tonight nests within the larger context of the settlement agreement and the actions that will be covered under DTSC's proposed permitting decision.
Now, Member Strauss-Hacker, are you focused on dewatering specifically or in the grander scheme? So let me take a shot. I'll take a shot at this, and I will concede that other than the section of the settlement agreement related to the containment building floor that I had modified, as I discussed, to make a commitment that was clear that we were going to replace the entire floor, I haven't looked at the entire settlement agreement in quite a while. But my recollection is that the settlement agreement includes a commitment from Ecobat to make permitting submittals in order to get approval to operate the dewatering equipment. And Wayne talked about that. And then the second half of that in a belt and suspenders approach, and this is both in response to DTSC's enforcement on the containment building leak detection system. The second half of that is also a commitment from Ecobat to replace its entire floor system, and that is being done as part of the permit renewal process. Does that answer the question? I'm not sure if it did, but
I won't take time now. I was just trying to understand what is happening in the larger picture with these other 2 main mechanisms while we deal with the minutia of the temporary authorization.
Well, like what is the status of the permits?
What really happens next? But I'd like to just withdraw that because we have time that we have. You can come back and ask a question. Right?
Thank you, Matt.
Thank
you. I
you.
appreciate your time, and we are obviously running over. We were going to have public comment now, but no, we're not having public comment now. We're having a lunch break.
Yes.
Okay.
Madam Chair, it is now 4:05. Would you like to call for a 35-minute break?
Sure. Promptly back here in our seats, ready to go in 30 minutes. 30, let's go 30.
Okay, the board will now be taking a short 30-minute break. When we return, we will hear public comment. But before, before we leave the room, if I can take a quick poll of those on Zoom and in person, show of hands of anyone that wants to take a public comment so we know how much time to allot. Okay, and as a reminder, for those in person, I have some green comment cards here on my table and at the registration table outside. For those in person, please raise your hand so that my colleague Sheena can take a poll, and you can submit your questions via Q&A, and we will take them up then. Okay, welcome back, everyone. It is now 4:41. We will be, I think we have all of the board members back. So all board members are present. We have a quorum. And I would like to take this time to remind everyone that this meeting is being recorded, and by your continued participation is acknowledgement that you are being recorded. Madam Chair? We're moving on to item number 7.
Yes, and I want to make note for everyone, we're going to hear public comments. We're taking notes on public comments. We won't be engaging or responding back about them. So just want you to know that. It's not that we don't care and we don't want to chat, but we have a lot of people to make public comments. So please keep your comments in the 2-minute range. We'll be here all night, which is okay too, but so that's what we're doing. And just bear in mind that make your public comment. There are a lot of note takers. We're taking the core and essential messages, and we have a lot of public comments that came to us online, which we're also going through to be sure that we've collected everything. Thank you.
Thank you, Madam Chair. We will now open the floor for public comment. We have allotted 90 minutes. If you wish to comment and we're not able to sign up in advance, again, we have comment cards here at the table. You can just turn them in directly to us. For our Zoom participants, we already got a show of hands. So I will now check with Spanish interpreters, but sorry, before I do that, for participants on Zoom, you may submit your comments via the Q&A chat. Just before your comment, put states, please read aloud, and we will do so. I will now check with our Spanish interpreters. Give me 1 second. Checking with the Spanish interpreters. No Spanish comments. Okay, we will have a 2-minute timer set up for public comments. So we will start with the sign-up list that we had online for folks that were able to sign up in advance. I please ask that the first 5 commenters make their way to the podium. The first 5 names I have are Rebecca Overmeyer Velasquez, David Jens Thomas Peterson, Rachel Kirk, Marilyn Kamimura, and Elena Vasquez.
Good afternoon.
I'm sorry, please state your name and affiliation.
Good afternoon. Thank you for taking comments, public comments. My name is Rebecca Overmeyer Velasquez. I'm with the Clean Air Coalition of North Whittier and Avocado Heights. We have several members of the community here representing Clean Air Coalition with us today. The BES was created out of the SB 158 package of reform laws that Governor Newsom signed in 2021, as you all know. As Governor Newsom said that year, quote, "This comprehensive legislation gives DTSC the tools and sustainable funding it needs to make our communities cleaner and safer and boosts transparency and accountability to the public," unquote. The BES was charged with increasing, quote, "transparency and oversight of the department and its work," unquote. That same year, 2021, is when we received notice that DTSC gave Quemetco temporary authorization to install new equipment without any public input whatsoever. DTSC approved this new equipment without first going through a regular public review process. They allowed Quemetco to install this new equipment under a temporary authorization that April, basically a done deal, which we appealed. Then Quemetco went back to go through a regular public hearing process for a Class 2 permit modification, but the equipment was already installed and in operation. Moreover, the public meeting scheduled in September 2021 was hosted by Quemetco, not DTSC, which means we could not discuss this backward process that DTSC had allowed. To be clear, the public has had no meaningful input on the installation of new equipment that is clearly designed to support the increase in production that Quemetco has also requested, but that has yet to be decided. So there are several things wrong with this process, and I want to focus on the process. The September 2021 Class 2 modification request to install and operate new equipment did not actually take the public comment requirement for permitting seriously, since the equipment was already installed and in operation. 2, this was a request to modify a permit that had expired 6 years previously. DTSC should have told Quemetco to include this modification as part of the permit renewal process so that we could evaluate the whole business at once. Why are we all wasting our time on this piecemeal modification of an expired permit? 3, while Quemetco is not permitted to increase production, the installation of this equipment is clearly a means to increase production and likely to go back to burning rubber and plastic in the furnaces, a request we know Quemetco has made to SCA QMD. 4, Quemetco was cited for several Class 1 violations in the year before DTSC approved the temporary authorization, including the failure to maintain a functioning secondary containment system and leak detection system for the batch house. I urge the board to save your credibility as a body that actually provides oversight of DTSC staff, and the BES must deny the secondary permit temporary authorization. Thank you.
Thank you, Rebecca. Sorry, I lost my order here. Next person is James. Is James here in person or online?
Just have the next person come on.
Okay. The next person is Rachel.
Good evening. My name is Rachel Valenzuela-Kirk. I have lived in San Gabriel Valley for 50 years now, and I urge you to deny the temporary authorization. I was shocked when I learned that this has been going on for 8 years. I assume, like many citizens, residents in this area, that this board, this group, is here to protect us, that they are to check on make sure that our health is not affected negatively by any kinds of businesses or activities. And I was shocked to find out that apparently that's not the case, that when it comes to people's health and worries about asthma or other issues, that the board seems to take more the side of the business by giving them continuing authorizations. So I urge you to think about it. Who are we here to serve? As a longtime resident, I just assumed that people elected or people nominated.
Thank you so much.
Thank you.
Oh, I'm sorry. I'm sorry. You have one more minute. I thought I saw 4 seconds left. I'm sorry. I apologize.
Yeah. Okay. Well, I was going to start by saying everything she said. I do agree with her, and I urge you again to think about the residents of this community first of all. Thank you.
Thank you so much. Next is Marilyn.
My name is Marilyn Kamimura. I'm part of Clean Air Coalition of North Whittier and Avocado Heights. I've lived in the impacted perimeter of Ecobat for 52 years. We are surrounded by freeways from rails, the closed landfill, and material recovery facilities. I know what it is to be impacted by a terrible environment, but I've always believed in the voices of the people. The people are here to correct the wrongdoings, and if they're not here to keep speaking forward at all the time, you cannot hear us or listen. So that's why we're here. By not following the established permit modification and appeal process for Ecobat on waste equipment and allowing a temporary authorization, you are shutting our voices. We hope you hear us. You have heard many people, you will hear many people tell about the impact, but I'm here to say, because we know the people who have been harmed. And so I ask the board to deny the temporary authorization. Thank you for your time.
Thank you. Next is Elena. Please state your name and affiliation.
My name is Elena, and I live in Avocado Heights. I implore you to deny Quemetco's temporary authorization request. Quemetco is a dangerous polluter that continuously harms my community and neighbors. I know this for a fact. I live about 1.5 miles away from Quemetco, and I decided to have my soil tested for lead, metals, and arsenic. The soil testing took place in August 2023, and the results yielded high levels of lead. For instance, my front yard tested for 117 parts per million. The drip line demonstrated 94.2 ppm, and my backyard was 163.1 ppm. As you know, the California threshold for safe levels of lead is 80 ppm. That means my backyard is nearly double the threshold for what the state of California deems to be safe. However, many of my community members and my neighbors know there really is no safe level of lead, especially for children, women who are pregnant, the elderly, or individuals who are immunocompromised, such as myself. I survived a cancer. As a young adult, I was fortunate enough to overcome a rare blood cancer. However, now I must cope with the fact that not only do I live dangerously close to Quemetco, but I must also live with the guilt that I am unintentionally endangering my loved ones' lives as well. By living near this toxic battery incinerator, my pregnant sister-in-law's unborn baby's life is put at risk. My niece, who visits me daily, is also at a higher chance of developing a neurological or intellectual cognitive impairment. My pet's health is also put at risk. Not to mention all the workers and students who go to school in the nearby community. That's hundreds of students. There are at least 20 elementary schools within a 2-mile radius of Quemetco who attend school for at least 30 hours a week. I am so saddened and frustrated since I know I'm not alone. I know there's countless others in my community with similar levels of lead. The community across Quemetco has also tested for, some of them have gotten results of 200 ppm. Therefore, I'm perplexed. Why would you even consider allowing this temporary authorization request? If it's your responsibility to oversee emissions from corporations, then you have a moral and ethical obligation to hold them accountable, to ensure the safety of the workers, the residents, and the students in the community. I hope you do the right thing. Use your authority to push DTSC to do better and deny this temporary authorization request. Otherwise, you're going to leave tonight and you're going to have this on your conscience, that you are contributing to the exploitation of local residents for greed and profit. If you're okay with that on your conscience,
a lot of commenters tonight. Please, thank you.
I know.
I'm so sorry. We have a lot of commenters tonight. Next, the last person that signed up online is Duncan McKee. And
let's get the next 5 people.
You also signed up with a comment card, but you signed up online, so prioritizing your online comment yourself.
Okay.
Please state your name and affiliation.
Duncan McKee, I'm a community member. Really wondering how we can be modifying an expired permit that has conditions that have not been met to this day from 2005. We believe that DTSC has made an error that applicant must provide truthful and accurate and complete information in these applications. They failed to disclose that they have these applications in with AQMD to act as a hazardous waste incinerator by incinerating hazardous waste, plastic, and rubber. They no longer are allowed, or KW Plastics is not taking this material as recyclable material. In fact, DTSC is involved in cleaning up the mess that was caused by it up there. This will not improve the management of hazardous waste if they are permitted to start burning plastic and rubber. All they have to do is vacuum up and pump that material off that containment floor into the wastewater treatment facility. We believe that the centrifuge is to dry that plastic and rubber prior to it going to the rotary kiln dryer and being fed to the furnace and incinerated. And their attorney is inaccurate in saying that the furnace temperatures can be lowered in that they have a application in with AQMD to increase the temperature of the rotary kiln dryer, even though the scientists at AQMD recommended lowering it to reduce the cancer risk. He's also inaccurate. Just look up Morris Kirk from Alco Pacifico, where Quemetco was involved in dumping hazardous waste in Mexico, where little children were exposed to that waste.
Thank you.
Okay?
Thank you.
Thank you.
Thank you very much.
So before we move on to the comment cards, I want to honor David Jens Thomas Peterson that signed up online. I'm calling on him again, calling on them again if they're here. David? No? Okay. We're going to move on to comment cards now. I'm going to call on the first 5 names. If you can please line up behind the podium or at the aisle. I have Stephanie Scruggs, Mark Hoffman, Mike Buchans, and please apologize. I do apologize if I'm not saying your name correctly. Ozzy Martinez and Art Loza. First is Stephanie Scruggs. Please state your name and affiliation.
Absolutely. My name is Stephanie Scruggs. I'm the Chief Sustainability and Health Safety Environmental Officer at Ecobat. I'd like to start by thanking you all here for providing this forum for constructive feedback and this public engagement for all interested parties. I'd also like to take a moment to acknowledge the employees, community members, and Teamsters who've shown up today in support of the temporary authorization. If you wouldn't mind showing your hands, I'd appreciate it. At Ecobat, we're proud to serve and provide a vital service to California and for the rest of the nation. We are the only lead-acid battery recycler west of the Rockies. Our facility allows California to responsibly recycle the waste it generates within the state. The City of Industry facility is the cleanest lead-acid battery recycler facility in the world. And without Ecobat, most of the millions of spent lead-acid batteries generated in California would be exported to foreign countries that have significantly lower environmental standards or illegally disposed of in landfills. We strive to continuously improve our environmental performance, and since 2008, our facility has invested over $50 million in state-of-the-art emission controls. At our facility, we recycle 240 million pounds of lead annually, and our lead emissions only total about 5 pounds. That's less than a single car battery. Our lead emissions are 80% below AQMD stringent legal limits. Our dewatering project is the most recent example of Ecobat's resolve and commitment to do the right thing, and we are looking to invest in environmental improvements now. The project allows us to improve the management of our hazardous material now. And also it allows us to reduce the risk for hazardous materials and potentially entering groundwater, and also reduces the possibility for increased sulfur oxide emissions. So with this, I'd like to take a moment to really ask, thank you.
Thank you.
Thank you very much.
Mark Hoffman. Please state your name and your affiliation.
Yes, my name is Mark Hoffman. I'm the Environmental Director for Ecobat Resources. I'm going to reiterate a lot of what's been said here, but I'm doing it for a reason. As part of the lead-acid battery recycling process, lead-bearing materials are currently transferred to the containment building. They contain a significant volume of liquid. which we talked about, drains across.
Mic up a little bit so everyone can hear
Sorry.
you. Thank you.
Which we've talked about, drains across the containment building floor to some ports pumped for further treatment. The dewatering project improves this process. It removes the liquids before transferring the lead-bearing material to the batch house. Those liquids are removed in an enclosed system. This has several environmental health and safety benefits. We've talked about them. I'm going to reiterate them because I think this is an important point, that this is environmentally beneficial. Handling the liquids in an enclosed system and reducing the amount of liquid on the batch house floor makes the operation safer for the environment by reducing the risk of release to soil or groundwater. A component of this liquid is electrolyte that contains sulfuric acid. Removing the liquid before feeding the material to our drying kiln and furnaces reduces the amount of sulfur dioxide emissions generated. Additionally, drier feed material uses less energy to smelt. Our furnaces are natural gas fired, and if we require less energy to smelt, there's a reduction of energy-related greenhouse gas emissions. These are all environmental benefits. We've been seeking approval to operate this equipment since early 2021, coming up on 3 years. Due to appeals, we've been largely unable to operate it. We respectfully ask the board to deny Clean Air Coalition's appeal and allow Ecobat to begin operating the dewatering equipment that DTSC has repeatedly concluded will be more protective of human health and the environment. Thank you.
Thank you.
Thank you. Mike? Thank you. Please state your name and your affiliation.
Chair Riddle, members of the board. My name is Mike Buckhans. Your pronunciation was really good. I'm the manager of environmental technical support for Ecobat, and I'm also the owner of a consulting firm called PB Environmental Consulting, which specializes in environmental concerns for the battery recycling industries. I've been doing this stuff for lead recycling facilities for nearly 25 years. The pollution control equipment employed by the Ecobat facilities throughout the United States, but particularly at the facility in the City of Industry, is unmatched by any lead smelter on the face of the earth. Since the mid-2000s, throughout the smelters in the United States, Ecobat has invested tens to hundreds of millions of dollars in pollution control technology. In each of its facilities, the footprint and the space taken up at the facility by pollution control equipment is actually larger than the space taken up by the production equipment. Ecobat's processes effectively recycle or reuse all of the components of the battery. The battery plastic casing is recycled, the acid in the battery is recycled, and of course the lead components are recycled as well. Since the deployment of its WESP technology, lead emissions have been reduced by 98% to around 5 pounds a year. Arsenic emissions have been reduced by about 95% to about 6 pounds a year or less. Lead is the most recycled material, more than aluminum, more than newspaper, more than aluminum cans or plastic bottles. The recycling of lead has gotten us to the point where we no longer have to mine lead in the United States and bear the consequences of environmental impact from mining operations. It's an incredible success story in the world of environmental excellence, and we continue to pursue it through the use of supplemental pollution prevention projects. We have applications at DTSC and AQMD for VOC reduction, for NOx reduction, and to reduce the amount of hazardous waste over the road through a plastic pelletizing project. Thank you for your time today.
Thank you, sir.
Thank you. We appreciate your comments. Ozzy Martinez, please state your name and your affiliation.
Good afternoon. My name is Ozzy Martinez. I am a West operator at Ecobat. Not only do I work at Ecobat, I also live in the community for the last 24 years where I'm raising my family. In my role as a unit steward, ensuring the welfare of my fellow workers is most important. Ecobat, with its 250 union members, is committed to our health and safety. Many of our Teamsters members have worked in our recycling facility for several decades, and we take pride in what we do and in being a good neighbor. The dewatering project reduces waste, enhancing workplace safety, and underscoring the dedication to excellence. As a union steward, I proudly support this initiative, knowing it not only safeguards the well-being of my fellow Teamsters, but also fosters a workplace and culture that prioritizes their health and the health of our community. We know that the dewatering equipment works, but the small group of opponents use unfair delaying tactics that prevent us from using it. They do not deny the environmental benefits but they oppose everything Ecobat supports. They even argue and urge a boycott of City of Hope Ecobat because Ecobat contributes. This blind opposition doesn't make our neighborhood a better place. Thank you.
Thank you.
Thank you. Next up, we have, thank you. Next up, we have Art Loza, but before you begin, let me call up the next 5 commenters so that they can line up. I have Alyssa Manukian, Jackie, it just says Jackie, Adriana Quinones, Greg Freach, and Paul Ortiz. Thank you for your patience. Art, please state your name and your affiliation.
Art Loza, Teamsters Local 986. My name is Art Loza. As a dedicated union representative, my allegiance, it lies with the 250 union members, whom are the heart of Ecobat. And without our unwavering commitment to health and safety is embodied in our work culture. My fellow union workers and I have the right to a healthy, safe workplace, and we proudly believe that we have that. We also believe our recycling facility is a good neighbor. We are proud of our work recycling millions of batteries, keeping them out of the landfills. Unfortunately, our opponents, to my left, are a small group of individuals that only want to get rid of us and the 250 jobs. They oppose everything, and they bully and harass everybody that has anything to do with it. Anyone who expresses support for our facility, and they even oppose when Ecobat has had health fairs. They've had food drives. They show up and protest those for the community. They challenge everything using government bureaucracy to delay projects like dewatering that have the environmental benefits. We're here to ask that this thing goes forward. The same people that protest Ecobat are the same people that would show up to the facility when there's food drives. They're the first ones to step in line. They go in there and they get the food. They show up, they get the benefits. I've personally witnessed it myself. Individuals here, where they go in there, they stand in line, they take the free food that has been given out to the community, then they go and drive across the street, park their cars, leave their cars there, grab the protest signs, and then they start protesting the same benefit that they just benefited from. That's ridiculous.
Thank you.
Thank you.
Alyssa Manukian. Please state your name and your affiliation.
Hi, my name is Alyssa Manukian from the Clean Air Coalition. I would like to, I'm just going to make this quick, cut out some things. I also remember him from some rallies that we had outside of these community days that the surrounding community was not involved in for the most part. And he, we weren't against, no one went inside to get food, and he yelled at us to get a job on a Saturday morning, practicing our right.
You could limit your comments to what's in front of us. The crossfire with each other is not going to get us. Okay, so if you could do that, I'd appreciate it. Give her time back, but yeah.
Am I allowed to address like something that the Ecobat lawyer said to you?
Absolutely.
Okay.
Anything that has to do with the temporary authorization, your experience as a community member is totally welcome, but yeah.
Okay, I'll start over.
Thank you.
I would like to thank you for coming out here to Hacienda Heights today. In my experience in meetings with the DTSC, it's often challenging to have dialogue about Ecobat, as well as discern between the vague language used by the representatives of DTSC to the community. As you showed times you were confused by what the representatives of DTSC were saying is exactly how I and many other community members have felt every time with them. On top of that confusion, we've been limited to 1 minute long public comment without any opportunities to respond, and the DTSC has not even tried to answer our questions oftentimes, which, as you pointed out, there is a drastic difference between public comment and public engagement. And the public has not been meaningfully engaged, which is why I urge you to deny the temporary authorization. I would also like to briefly address some comments made by Ecobat's lawyer. He mentioned how if the facility were to close, then our car batteries will get sent to developing countries where the environmental regulations are much more lax. Firstly, Ecobat already has facilities all over the world. According to their own website, the first Ecobat facility was opened in Italy in 1938, the same year the fascist Mussolini came to power. Their next facility, according to their own timeline, was in 1948 in South Africa, the same year that the white supremacist apartheid government seized power. Ecobat still has about 6 facilities operating in South Africa from my memory. A company with this history is exactly the kind of company taking advantage of lax environmental laws in developing countries, and he should not be allowed to justify the pollution of our own communities by claiming that these batteries get sent abroad to their own Ecobat facilities in poor countries. Yes, car battery recycling is essential, but that doesn't mean that the children and people of Hacienda Heights, La Puente, and surrounding communities should have to live in a sacrifice zone for lead acid battery recycling through the burning of hazardous waste. I would also like to say that the Teamsters and other workers have my full support. I've participated in practice pickets in solidarity with the UPS Teamsters last summer. We have much more in common with each other as workers than we do with the members of the ruling class, like the CEO of Ecobat, who makes millions of dollars per year. Side with the community members and not with the ruling class that doesn't care if we're poisoned. I fully understand where the resistance to want your jobs to go away. Workers who were the facility, the Farmer John's facility in Vernon that were closed, are currently working with union reps to get integrated into new jobs. And I fully support the workers' desire for work and money.
Thank you.
Thank you.
Jackie? Please state your name and affiliation. You have 2 minutes.
Good afternoon. My name is Jackie. I'm a member of the community here.
Hold the mic a little closer so we can all hear you. Thank you.
Is that better?
That's better, Jackie. Thank you.
Thank you. Good afternoon. I'm here today because my husband died of a rare aggressive form of cancer. I was unaware of Quemetco Ecobat when I first moved to this area. It was only through a friend moving to an adjoining community and their dealings with the AQMD. I was astonished to find out how little I knew, and speaking with local residents, I've learned that I'm not alone. Quemetco Ecobat is a known polluter due to their many violations, and they have been for years. They have been allowed to continually operate with little consequence. They are given special privilege to operate under the guise of emergency needs to circumvent the system and ignore any public engagement. This is in stark contrast to other local concerns. For example, we had a shooting range moved to a different location due to noise. We build walls along freeways. We acknowledge complaints of smelly hot sauce factories, yet toxic pollution is somehow okay. People are sick and people are dying. Where is the outrage or concern? In addition, I question the supposed goal is to decrease the pollution. Why should there be any consideration of an increase in production by 25%? Quemetco Ecobat is not the only one accountable. The DTSC has the purpose to watch over our communities, and instead they are complicit. We should be here today discussing the denial to Ecobat, also known as Quemetco, for any renewal of any permit. They never should have been able to operate with an expired permit. Quemetco Ecobat should be responsible for the cleanup of the surrounding neighborhoods and their own work site immediately. Nothing else should be in consideration before this. Thank you.
Thank you for your comment.
Thank you. Adriana, please state your name and your affiliation.
My name is Adriana Quiñones, a community leader in Hacienda Heights. I was going to write my speech, but I'd rather speak from the heart. I'm here to represent my nephew, Christopher Saldaña, who died of a rare form of cancer at the age of 36. My family did not know we had Quemetco in our backyard. When I found out about it, I started doing research, and for 9 years, I have been involved with Clean Air Coalition. And I was writing some of the notes that made me very upset. You know, I'm part Italian, so, you know, my temper just went up. The attorney mentioned something about public engagement. I think he doesn't know our community. Our community is composed of, you know, we have Koreans, we have Chinese, we have Latinos. The outreach has not been done in those languages. How many community meetings, real meetings, have we had? I can tell you with one hand how many. Why are we talking about giving them a temporary permit without them following the rules? Why do we continue? What does DTSC continue to cater to them? Should they not be representing us, the community? What about a KQMD? The same thing. I was writing all the things that were coming to my mind, and one of the things was no confidence. in our government, because how many of our people need to die before somebody takes these companies like Quemetco seriously? I can tell you that for the rest of my life, I will continue to fight against this company because too many of our community members have died. And I understand the Teamsters wanting to keep their jobs, but at what cost?
Thank you.
Thank you. Thank you.
Greg Freach, you have 2 minutes. Please state your name and your affiliation.
My name is Greg Fritchell. I'm a resident of the city of Walnut, a retired social worker, and a 5-time top 2 candidate for the state assembly. As a candidate and as a private citizen since, I place high concern on good government. And that means not just doing the right thing, but doing it the right way. The ends cannot be used to justify the means. Hurrying an inadequate solution is not better than taking the time to find an adequate solution. I heard the DTSC representative saying that he thought that the approval of the temporary authorization currently under appeal was a no-brainer. This underscores a very concern I've had about regulatory agencies using the wrong definition of oversight as an act of overlooking rather than an act of overseeing. The purpose of these bodies is to hear and consider the input of experts, not to declare themselves the experts. No, none of this is a no-brainer. The DTSC is just to find its own error. The Ecobat representative essentially argues its own benevolence by suggesting that the other companies might just export their toxic waste elsewhere. Apart from being purely speculative, that argument is irrelevant. We're not as bad as the other guys is not a valid argument for getting a pass on proper oversight. Further, their quote of Senator Allen's statement is truly ironic, given that they are in fact importing toxic substances from all over the country and all over the world for their business. The DTSC's own stated mission is to protect the people. Ecobat continues to operate while multiple toxins continue to accumulate and dispersed in the local neighborhoods. As a social worker, I worked with many families in the neighborhoods immediately surrounding this facility. I not only came into their neighborhoods, but into their homes. I got a firsthand look at their living experience. Like my brothers in the Teamsters here, I'm a union guy, a 33-year labor activist. And as such, I'm concerned about the long-term effects, health risks posed to delivery drivers who make regular stops at Ecobat. I'd like to think they are too.
Thank you.
Thank you. Paul Ortiz, as you make your way up, I will call the next 5 commenters. I have Taona, Stephanie Serrano, Jeffrey De La Torre, Sam Vo, I believe, Reina Schmitz. Please line up behind the podium. Thank you, Paul. You have 2 minutes.
Yeah, my name is Paul Ortiz, and I'm a resident here in Hacienda Heights. As a matter of fact, maybe about 1 mile from the plant. I'm asking you to allow them what they're asking for. I know that AQMD is monitoring them, and I know the AQMD is it's real hard on companies that pollute. So I know they're monitoring them and they're making them do things that they're supposed to be doing. I understand cancer and all this other stuff. But I mean, we're going to be looking at that. We might as well look at all the cars that go along the highways, all the exhaust, all the rubber, everything, because all of that contributes to pollution that we breathe and inhale and everything. So, I mean, it seems to me that they're trying above and beyond to try to meet the recommendations that the AQMD and you guys are making them do. They just had to pay a fine, and I'm pretty sure that hurt them. So I know they don't want to do anything else to cause any more problems with you guys or the AQMD. So, you know, too many jobs have gone out of this state and they're going to other states, good paying jobs. And I'm not just saying that, you know, I'm concerned about people's health, but they are complying and they're just asking for an extension. And I think it should be given to them.
Thank you.
Thank you so much. Taona?
Hello, good evening, everyone. My name's Taona, and I'm proud to represent Ecobat today, where I've been an employee for close to 6 years now. When I first started working at Ecobat, I came straight out of college with my chemical engineering degree. And I was really excited to be involved in a role where I could actually make a positive impact on the environment. This initial role as an environmental supervisor, it allowed me to make a significant impact by ensuring compliance with the best practices. During my tenure of 6 years, I've experienced various roles tied to continuous improvement projects. In my current role as a senior process engineer, I even had the opportunity to work on the dewatering project. Accordingly, I've seen Ecobat's commitment to continuous improvement from enhancing safety controls and environmental protocols, as well as nurturing a culture that elevates our employee morale. As someone who truly values family and I deeply, truly care about my colleagues, I prioritize workplace safety. A priority that Ecobat shares wholeheartedly. They spearheaded, in fact. Our dedication to continuous improvement is showcased in initiatives like the dewatering project. Being intimately involved with this initiative, I've seen its positive impact. Once implemented, it will enhance safety, benefit our community and the environment. But these delays, due to bureaucratic delays, has been pretty frustrating for a project with such clear benefits. It's challenging to understand the opposition. So let's pause and reflect. Do we want employees to thrive in an enhanced and safe workplace? Do we want Ecobat to continue its path towards improvement? I think we all want the same thing in this end of the day. And to get to what we want, it's crucial that we move beyond individual agendas. Thank you for your time.
Thank you.
I have Stephanie Serrano next. Thank you. You have 2 minutes. Please state your name and your affiliation.
Hello, everybody. My name is Stephanie Serrano, and I am the Vice President of the Board of Education for Hacienda La Puente Unified School District, the largest school district in the San Gabriel Valley. We have 22 school sites within a 2-mile radius, largest stakeholder in the area. I am also a member of the National Federation of Women, and all of which are taking a stand against this permit. Equally important, I'm a mother in the community here. I'm a strong advocate for unions. I'm a Teamster family member and showed up in solidarity along with the community activist to stop Amazon warehouse in West Covina. I am here to represent 15,000 students, nearly 3,000 staff members, of which are part of 3 unions, SEIU, CSEA, and HLPTA. I am also here on behalf of the 15,000 students that attend our adult school, which is the 2nd largest adult school in the district. In California. I'm also here on behalf of the Gabrielino Shoshone tribe, and they have given me permission to let you all know that they stand against this permit. Okay. The school testing composite testing mechanism is inappropriate. We already have written proof that that testing system is inappropriate. We have asked them to test one of our school sites, and it's inadequate. The specific machine permit that is being requested is for another purpose. The larger picture is that Quemetco is seeking to start acting as a hazardous waste incinerator, burning plastic. And I'm concerned about the children that are going to be breathing in plastic and rubber chemicals in our community. Quemetco keeps bypassing the stakeholder engagement legal requirement for this process because it is clear that community stands in opposition of this. The community meaning the people that are not paid by Quemetco. Please test all the schools that are downwind from this company because it is poisoning our community.
Thank you. That's time.
Thank you.
Jeffrey de la Torre. You have 2 minutes. Please state your name and your affiliation.
Thank you. Good evening, everyone. My name is Jeffrey de la Torre, and I'm here as a resident of the Hacienda La Puente Unified School District. So I'm also a parent. Based on Ecobat's own website, approximately 10 million batteries are recycled annually at Quemetco Ecobat. My concern is that the lead particles have polluted our atmosphere. Lead has been embedded in our communities, and we have a great deal of homes and schools, 22 to be precise, within a mile or 2 radius that are being affected. We know that Quemetco Ecobat is the only melting recycling facility in our vicinity. And I am asking Ecobat to soil test our nearby schools and clean after themselves, as a good neighbor would if it infringes on its neighbor. I ask and I urge the board to please not authorize any extensions or permits, and to support, hopefully soon, the closing down, so that our communities can live peacefully. You know, I'm a union member too, with UTLA. That's my day job. I can tell you that, you know, I worked in Vernon. We have had other, you know, they took it upon themselves to clean after themselves. You know, they pay off some people to live in a hotel while they did all that. And we're just asking them, as if I'm a dog owner and I'm walking my dog and my dog would poop on somebody else's yard, you know, clean after yourselves. And so that's what I'm asking Ecobat to do the same in our community. We understand that we're close to the freeway. We understand all that, but we need to do our part to make sure that we provide our family, our children, the very best that we can. So thank you so much for your time. I appreciate it.
Thank you. Thank you.
Thank you. Next, we have Sam. Sam, you have 2 minutes. Please state your name and your affiliation.
Sam with the Clean Air Coalition. I'm here because I am pro-labor. I see the Teamsters here. We're not trying to take your jobs away. What your facility is asking for is an expansion. And what your facility is asking for is to circumvent all the safeguards that should theoretically exist to help protect and safeguard our right to live free from contamination and to protect our public health. Had the DTSC done their job, we wouldn't be having this conversation and you wouldn't be yelling at us. Yet the DTSC has systematically engaged in racism and discrimination against the community residents of La Puente, Bassett, Avocado Heights, and Hacienda Heights. They were shown a video at the beginning of this year that showed that more than one emission stacks are producing emissions from the facility that are not part of the West stack. So you might be the cleanest facility in the world, but you can't deny what I know every single night to be true, that emissions are coming from more than one emission stack that are completely unregulated, and that you have water leaking from the facility, seeping into the San Jose Creek, and there's been no investigation of that. Now, I respect your right as labor, but I also respect our right to live free from public health dangers. I'm also a part of the union, and that is the Unión de Ranchos. And in our community, the contaminated soil, we breathe it when we're working our horses. Nosotros somos gente de rancho y no toleramos este abuso.
Thank you.
Thank you. Reina Schmitz, and as you make your way up, I have last 2 comments, Andrea Gordon and Erica Estrada. Can you please line up behind the podium? Reina, you have 2 minutes. Please state your name and your affiliation.
My name is Reina Schmitz. I'm a member of the Citizens Oversight Committee. Years ago, we passed a bond to improve the schools in our community. I retired from a union for over 30 years. I'm a strong supporter of unions. I work with the Teamsters in many occasions. I box now foods that I'm retired for the food banks. So I do a lot of volunteering. But what I'm here about talking to you is that the health and the well-being of both the employees and residents around the facility that we're talking about, it's important to keep them safe. And that means the responsibility has to take a lot in mind to keep it safe of danger for both the employees and the community, especially the children. The employees, many of them, yes, they can afford to live around where they work or close to where they work, but not everyone. They will come and work and leave. They take something with them. They're breathing for 8 hours. Students are breathing the air that is contaminated. The water is seeping into the soil. Where is it going? Who's catching the water? Who's really cleaning this soil? Think about it. We care about the employees, but we also care about the communities around us. Please, think about it. Confrontation doesn't bring as much leverage as cooperation. Thank you.
Thank you very much.
Thank you, Reina. Next up, I have Andrea Gordon. Andrea, you have 2 minutes. Please state your name and your affiliation.
My name is Andrea Gordon. I'm with the Clean Air Coalition. I'm a former 47-year county employee working all throughout LA County. I'm also a cancer survivor. I did chemo for 6 years. I was treated at City of Hope. I recognize PR campaigns, and what you have is a very underserved community without a lot of financial resources, seeking to right the wrongs in our community, and we get the weight of large corporations, all their lawyers, all their PR campaigns down upon us, and then we get criticized and attacked for it. We just want the Department of Toxic Substances Control to do their job and protect our communities from the pollutions that we've endured. In our own community, we have seen repeatedly, over and over and over, violations repeatedly. And then they fight the violations. The state of California sues Quemetco or Ecobat. That also is a PR campaign to make it sound like they're more environmentally friendly. They tout the fact that they are the best at this or that, but they continue to pollute and violate. We just want that stopped. That's all. Stop it. And as a former union president for government workers, managers, as a matter of fact, as the founding president of a union, I stood with union labor all over this county all the time through the LA County Federation of Labor, representing 850,000 union working people. I don't want anybody to lose their jobs. I want them to save their lives. That's what we're talking about here. Something much more important. Thank you.
Thank you.
Thank you. And for our last comment card, we have Erica Estrada. And after this comment, we will be moving on to our Zoom participants. Thank you so much for being patient.
Okay. Good afternoon. My name is Erica Estrada. I am a teacher for Montebello Unified School District. I'm a proud union elementary director for Montebello Teachers Association, and my husband is a proud Teamsters for Bonds Albertsons for the past 20 years. And I'm sad and shocked because he said that Teamsters are not supporting this meeting, according to him and his shop steward. So I'm saddened to see that union workers are not supporting the well-being of students in this community. And so my question here is, if this company is so great and wants to expand, just like Bonds has, just like all the other companies have, why can't they relocate to a less populated area where there's not that many students, there's not that many roads? We already have, yes, all this contaminants from freeways. Yes, of course. But why would we want to add triple, quadruple, 100 times over when there is lots of expansion in other areas? Now, the question here, nobody would lose their job if they just relocate away from 20 elementary schools, right? And so the question is, Mr. CEO, this is a question, would Mr. CEO be okay with having this company in his backyard? That's the question. That's the way, would I want my students, my son and daughter be treated the way, the teachers treat? That's how I see my job. I'm a teacher. So I treat my students the way I want the teachers to treat my son and daughter. So this company, would you treat your workers the way, your family, like the way you're treating your workers and the community, Hacienda Heights especially? That's a good question to ask. Would you put this company in your backyard? That's the question we need to ask.
Thank you. That's fine. before we move on to Zoom participants, I just wanted to mention we do have 3 hands raised on Zoom. Looking at the time, we still have ample time before our 90-minute mark at 6:15. So I will start with the first hand. Cynthia Babbage, please. We'll send you a request to unmute. You have 2 minutes. Please state your name and your affiliation.
Hi, my name is Cynthia Babbage. I'm the director of the Del Amo Action Committee, and I'm also the coordinator of the Los Angeles Environmental Justice Network. I just want to say, first of all, that the community members have done an outstanding job today representing themselves. Just because we have a crisis with hazardous waste, and I will note that the hazardous waste report just came out yesterday, and many of us are looking forward as using that document to really get to the bottom of how hazardous waste is handled in California. There's a lot of shenanigans that are going on behind the scenes with politicians and the fact that we're so dependent on the recycling of lead batteries. I watched it firsthand as I was on the community advisory panel looking at hazardous waste. And so I just want to say that just because we have a problem and we don't have Exide community people to keep poisoning, it doesn't mean that we have to sacrifice this community. No more sacrificing of communities. This is overburdened, just like we do in Kettleman City and several other places where we dispose of hazardous waste. It's hard enough to try and get a word in edgewise when you have so much against you. Please do not allow people to not follow the weak process that we already have, but it is a process. Just because there's some epidemic that we need to increase the battery recycling and not be honest about it. We're all adults. Let's figure it out. You know, there's a lot of pieces that go into the solution. So deny any further Quemetco, Ecobat, whatever you want to name yourself, shenanigans, and support the right of people to have a life. Thank you.
Thank you so much, Cynthia. And before I move forward, I wanted to correct the instruction that I said earlier. So folks that do have their hand raised on Zoom, we will send you a request to unmute. For those that are having technical difficulties or are unable to make verbal comments, you may use the Q&A chat function. Please clearly type at the beginning of your comment, please read aloud. Otherwise, we will send you a request to unmute if you have your hand raised. The next person on Zoom, we have Florence Garabidian. Please accept the request to unmute. And you have 2 minutes. Please state your name and affiliation. Florence, please accept the request to unmute. Okay, I'm not seeing Florence coming up. So I'll move on to the next person. I'll come back. The next person we have on Zoom is Vanessa. Please accept the request to unmute. Vanessa? I'm not sure if we have technical difficulty happening on Zoom or if folks aren't accepting the request. Okay, I'll move back to Florence when I hear from our tech team if we're able to send them a request to unmute. Let me try on my end if I can unmute them. No, I can't. Okay, while we try to fix that, I'll go to the Q&A comments. Again, if you have any technical difficulties or if you are unable to make verbal comments, please use the Q&A function to write a comment. Please clearly type at the beginning. Please read aloud. So far, I have one from an anonymous participant. And it reads, I live in this community, and Ecobat's efforts toward health and safety are commendable. The dewatering project is a positive step that benefits us all. Let's not delay progress that improves the well-being of our families and the environment. The dewatering project, with its efficient liquid removal process, sets a standard for environmental responsibility, and it's high time that we all embrace this improvement for the betterment of our community. That was from an anonymous participant. So I will go back to our hands raised on Zoom. Are we able to send a request to unmute for Florence Garabidian?
Okay, we got it. I don't know what went wrong. This is Florence Caribbean. I'm the chair of the Del Amo Action Committee and darn proud of Cynthia for her excellent comments. I look at this issue a little differently, and that is because I worked in the environmental field for 50 years. I worked for DTSC. We did enforcement, and I can tell you the first thing is you don't have anybody from enforcement here who could describe the circumstances that are going on at that facility. The water, I have a big issue about what would happen to the water under this scenario. First of all, I don't think it would be as effective as they allege that it would be. And I wonder how they collect the water, where the water goes, pointing out that every part of a battery is contaminated with lead. So there's no reason why the water would not be contaminated with lead. When I heard Duncan McGee say that the South Coast was considering allowing Ecobat to put the plastic into their incinerator, I just was like astonished. It's not the right thing to do. I don't think this project has enough technical support to really prove that what they want to do would even make that big of a difference. And I think that should be demonstrated. And I also think it's a shame you don't have anyone from enforcement saying what they saw when they went there. What's happened to this water all this time? And again, please accept every part of this is contaminated with hazardous lead. The last comment I'll make is that I worked on a company that took perk, and they made a big mess out of perk, and everybody waved their arms around and said, oh, what are we going to do? What are we going to do? We closed them down. Other companies picked it up. We need new technologies. And thank you so much for listening to my comments. I am not in favor of the approval of this project.
We're going to move on to Vanessa.
For many reasons.
Vanessa, please accept my request to unmute for someone's invitation.
Hello.
Invite. Oh, there you
Jenny.
are. 2 minutes.
Yeah.
Please name and your affiliation.
So I'm an outreach specialist. I help homeless youth out in the community. And my comment, jobs are crucial for our community, and Ecobat provides 250 union jobs. Let's appreciate a company investing in its employees and community. This dewatering project ensures safety and contributes to a healthier business climate. It's a win-win for us all. Ecobat's proactive approach to investing in environmental improvements, such as the dewatering project, sets a standard for corporate responsibility that other companies should aspire to benefit, both our local economy and the overall community well-being. And that's it. Thank you.
Thank you, Vanessa. I apologize. The next person, Shahrazad, please accept our request to unmute. Shahrazad.
Yes, I'm here. Thank you. My name is Shahrazad Shishagar, and I'm a member of the San Gabriel Valley Progressives. I represent 156 members that reside in the area. And we are very concerned about what is happening with Ecobat, because they've been for 8 years now, having permits that were expired. And there's been appeals and requests for temporary authorizations that prevent the community from engaging in a reasonable engagement with the company. And I'm very worried about what DTSC is doing. The oversight they're supposed to be providing is not happening in my book, because why would they allow them to continue to perform with an expired permit? If the smelters are so good and dewatering project is so wonderful, why are they and why if Ecobat is so friendly and safety conscious, why not apply for the regular permitting process so that we as citizens can have oversight of it as well? Why go for a temporary authorization which shuts us out? Please deny the temporary authorization and ask them to proceed with a normal process. I would ask them to go through the regular permitting process, because employers may be safe. Also, the employees may be safe due to their protective gear. I'm assuming that they have that going on, but the community doesn't have that protective gear. You heard the lady who tested her soil, which showed elevated levels of lead. That is of serious concern. I don't know why there's not current testing going on, and I would urge that as well. Therefore, I am definitely against approving the temporary authorization. Thank you very much.
Next person is Luz. Luz, please accept our request to unmute. Please state your name and your affiliation.
Yes, can you hear me?
We can hear you.
There's an echo on the Marvin, can you pause my time, please? There's an echo on the Zoom, and I'm not quite sure that's regular word.
Echo on our end. I believe it's just because of my microphone. As soon as I turn it off, it should go away. Go ahead. You have 2 minutes.
Okay, can you start my time then? Since I was trying to figure out what the
started your time yet. As soon as you start your comment, your time will start.
Thank you. Hello, everyone. My name is Luz Sandoval, and I'm the parent and proud parent of Kimberly Sandoval, she's 13 years old, and she's an advocate for kids with disability. And I'm very concerned if you pass this permit. It's not very good for all students in schools, because right now we are having a lot of problems with school, that they're closing schools and they're not being tested. So that's a main concern for all students and the kids, because these kids and children are future of our doctors, engineers. And if you pass this, we are jeopardizing their health. So every time you go ahead and pass these things, just imagine your hands. Look at your hands, because this is something with the kids is going to be very jeopardizing their health in the long run, and we're not going to have enough doctors, engineers, surgeon, psychology, and all the students that they're going for to get their careers. As I was saying, look at your hands. They will be full of blood if you let this pass. So every time you wash your hands, it's like you're passing one person who's dying. So we're not, every time you wash your hands, we don't supposed to be like just washing your hands like nothing's gonna happen. It's going to affect our kids, our youth, our seniors' health, regardless what it is. Please do not let this pass. Again, thank you very much and have a good day.
Thank you. Are we moving on to the next Zoom participant, or are we going to go to emails?
If you're not echoing, we can.
Okay.
I was just going to give you time to move locations because I think
Okay.
it's your location.
Thank you. I'm sorry. For those on Zoom, we're trying to fix the echo issue. It doesn't seem like it's continuing, so I will move on to the next person on Zoom. Ricardo Martinez, you have 2 minutes. Please state your name and your affiliation. Once you accept the request to unmute.
Hi there, can you hear me?
Yes, we can hear you. Go ahead.
Okay, I'm going to be doing this in Spanish. Hola, mi nombre es Ricardo Martínez y soy residente de la ciudad de La Puente y delegado del Distrito 56 de la Asamblea para el Partido Democrático de California. Voy a leer unas frases de la misión de DTSC en su página web. Las salvaguardias de California contra los derechos peligrosos comenzaron en gran medida con 5 miembros del personal que trabajan en el Departamento de Salud de California a principios de la década 1970. Hoy en día, el Departamento de Control de Sustancias Tóxicas.
Can we please pause the time for Ricardo? I'm sorry. We need to.
Pardon me? Hello?
Sorry. If you're giving your comment in Spanish, then you double the time.
Okay, yes, I
So
specifically
you have
said
double
that
the
I was going
time
to provide
because
the
you're
comment
doing
in
it in
Spanish.
Spanish. So then we'll have somebody translate afterwards. So you can continue.
Okay. Hoy en día, el Departamento de Control de Sustancias Tóxicas, DTSC, es un departamento de gobierno estatal de pleno derecho que cuenta con aproximadamente 1,000 puestos en Sacramento y 9 oficinas regionales. Todos comparten una misión: proteger a la gente y el medio ambiente de California de los efectos nocivos de las sustancias tóxicas. Como llegamos hasta aquí, es una historia de emergencias y respuestas, de protesta pública y acción gubernamental, de investigación científica rigurosa y divulgación pública que conduzcan a regulaciones y aplicaciones sensatas. Leí esto y me pregunté, esto viene de la página web de DTSC, sobre la historia de DTSC. Yo leí esto y me pregunté, ¿dónde está tratando DTSC con Quemetco? ¿Tienen una relación especial con esta compañía? Una empresa cuyo ha violado repetitivamente muchas veces las políticas ambientales. Es nuestro derecho a vivir en un ambiente limpio, seguro y saludable. Las acciones de Quemetco no solo ponen en riesgo nuestra salud, sino también nuestra calidad de vida. Nuestra comunidad merece algo mejor y es deber de esta Junta proteger nuestros intereses. Por eso imploro a la Junta, DTSC y todos ustedes que tomen medidas inmediatas y decisivas contra Quemetco. Exigimos regulaciones más estrictas, mayor monitoreo y aplicación estricta de los estándares de seguridad ambiental. Y eso es porque les recuerdo a todos ustedes que están en la junta directiva, ustedes son funcionarios públicos. Decidieron tomar una decisión de estar en esa posición para servir al público, ¿verdad? Entonces, cuando está un interés corporativo y lo estás ayudando, no estás sirviendo a la comunidad pública, no estás haciendo tu rol como un miembro de la junta directiva. Entonces, por favor, te imploro que lo pienses de verdad lo que vas a hacer y les niegues este proceso para que Quemetco pueda continuar sus funciones. Muchas gracias.
Thank you so much. Can we ask that an interpreter?
Do we have the interpreters on to translate the comment and read and say it to the board members, please, and the public?
You are a public worker?
Okay, while we wait on that, we have several comments that have been emailed to the board. And so until I get a thumbs up from the interpreters, I'm going to go ahead and start with these comments in the interest of time. So we have a comment from Don C. Moss from Avocado Heights Community Advocate. Madam Chair and honorable members of the board, I am Don C. Moss, an independent community advocate for Avocado Heights and one of the few remaining members of the original Cleanup Quemetco Committee formed by Hacienda Heights Improvement Association in the 1970s. The work of that original committee can be credited with the current corporation's reputation as the cleanest lead recycler in the nation. That notwithstanding, there is more to do within the operation to bring its discharge into full compliance 24/7. Also of importance regarding my observation for the board is the fact that my property is dead center of the previously published discharge plume simulations. Those publications indicate that the estimated greatest volume of heavy metals was dropping out of the discharge plume at that point. I believe the regulatory agencies should work proactively with the corporations they oversee to achieve the goal of the cleanest, safest operations possible. To that end, an upgrade of line equipment which increases employee safety and decreases environmental discharges should be approved by the regulatory agency as rapidly as possible. Only when an actual increase in throughput is requested, or if equipment or operational change will result in increased environmental discharge, should the process be slowed down by appropriate deliberations. As such, I see the requested equipment upgrade as positive for all involved, line workers, surrounding community, and operational functionality. I recommend that the Board of Environmental Safety find the above noted appeal without merit and find that the immediate use of the system upgrades is appropriate and approved. Thank you for your careful consideration of this issue. So checking, Evelyn, do we have the interpreters to translate the last comment? They're not able to. Okay.
Right, yeah, they couldn't capture the entire comment. I guess in the Spanish line, there was a lot of echo. I'm working to try to get the comment to the translator, but in the meantime, we'll move forward with the rest of the hands on Zoom, if that's okay.
Perfect, great.
Okay, the next person in the Zoom is Sonia Holguin. Please accept the request to unmute. You have 2 minutes. Please state your name and affiliation.
Hi, my name is Sonia Holguin. I'm a La Puente resident, and I represent just the community. I've been a resident in La Puente since August of 2002. I have been battling with breast cancer for the last year. I cannot say that I'm a survivor because I'm still in treatment, and I have been told that I'm still not in remission. I have no family history of cancer. And so I'm asking you that you consider rejecting the extension until schools and surrounding areas have been tested. I thank you for listening to me, and I hope that no one else goes through what I'm going through. Thank you.
Thank you. The next person, we have Armando Nunez. Please accept the request to unmute. You have 2 minutes. Please state your name and affiliation.
Can you hear me? Hello? Can you
yes,
hear
we can hear you. Go ahead.
Thank you very much, board. I'm a member of the community. I'm just listening, and they're talking about how great this company is. And to myself, I'm saying, why did it get fined if it's that great? A little bit about myself. I've been a firefighter for 31 years, a fire inspector, and also a supervisor of inspectors. The first thing I did when I got on the department, I gave an oath. The oath was to save lives. Number one thing, save lives. Air quality, when I did this presentation to them too, I told them, do the right thing. Listen to who? The people in the community. They're the ones that live here. Does the owner live here? I don't know. But I could tell you, we live here. My wife, when she wakes up, she looks outside and she sees the emission going out from the company. We have grandkids. And I'm not only talking about my grandkids, I'm talking about all the grandkids and all the kids here in our community. One thing that I know for sure as an inspector, you have a big decision to make. Your decision is going to be about saving people's lives. Fire department, by the way, the fire department is responsible to give also the license for this company to continue. And where does it sit on? The fire marshal. The LA County Fire Marshal is responsible for that too. What has been done? They don't have a license, according to what I'm hearing. So with that, I leave the board with my main thing is safety of life. Thank you very much.
Thank you. That's time. The last hand that I see raised on Zoom is Philip Chandler. Please accept the request to unmute. You have 2 minutes. Please state your name and your affiliation.
It unmuted. Okay. Name is Phil Chandler. No particular affiliation. I'm former employee of DTSC. You have already stated a number of places, various DTSC folk and others, use batteries or has waste. The shredded material is going to be handled by this equipment. There's also a has waste, as cited. However, the separated lead contains adhered plastics and rubber casing. So your waste type, you actually admit this, or not admit it, it's unfair. Various casing materials that may include adhered metal. However, the hazardous waste code that you use, and this is used in your materials that are part of this TA, doesn't cite the plastic as having a hazardous waste code. So I think that might be an error, since you're worried about errors in the TA being the grounds for its the appeal being held up on it. But also I think that you need to get a handle. DTSC needs to get a handle, and it should come from Quemetco, the volume by weight, how much adhered plastic, adhered rubber goes directly into the furnace. Furnace, if there's enough going through there, the furnace is essentially acting as an incinerator. Now, Quemetco got its, well, when I issued the permit, when I did the permit in 2005, we gave Quemetco a pass on adhered plastics. However, at the same time, it turned out they were incinerating plastics and rubber as coking material. They had been given a permit by South Coast Air Quality Management District, who didn't seem to know what hazardous waste was. So that they were allowing, or they had allowed in their permit for Quemetco to incinerate battery casings, hazardous waste. I'd like to see that somehow gets taken care of this time around. Thank you very much for your time.
Thank you so much. That's time. I'm going to check for Q&A. Give me 1 second as I pull up the Q&A from Zoom. We got 2 more comments from the Q&A. I'm sorry. Well, let's go. Oh, there are 2 hands. I'm sorry. I see 1 hand from Zoom user. Zoom user.
Yes.
You have 2 minutes. Please state your name and affiliation.
My name is Ana Escalante, and I am a resident of Avocado Heights on 5th Avenue. And I am here to discuss the not to renew that or try to renew the Quemetco. I have my kids that attend Palm. I've been a resident here since 1985. We still own our house right there. And this has been an ongoing problem since then, since I was 3 years old. And it continues, and our kids are exposed to this. And now with the school closures moving us to Palm, you know, the testing is going to take a year to test the soil. And I'm asking you to not, the board to make the conscious decision to not let them go ahead and do this, because of the simple fact that these kids are getting exposed. My kids, I got 4 kids in the district at Palm School, which is less than 2 miles away. And, you know, we live here. Just like the gentleman said, we live here. Everybody that spoke for them are people that are affiliation, work with them, but they do not live here. They're not exposed on a daily, every day, weekends. You know, that is us, the residents that live here. Thank you.
Thank you so much. So I believe that concludes the portion for the Zoom participants. But before I close that out, I want to ask our interpreters if there are any Spanish participants on Zoom wishing to make a comment. Bear with me as I try to get that response. Okay, no Spanish comments on Zoom. So we will now move on to the emails that we've received online. And just for a quick time check, it is 6:06. The 90 minutes concludes at 6:15. Because a former commenter on Zoom did email us, we weren't able to translate. So this is the closest thing that we have to a translation to the former Spanish comment on Zoom. I'll read it now from Ricardo Martinez. He is an AD 56 delegate for the California Democratic Party. His email reads, "My name is Ricardo Martinez. I am here as a La Puente resident and an assembly delegate for the California Democratic Party. I am troubled by the actions of Quemetco, a lead acid battery smelting company operating without regard to previous violations they have done. We cannot simply ignore the devastating impact this company has on our environment and public health. Quemetco's reckless release of toxic substances, including hydrogen cyanide and carcinogens, poses an imminent threat to the well-being of our community. These pollutants have been linked to severe health problems, including respiratory issues, cancer, and neurological disorders. It is unacceptable that our families and children are subjected to such dangers. Furthermore, it is our right to live in a clean, safe, and healthy environment. Quemetco's actions not only jeopardize our health, but also our quality of life. Our community deserves better, and it is the duty of this board to protect our interests. I implore the DTSC board to take immediate and decisive action against Quemetco. We demand stricter regulations, increased monitoring, and stringent enforcement of environmental safety standards. It is time for Quemetco to be held accountable for its actions and to cease its reckless practices that endanger our lives and the environment. Our community deserves to breathe clean air, drink safe water, and live without the constant fear of exposure to harmful toxins. I therefore strongly urge the DTSC board to prioritize the health and well-being of its residents over corporate interests. Let's ensure that our community remains a safe and healthy place for everyone." Okay.
Okay. So I'm going to read the comments only from those participants who haven't participated in person. I know there's a number of folks that submitted comments, they emailed it to us, and then they also did in person. So the board has received all of those comments. Everything that's been emailed to the board will be posted on our website as well in the coming days. And so I will go ahead and read these next few comments. The next one is from Vivian Zamorona. Members of the Board of Environmental Safety, as you consider arguments in your appeal decision, it is incumbent upon your body to weigh right and wrong along a temporal continuum. For 8 years, Quemetco Ecobat has been allowed to operate on an expired permit. Since 2021, Clean Air Coalition has twice appealed a temporary authorization that DTSC approved to allow Quemetco Ecobat to install new equipment without any public review and without including this new equipment in the regular permit renewal process, which also required public review. By DTSC's own admission at a recent Quemetco informational public meeting on 11/8, Ecobat is not as bad as they used to be. However, in this admission, they acknowledge they have been accomplices to Quemetco's hazardous operations and the company's long game plan of increased operations. Incremental changes and temporary authorizations to the expired permit appear to be part of that plan. At the same meeting, DTSC wanted to hear new information from the public. Can you justifiably allow them to ignore the cumulative impacts and complaints of decades of contamination to EJ communities? Don't allow Ecobat to circumvent regulations and continue to deceive the public. Please don't simply defer to DTSC staff to take the correct action. You must hold DTSC and Ecobat accountable to a process that protects the health of people and the environment. We can't let DTSC, Quemetco, and Ecobat get away from this end run around the community, deny the temporary authorization. The next comment is from Sarah Brady. I'm requesting that you please put the community first by making sure we are always part of any decision made about Quemetco Ecobat. A temporary authorization serves a particular function within the structure of permit modifications to allow a rapid response so that activities necessary to respond promptly to changing conditions can be undertaken. Just as the appeal officer observed in January of 2022, this temporary authorization was not issued because of a need for a rapid response. Rather, this temporary authorization was issued in response to the desire to circumvent the clearly established permit modification and appeals process. CAC calls upon the BES to support rather than undermine transparent permitting decisions by directing permitting to deny Quemetco's June 2022 request for a temporary authorization to operate the waste equipment at issues here. Thank you. The next comment is from Daniel Talamantes, PhD, Claremont Colleges. Dear DTSC Board of Environmental Safety, I'm writing to express my deep concern and frustration regarding the ongoing violations and compliance issues at Quemetco Ecobat, as highlighted by the recent multi-agency inspections and enforcement actions. It is imperative that the DTSC prioritize the community's well-being by ensuring their active involvement in any decisions related to Quemetco Ecobat. The documented violations ranging from illegal storage to inadequate inspections and to failure to address issues such as hazardous waste sludge removal raises serious doubts about the facility's commitment to environmental safety. The community's distress is palpable, evident not only in public comment, but also in news articles that underscore the urgency of this matter. Adding to the problematic is the community's deep-seated distrust in temporary permits issued for equipment that fails to address the persistent lack of groundwater leak detection. Temporary permits, if not carefully scrutinized, may exacerbate existing issues and compromise public safety. The community rightfully questions the efficacy of such permits and demands a comprehensive and trustworthy approach to permit issuance. The compliant for civil penalties and injunctive relief case number 18STCV 03084, issued on 10/21/18, further emphasizes the severity of the violations. It is disconcerting to note that these violations persisted through multiple inspections from 2014 to 2018, reflecting a systematic problem that requires immediate attention. The inspection logs from 2022, which did not overflow and build up materials, and the ongoing issues observed of the containment building batch house as outlined in the SOV. Other issues concerns highlight the pressing need for decisive action. The community has voiced concerns about Quemetco chronic toxic contamination and failure of state agencies to shield them from such hazardous exposures. The delay in the permit renewal process since 2015 is unacceptable, especially considering the documented pollution and the associated risks of resident lives. The Clean Air Coalition advocacy of the denial of Quemetco's permit renewal underscores the significant resource disparity between the community and the company. The lack of transparency, accountability in the permitting decision is a glaring issue. The community demands a fair and thorough evaluation of Quemetco's operations. I implore the Board of Environmental Safety to prioritize the community's concern and take immediate and appropriate measures to address the compliance issues at Quemetco Ecobat, including the distrust in temporary permits. The health and well-being of the residents and the environment must be safeguarded through transparent and accountable decision-making process. Thank you for your attention on this critical matter. I have two more comments left. The next one is from Dale Stenberg. My name is Dale Stenberg, and I'm a resident of Hacienda Heights. I urge you to deny Quemetco's temporary authorization request. Quemetco is a dangerous polluter that continuously harms my community and must not be allowed to disregard public participation requirements. We have been in the community since 1965. 1965 Turnbull Canyon, 1970 Walbrook Drive, 1974 Beach Hill Avenue. I had endometrial cancer, hysterectomy. 2 young men, 2 doors down, suffered jaw cancer and died. My daughter had aggressive type brain cancer and died on 10/27/23 at the age of 53. A neighbor woman had cervical cancer and died 2 weeks ago. We do not believe Quemetco has been a good neighbor. We feel it should be closed. The next comment is from Marisol Sanchez. Hello, my name is Marisol. I am a member of Clean Air Coalition, a resident of La Puente. I urge you to deny Quemetco's temporary authorization request. Quemetco is a dangerous polluter that continuously harms my community and must not be allowed to disregard public participation requirements. I have a family member that lived within a mile of Quemetco for more than 27 years and mysteriously got very ill one day last year and had to be taken to the emergency room immediately. After being in the care of doctors, she was diagnosed with kidney disease and now has to go on dialysis center regularly. She's an elderly lady, but with a toxic polluter like Quemetco just around the corner, it makes sense that they gave her this illness rather than just falling ill because of old age. I want this story to emphasize that Quemetco should not be allowed to exist nearby homes, and DTSC needs to stop being lenient with them. A penalty fine and the continuation of Quemetco's operation is not justice and doesn't live up to DTSC standards of protecting communities from polluters. Quemetco is using the temporary authorization to disregard, skip, ignore the public participation process that would otherwise be provided through the normal permitting process. If DTSC really cared about the community input, it wouldn't allow this abuse of temporary authorization process. Use your authority to push DTSC to do better. Deny this temporary authorization request. All right, last one. My name is Andres. I'm a teacher and concerned parent. I've been a resident of Hacienda Heights my entire life, and I'm writing to tell all of you at the BES, not ask, nor urge to deny all and any permit Quemetco Ecobat applies for. They are the most dangerous polluter to exist here since Exide. Look it up. People in our community have died and filed lawsuits because of the specific DNA that is made with lead, arsenic, benzene that has been scientifically proven to come from Quemetco and Ecobat within a 2-mile radius. Not including the wind draft, which drags it to other cities. This spreads to my job, children's school, and now with school closures, my family is set up to live in a toxic waste dump. We've been advocating for over a decade to shut them down. It won't bring back the dead, but it will prevent more deaths from happening. Our voices have been ignored for too long. Listen to the community. No to any permit renewal. Andres.
Thank you. So that concludes this public comment period. It is 6:18. We're just a few minutes over, so I will now turn it back to Chair Rizzo.
Well, thank you. And thank you all for your active participation today. We certainly did hear a lot, and I'm glad that we read off the written comments as well. So everyone who wanted to comment, I believe, has had the opportunity to do that. It's now the section of the meeting where we will call back for closing final comments by Ecobat first, then DTSC, and then Clean Air Coalition represented by Earth Justice. So I'll welcome back Ecobat. Reminder that that will follow. We'll then have a Q&A. The board will start to deliberate, and if they have questions of each other, of any of you, then we will ask them at that point. And if there's anything you didn't get to when we cut you off before, now's your 10-minute chance. So
just press the button down for like 2 seconds.
Would it be possible to get my presentation put back up too? I don't know.
I don't care. What? Yeah, I mean, if you can get the presentation back up, that's fine. I don't know if we can, but why don't you get started because the clock's ticking.
Let's pulling it up.
Yeah.
Well, I'll get started while we're working on that. Is that better?
Yeah.
Okay, sorry. Obviously, lots of comments that we just received about this facility, covering a very broad range of topics, and I have 10 minutes to cover this, so I'm not even going to attempt to try to respond to most of the issues that were raised. Instead, I think it's really important, and Chair Rizzo, at the beginning of the public comment, you reminded the speakers, is let's stay focused on the issue at hand here, which is the dewatering project. And not just a general question of, is the dewatering project a good idea? Should it be approved? Should it not be approved? But it is a very specific question. Did DTSC make a clearly erroneous conclusion of factor law when it decided that the dewatering project was necessary to enjoy an environmental benefit project at this facility? And as we talked about previously and earlier, the answer there is a clear no. The job of this board is not to replace DTSC's judgment in making that determination. It is to ask the question was DTSC's judgment clearly erroneous? And we have heard nothing today that would change DTSC's conclusion. And again, I want to remind, we heard lots of concerns from members of the public about potential or alleged actual environmental impacts that this facility is causing to this community. This is a project that nobody disagrees will be a benefit to the environment and will help protect the environment. We heard a number of commenters talk about potential soil and groundwater impacts. Nobody is disputing the fact that the dewatering project is going to minimize significantly, and if not eliminate, the risk of soil and groundwater impacts from liquids being released from the containment building. So in a sense, the dewatering project is addressing some of the concerns that the community has raised today. And I don't think we should lose sight of that. And I want to just go back to where we ended, I think, in some of the Q&A with the potential timeline here, is granting this appeal is going to add at least another 12 months where we're going to continue to be storing this liquid on the floor of the containment building. We're going to continue to have, I personally, and the technical folks that I work with, think the risk is very low, but we're going to continue to have an increased risk of a release from the containment building that could impact soil and groundwater beneath the containment building. Operation of this equipment eliminates that risk. So we are increasing the risk of a release from the containment building for at least 12 months by not giving Ecobat temporary authorization to operate this equipment. And another theme that we heard through the comments from the community, again, is the concerns, and I heard same concerns from a number of members of the board about public engagement. And this was one of the things I got cut off on earlier because I talked too much on early topics in my presentation. But I wanted to come back to that because this is not a case where we just submitted a temporary authorization request and tried to sneak this in without having any public engagement. At this point in time, we have gone through an initial temporary authorization that had an appeal. We then had a full Class 2 permitting process that had a public comment period in response to those public comments, and then another appeal. We then had this temporary authorization that is going through this appeal, and we've seen extensive public engagement here. And then we've also had a second Class 2 permit modification request that had a public comment period DTSC is preparing responses to those comments and has now been transferred over to a Class 3 permit mod, which requires yet another public comment period. So in total, we've had 4 public notices go out to the public about this permitting change. We've had 2 60-day public comment periods, 3 public comments letters received from the appellant here, CAC, 2 public meetings. True, being held by Ecobat. That is the regulatory requirement. These are public meetings that get held by Ecobat. In fact, in the last public meeting, Ecobat actually went out and I helped prepare responses, some to directly to CAC members and Ms. Johnson, addressing questions that were raised at that meeting and attempting to engage. And I offered to have additional discussions with them if they had questions the last time around. Again, I got no response to that additional outreach. And then we've had 3 CAC appeals of each of those permitting approvals with over 70 pages of briefing. So this is not, we're not in a situation here where there has been a lack of public opportunity for public input and public engagement here. It is candidly, other than a full permit renewal, I cannot think of a single instance where I have done a permitting modification or permitting action where I've seen anything close to the level of public engagement we have here. And this is for 2 pieces of equipment that are a significant environmental improvement for this facility. And so with that, I will, well, I guess before I go there, we also had reached out when we were in our period of time where we couldn't process appeals because the board was creating rules, and had offered to the board is, let's get everybody together. Let's have CAC sit down, other members of the community, the board, DTSC, and try to figure out a solution. We had the president of Ecobat, Craig Clark, sent a letter, I think it was to Chair Rizzo, but it included all of the stakeholders that had been involved in this dewatering project. And Chair Rizzo, you responded, but other than that, we got no responses from anybody. So we have been trying to go above and beyond and to engage with members of the public and to understand how we can, I mean, I think this is a great project. Everybody that I know that I talk about with this project thinks it's a great project. It's going to benefit the environment. DTSC has now found that 3 times. I think this is something that everybody should be supporting, and I'm eager for additional engagement in order to try to get people to that position and that conclusion. And so I'll just conclude again, reminding everybody, this is a narrow issue that the board is being asked to decide here. It is whether DTSC's conclusions was clearly erroneous. We have heard nothing from the presentation from CAC or in the briefs that were submitted by CAC that rise to the level of supporting a finding that their decision was clearly erroneous. Instead, we ask that you deny the appeal. It would allow Ecobat to operate this equipment for a period of 180 days. And don't forget that we have pending permitting actions undergoing. We have this Class 3 process that may move forward. We also have the permit renewal. Both of those permitting processes include requests to operate the dewatering equipment. So there will be additional opportunity for public engagement on this equipment before Ecobat is granted permanent authorization to operate this equipment. Thank you very much.
Thank you, Matt. DTSC.
Thank you again for an opportunity to provide some concluding remarks on behalf of DTSC permitting. Similar to a few of the points that Ecobat was making, overall, the issue at hand is about the temporary authorization that the appeal was brought for by Clean Air Coalition. And what we really need to look at is, was DTSC's decision clearly erroneous? And as I said before, clearly erroneous essentially means, did we make a mistake? And if you can't find that there was a clear affirmative way that DTSC made an error in their decision, then the standard of review guides us towards denying this appeal. And another important factor to just keep in mind is that this assessment should be looking at the facts that existed at the time that DTSC made its decision back in July of 2022. And there are a lot of additional external issues that have been raised about Ecobat and about DTSC, but they are not specifically about the temporary authorization that we're here to discuss today. And that's the key piece that we need to be focused on. DTSC's decision was reasonable. It was supported by facts, and it was not clearly erroneous. And there was no mistake made. It was done to resolve potential environmental risks. There's been a lot of dialogue about that. We're doing what we can to make sure in a sooner approach to address those risks. And a temporary authorization doesn't require an emergency. The example given earlier today about a fire, well, that is not it's true that you could use a temporary authorization, then it's not required that it's an emergency like a fire. That is the only circumstance where a temporary authorization is a valid response and that a rapid response is required. That's just an important piece to keep in mind, and that ultimately DTSC is in charge of determining that a temporary authorization is necessary, and a temporary authorization comes before another permit decision, and that decision could be a modification or a decision about a renewal for a permit. And so a temporary authorization just doesn't exist by itself, and that's the process. So overall, Clean Air Coalition, the appellant, has not met its burden to show that DTSC's decision was clearly erroneous, either in a finding of fact or a conclusion of law. It has not shown that DTSC has made a mistake. So based on the applicable laws and facts, DTSC respectfully asks that the board denies this appeal, and that is our concluding position. So thank you so much for your time.
Thank you. And just restate your name for the record.
Leah White.
Right. Thank you. Thank you, Leah. Okay, now Angela Johnson.
So I've got 10 minutes to wrap up after a long day with a lot of testimony and a lot of conversation. And I've got a full table here of notes and stickies and comments. I've got messages coming from Adam. There's a lot that can and probably should be said. But alas, we do not have the time. So I'll just take us back to the beginning of our time here together. And when I started my comments this afternoon, we pointed out that our client sent us here to demand integrity in the permit modification process. And central to integrity is ensuring that no other community is required to go through this process in order to address permitting's unlawful and erroneous interpretation of the temporary authorization modification requirements. Please do not lose sight of this fact as you deliberate this evening. Permitting in Quemetco would have you ignore the purpose that's clearly stated and that makes sense in the context of this regulation for the proper and appropriate use of a temporary authorization. They've spent a lot of time talking about how important this project is. They've even repeatedly argued that our client isn't denying any of that, which is just factually untrue. But regardless of their claim, the reality is that it requires more than the assertion that your project is significant and important to rely on the temporary authorization process. And that is nothing that's been said here changes or should obscure that reality. It's clear, as a matter of fact, that DTSC made a permitting decision on this exact equipment. And nothing that has been said here today has changed that fact. And DTSC's assertion in its approval that they couldn't make a decision before issuing this temporary authorization is just wrong. It is clearly erroneous. And the reality is that we've been here since 2021 having a conversation about this permitting request. And you know, back in February 2021, Quemetco should have submitted a Class 3 permit modification request. They'll argue, at least give me a Class 2, but it should be a Class 3 permit modification request. That's where we've ended up. And if they had submitted that request back in February 2021, we'd have been through all of this. When permitting had an opportunity to make a decision about that permitting request back in April 2021, they should have told Quemetco to go through the process. So they can't sit here now and insist that it's our appeals that is the impediment that they should get around. It's improper, and it strips not only DTSC of its credibility, but it also results in people turning up to report to you about what's been happening at this facility with DTSC for years has frustrated them, has injured them, and has resulted in them coming to the Hacienda Heights Community Center at 6:30 on November the 29th to, some people may say, rant. Some people may say insist. Some people may say with focused determination to hold this agency to account and to not allow it to shift to the community the harm that's caused by their choices. So we still urge this board to use its ability to read, to understand, to hear, to analyze, to look at the information that's in the record, verbally unaugmented by information that was added today, but look at the information that's before you. Look at the requirements, look at the facts, and make a determination based on your role as a board that was conceived of as a place to facilitate DTSC's transition to being the agency that it in fact wants to be. The agency that is careful, that is deliberate, that follows its regulations and respects the communities that host the facilities that it regulates. Thank you.
Thank you, Angela, and thank you to all three of the parties. Doesn't feel much like a party, but I think all three parties have now had that opportunity. We are going to have a 30-minute opportunity, and I am going to pass the mic to Swathi. I can keep it here. You have another? Okay. The goal here now is to see what questions board members have and to direct them to any of the people at the three party tables and or to each other as we deliberate. Then we'll take a little bit of a break because it's always good to have coffee before you vote or something when it gets this late. So we will return, reestablish a quorum, and then continue our deliberation. But right now it's time for questions from our
I just
staff.
wanted to reiterate that the board members will ask questions either directly of staff and or of the parties, but this isn't an opportunity for everybody to respond to that question. It's the specific person or party that the question is directed to from the board members. So I ask the board to be as specific as possible when you're directing your questions, please.
Alexis? No. I think so. Oh, that end of the table's ready to go. Okay. Liz.
I have a question for Angela. Throughout the presentations, I saw you make expressions of disbelief, and I was particularly interested in whether you can clarify something that is written within your appeal regarding the installation of the equipment. I'm still unclear about why it was installed. How was the first appeal? When was what's the timing like that there wasn't some sort of stay for the equipment to not have been installed? I'm really confused about that.
This might be a question that I can only partially answer. It's our understanding, based on comments made by permitting and by Quemetco, that they installed the equipment sometime after they granted, after permitting allowed the temporary authorization, but before we appealed it. I think that their argument is that a temporary authorization goes into effect immediately. And so they, quick like a bunny, rushed out and installed the thing, even though we have 30 days to file an appeal, which is what we did. So I believe that that is what happened, but there may be those who have clearer insight into that question. I'll also just note quickly that when Quemetco did its application, it talked about anticipating a pause for some other work that needed to happen there. And the permit appeals officer notes this in his determination. They talked about some pause that was coming up, and there was a question about whether or not they'd be able to install this equipment during that pause. But I don't know exactly when the equipment was installed. It's just clearly there now.
And was that contested, the installation of the equipment, irregardless of the ability to file an appeal?
I think your question is, then in April of 2021, did CAC challenge the installation of the equipment? We did not know that the installation of the equipment was going to occur. I mean, if they had, I mean, gosh, all this time we would have raised that. So we didn't know that that was going to happen. So we didn't have the ability to raise that.
Got it. Thank you.
I have a question for Greg. Based on the administrative record,
Greg is our staff attorney, yes, for those of you who weren't here earlier, and he's being asked a question.
So based on the administrative record and what we heard today, we know that the Title 22 has a specific provision or subpart that allows DTSC to consider temporary authorizations for health and environmental protection reasons. We also heard that DTSC asserting that they have the expertise to determine when to use this subpart or provision. But it's unclear to me that the use of the temporary authorization is clearly erroneous unless we establish that it is necessary to consider the dewatering unit as a separate issue from the broader permit modification issue at hand. So my question for you, if you can just share with us, what are the legal elements that DTSC is required to satisfy in issuing the temporary authorization?
Thank you, board member. I'm happy to do that. And if Gabrielle, if you could help me out, I actually have my own little slide deck that I'm going to refer to. And so slide number 3, if Gabriella could help us out and put that up there. What this slide does is it summarizes the elements that are required for DTSC to issue a temporary authorization. And so the first bullet says the DTSC may grant without prior public notice and comment a temporary authorization for a period of 180 days. The decision to grant or deny shall be made as quickly as practical. And then as far as the elements that have to be satisfied, that's the third bullet here. So A, B, and C are 3 elements that are required to be met. The first is that the activities meet the standards of Chapter 14. The second, that the request is exempt from or meets the elements of CEQA. Neither of those have been disputed in this appeal. Really, this appeal focuses on the third element. And that one is one of necessity. So the temporary authorization has to be found to be necessary to achieve one of 5 listed objectives. And key terminology here is timing. So that necessity is necessary before action is likely to be taken on a modification request. So in asking the question, as you just did, you noted that this dewatering project has been decoupled from the permit renewal. And so how is it that DTSC can issue this ahead of the permit renewal? And this element really speaks to that. Gabrielle, if you could just advance one more for me.
Greg, will you just say what Chapter 14 is for people?
Chapter 14 is just the standards that apply to hazardous waste management, I think, paraphrase. And so in the hearing today, we heard from lawyers on different sides about how this is interpreted. And there was comparisons to federal law and state law. And I put this together just to show that the federal regulation contains exactly the same language on this specific point. It's verbatim the same. And so both the federal and the state rule says that this timing element has to be satisfied. And so the question really presented, one of the main questions here is, what level is required to satisfy that? Is it to the level of an emergency? Is it merely sort of urgency? Is it some kind of an exigency, or is it a lower standard than that? And clearly there has to be some showing that this can't wait. And what we heard is that the waiting is certainly months, possibly years. And so what is it about this that can't wait? And that's the determination that has to be made. And so the focus needs to be on what the findings were that established that there was this exigency or urgency or timing that necessitated issuing this ahead of a longer process.
Did that answer your question? Thank you. Keep going. You're on a roll.
Okay. So we heard today that the Quemetco facility has a containment building where the dewatering unit is going to be installed. That containment building has already been permitted for holding these aqueous standing liquids. We heard that. We also heard then that because there's standing liquids, hazardous waste, potentially hazardous waste, there is an urgency to remove the aqueous liquids from the floor. So I'm basically questioning from the administrative record and what you heard today, have we established then that the temporary authorization is required as a rapid response mechanism? Like, what has changed?
Well, possibly, again, I could get some help from my handy slide deck here. If you could advance one more slide for me, Gabrielle. So actually, let's advance to number 8. Number 8 is the decision of the permit appeals officer in the initial appeal that considered this and looked at the factual circumstances at that time when the temporary authorization was issued in 2021. And he concluded that because the facility had been in this condition where there were liquids on the floor of this containment building since at least 2001, he felt that Quemetco had not explained why a temporary authorization is necessary. He said, well, this condition's been there a while. It doesn't seem like it's a new thing. So why now? I'm paraphrasing. And he found that that was clearly erroneous, and that was the basis for his decision. And so in response to this, then DTSC made specific findings when it approved this request the second time. And those findings weren't there the first time that that decision was made. So Gabriela, could we back up to number 5, please? What I've done is broken that out so that we can just look through it carefully, because there's essentially 3 things that DTSC said. So the first one was that the temporary authorization is necessary before actions taken on a modification because there were environmental improvements that were authorized, and that allows DTSC to continue its mission. And so we've heard more about that today, that there's environmental benefits to these, and that's consistent with DTSC's approach as a regulator. So that was essentially the first justification. If you can give me the next slide. The next one was based on this new technology being available, that new technologies are available from time to time, and that DTSC is responsive to those new technologies by allowing temporary authorizations, and that's a pathway forward. The third justification was that the addition of these would allow Quemetco to more safely manage its waste, and that it would not suffer the delays associated with the permit modification. I think we heard a lot of emphasis on that today as well. So I see in there 3 basic justifications for it.
Thank you. So to recap those 3 justifications, one is environmental protection, second was new technology availability, and the third is time. So based on what I heard today on the administrative record, I did not walk away with a clear timeline view that says that a new technology became available in 2021 or 2022, right before the temporary authorization. And I tried to get to the question of when was the unit installed in a facility perhaps outside of California, or when did the technology become available? So I'm just asking you, Greg, based on your read of the administrative record, did you see any timeline that can provide evidence to the fact that the new technology became available to Quemetco or was made available as an option to DTSC?
I'd love to give you an answer to that, but I'm just a lawyer, and I think you're going to need to hear from our engineer about that.
Let's go to Linda then.
There are no documents in the administrative record that state or show or demonstrate that this equipment was available at any point besides in the request.
You have more, Sushma? With that? Alexis? No. I'm not sure who my question's for. You can help me direct it. I'm still trying to figure out why we're on temporary authorization when we're either, and maybe you all can answer that at DTSC for me, where you've got a facility that's had challenges, right? I'll just put it broadly. And you've got settlement agreements that call for fixing the floor and getting rid of all the mess. That's been trudging along for quite a long time. Then, so instead of a permit renewal or permit mod that would allow for this to be executed, we have a period of time that goes by and then suddenly it's urgent. So I'm trying to understand the urgency for the temporary authorization outside of a permitting process that allows for a more fulsome exploration of all of this by the public, right? By the communities impacted, that they understand why is this good for me? I mean, we're hearing things that go much more broadly that I know that's not our purview. We are here only on the temporary authorization. I hate to have to repeat that. We may be back talking about a permit or a permit mod, but right now we have to focus solely on the temporary authorization. What made that so urgent that an alternative full on mod 2 or mod 3 wouldn't be advanced to where we'd have a more fulsome process? That's the part that I'm stuck on. And I will ask DTSC and Quemetco I will ask. Right now I'm directing it at DTSC. I know.
Let's do one at a time.
That's why she took control of the mic, because I really want to hear from everybody, but you can help me with that. But
let's start with DTSC to answer that question.
Thank you for that question. The criteria does not require the scenario to have urgency. The criteria only requires that it is more timely than an action that could be taken on a permit decision. So in our case, you know, we've talked a lot about the temporary authorization and the permit modifications. A temporary authorization does not modify the permit. Permit modifications are a separate category, and that's why it takes so much longer, because there's other criteria. So the answer is that the criteria doesn't require urgency. It's just that to use a temporary authorization, we have to find that we could act on it quicker than we would if they had filed a permit modification request. And that was accurate. That was true at the time we made the decision. Because here we are today, we're ready to make a decision now. That's why we've prioritized the permit decision in lieu of the permit modification.
I understand. Okay. I would like to hear from, go ahead, Georgette. Or did you not feel?
Hello, can you hear me?
Yeah.
Hello. Okay, there you go. So, Dwayne, can you go back? Because I really want to ask this question following the same.
Sure.
Does it? So you make mention that it doesn't require an emergency, right?
Right.
Does it preclude DTSC from defining how you make a decision on granting a temporary authorization as an emergency or not?
No.
So you could. You just chose not to.
Do you mean, are you asking if we could have granted approval for an authorization
if you
for
can
an emergency?
Justify it by defining. So it just feels like temporary authorization is a little bit, it really is based on the interpretation and how you implement it as DTSC.
Yes, it is.
So
discretion is.
It's the discretion of DTSC. So what precludes DTSC from defining this authorization as an emergency?
I don't fully understand your question, but I'll give it a shot. We never thought of this as an emergency. We thought of this as an opportunity to give a quicker authorization for an environmentally beneficial operation. So adding the equipment is environmentally beneficial. And so it gives us a quicker authorization route to do that, as opposed to waiting, you know, we're going to do a public, we're going to evaluate through the regulations. It's a much longer process. We take their request, we pair it up with all of the criteria in Title 22, and we go through that analysis. And then we end up with a decision that we go out with a draft decision with, we get public comments on. We do this as well for some things like even permit modifications don't have public comment periods, for example. If a facility wants to change their emergency coordinator. Most people aren't going to have an issue with that. You know, it's a name and a telephone number. And so the regulations are very clear about a shorter process for those types of authorizations.
Okay, thank you.
Okay, I think that answers that. Can I just follow on to you with one more? So given you've heard today, but you've heard before today, the concerns from community around this facility, right? Given that level of concern, to not put them through a full-on modification or permit process, help me understand, as long as you're going to expedite the permit, a temporary permit coming up or a permit draft coming up, I still don't get why you wouldn't have gone in that direction rather than the temporary authorization. I remain stuck there. Mm-hmm. And if somebody could unstick it, that would be helpful.
Well, at that time, so we're talking about at that time, we were not ready with the permit decision, but now we are. We're ready to go out with a permit decision in winter that is very close. So we're prepared to do that and to address all of these concerns, listened very carefully to the public's concerns, and we've heard it, you know, over and over again. Fundamental problem is that batch house floor. There's so many issues with Quemetco that need to be resolved with a full permit decision, and we're ready with that now. We weren't ready with that back then. That gave us an opportunity to give authorization for environmentally beneficial additions to their operations in the interim. If that, I hope
and
that's responsive.
That's the same argument for the first temporary authorization before you had a full permit.
Yes.
In process. So that's where I'm just, I can't transition from it got issued once without the benefit of a full permit. Now it's being offered again, and you do have a full permit in process. So that's a plus.
Yeah, right. I mean, yeah, it's not our intention to continue this. It's our intention to address this with the new permit decision and not with this authorization. All of the perspectives that we're offering today are about the decision that we made at the time back in 2022.
We all really appreciate the fact that you've come to be with us for hours to discuss this incredibly important matter that we're going to decide tonight. You've been respectful of the times that have been allotted in both making your comments. There's one matter at the moment where we have somebody making rude gestures on the camera, and I would ask if people could be respectful and civil in this democratic society and let us continue with our hearing so that we can reach a very important decision this evening. If we cannot achieve that, our alternative is to not have the camera and simply the audio. That wouldn't be good for everyone who's taken the time to participate. So we have purposefully wanted this to be as transparent and participative as possible. It's very significant for us. This is our first permit appeal hearing, and it will help us shape how we go do this for years to come. So if you could please help us make this a civil and respectful gathering, we will very soon be completing our deliberations and making a decision. Thank you.
Thank you. Thank you. Okay. I'd like to hear from each of the other two on that same question. If you're willing to comment.
And so we'll have Ecobat first, and then we'll have Earth Justice after.
Enough time has passed. I want to make sure the question is still your question, Rizzo, is this timing and sequencing question, but can you rephrase it again for me? Because we talked about a number of topics, and then Member Gomez had a question, so I just want to make sure I'm answering the.
You're asking a lot now, Matt.
Sorry.
Okay. I'm really trying to understand, given the broad scope of issues that will be being dealt with in the permit.
Yes.
In the permit renewal, and the historical issues that have brought out so many people expressing concern. Why would we have a process, a temporary authorization, when you know there's a permit, a mod 3 or a full permit right around the corner, a draft permit that will be coming out, in which this could be more fully explored in public context, outside of a board meeting? I mean, the board hearing is the place where we're hearing all this, right? So why would we go forward with a temporary authorization now and not have it be incorporated into the main permit? And I know you said time, but if it's not urgent, I'm not hearing the urgency, right? Where it's not urgent, it might be important, and it's not like it's not a good thing to have happen, but in the broader context, it just, it isolates one piece of the issue. One could make the case that if the temporary authorization goes through, the case is made, it'll take forever to get the full permit done, as opposed to that's part of the full permit. I know you want to get that done. So everybody is trying to understand why this is so important now.
Yeah, so I'll back up quickly too. I mean, the premise of your question, though, is sort of ignoring the fact that EPA and then adopted by DTSC have regulations that allow for temporary authorizations that don't require urgency, as Wayne was just getting to. So I don't want us to get caught up on this urgency issue, but I will allow myself to get caught up in the urgency issue a little bit. You know, we were talking earlier, I can't remember which board member asked the question about the installation of the equipment, but the equipment was installed immediately upon getting approval because there was a real urgency to address the concerns that were coming out of the community about the liquids on the batch house floor. Again, this was enforcement that began in 2016, and we went through years of discussions with DTSC about how we were going to address this. And this was a work in progress. And then the dewatering equipment came up, and I was personally involved in it. It was an aha moment of, oh my gosh, this totally addresses part of the concern with the containment building floor. We'll remove the liquids from the floor. This is great. Unfortunately, then the client says, let's install it tomorrow. And I had to be the lawyer and say, time out. This is treatment. We need to go through a permitting process for this. But we worked with DTSC permitting, and they were very, very receptive. And we were looking for ways to make this happen as quickly as possible. Again, because this was a enforcement issue that had been outstanding for years, that had a lot of public attention to it. And both parties wanted to address it as quickly as possible. So there was, in fact, urgency. Again, there doesn't need to be urgency, but there was urgency in this case.
I understand your perspective. Thank you for that.
I have a question, clarification question.
Yes.
Okay, so you're saying that there was a lot of public concern, and that's why there was this urgency, right? And we've seen the slides that during the temporary authorization process, rather than the mod 2 or the full permit process, the public participation is different. So if there is this concern from the public, why not go over and involve them in that process, even though that requirement isn't there? If the request is truly coming from the public, why not involve them through that process?
So to clarify, though, the public concern was being voiced prior to the submission of the temporary authorization. The temporary authorization was purely a reaction to that. And we maybe were naive when we submitted it, but we thought, DTSC, in my discussions with them, thought the same thing, is, man, this is a great solution. Everybody's going to love this. So we didn't come into this really until, at least from Ecobat's perspective, there was an appeal that was filed after the approval. We had no visibility that this was a project that was going to be controversial. We thought this was a great outcome. It was a significant environmental improvement project. There's not going to be opposition to this. So it surprised us when we got the appeal that was filed after the fact. So It's a fair question, but it just didn't,
Okay.
we didn't anticipate the level of opposition that we're seeing.
Okay.
And that was the first appeal. So what about the second?
Well, that was a
refiling of the
class 2
temporary
permit
jurisdiction?
mod process that had the
Okay.
public participation process.
Thank you.
Thanks.
Thank you.
Do you have a response to that? Okay, well, I asked all three of them to respond to that, so.
I guess I'm in the major leagues now. Three points. First, we didn't say that it needed to be an emergency. We didn't say that the regulation requires an emergency. There's a whole set of regulations that deal with emergencies. That's not this. What we said is they need to have an explanation. There needs to be a thing that's more than just, if we don't do any public participation, we can get the decision done more quickly. It just, that's not what the regulation is or does. Second, the permit, the temporary authorization process is a subsection of 66-270.42. It is permittee, it is permits at the request of a permittee, for permit modifications at the request of a permittee. It's not something that stands outside of requests for modification. So let me calm myself down and refocus and say this one more time. The regulation says that the temporary authorization is necessary to achieve one of the following objectives before action is likely to be taken on a modification request, not a full permit renewal, not some other kind of thing that needs to happen, but it's in the context of a modification request. And now what I hear is we're drifting into this world where we're going to use this temporary authorization while we're getting ourselves together to issue the full permit renewal. It's just an improper use of this tool. Third, what EPA was trying to do was they were trying to strike a balance. They were acknowledging that public participation is critical. And they were also acknowledging sometimes things happen that you have to respond to quickly. And so sometimes you have to weigh those things. It does require it to just be, it requires it to be more than just we could go faster. And if Quemetco and permitting were talking about this amongst themselves, and if they wondered what the community thought, they could have done a notification of a class 2 permit modification. And maybe everybody would have showed up here and be like, this is awesome. Let's get it done. But that's not what happened. And so they purport being surprised, but they did not need to be surprised. And I'll make one last sub point to that. When they posted in 2021 that they were doing this, even though there's not a public comment period associated with it, Byron Chan wrote to DTSC to say, don't do this. What's happening? So it didn't come entirely out of the blue.
Thank you for that. Fishman, you're trying. Oh, okay.
I have a question of Wayne, or for Wayne. So just to recap where we are, as you're walking up, I've heard that there is no renewed sense of urgency. aside from continuing to address the corrective actions that came out of 2016. We've also heard that based on the administrative record and what we heard today, it's not necessary to treat the dewatering unit separately. So putting those two things together, then we are making a call that bypassing community engagement, the benefit of bypassing community engagement outweighs the risks of potentially driving a different outcome through the full community engagement process. So my first question is that the argument? Does DTSC believe that in this particular case, the temporary authorization mechanism, the benefits of using it outweigh the risks? That's my first question.
So I would say at that time in 2022, we made that determination. We're not asking you to consider giving them any kind of authorization today. That's not what we're asking. We're asking that you look at the decision that we made in 2022 and determine whether that was appropriate or not.
Right. And this brings a broader question for me, which is, what is the purpose of community engagement through the permit process? If you can speak a little bit to why do you think community engagement is necessary?
Yes, absolutely. It is necessary. And that's why we're gearing up for the draft permit decision. So, and that's where we're going to have, you know, all of the comments that we heard today. Most of the comments that we got today were things that we want to hear in the permit decision. Many of them were not applicable to the temporary authorization request that was given to us in 2022. But those are the things that we want to hear when we move forward with a draft permit decision in winter. Those are very important to us. We value public input from everyone, and we don't shy away from it. So our own regulations require us to go through a process where we consider it and we take the time to respond to all of the comments that were given to us. So, I mean, I'm not saying that we don't want comments about the dewatering equipment. The dewatering equipment may be the subject of the draft permit renewal because it is actually in the permit application. So moving forward, if we make a draft permit decision, it will include the proposal to operate that equipment.
Okay. So my mental model now is, one, there's no renewed urgency. Two, we value community engagement. And in fact, DTSC uses that as it designs the permit application, not application, but response or decision. And then we've also established then that it's not necessary to treat the dewatering unit separately. So
can you expound on separating the dewatering equipment?
The question of why the dewatering unit is being treated separate from the broader permit application.
Oh, okay.
But
yeah,
I do have a follow-on question, which is, when I recognize that it's the permit holder's decision to use the mechanism, right? I'm assuming in this case, Quemetco came to you with a temporary authorization request. They may have chosen to come to you with a permit modification request. Help us understand, when a permit holder is making a decision, do they typically reach out to DTSC and ask for guidance and say, here's our situation, what venue would you like us to pursue? And what does that collaboration look like?
It depends on the operator. I mean, some are more knowledgeable about regulations and available processes than others. And I don't know what happened at that time. I don't know if we gave them guidance or not, but as far as the separation of the dewatering equipment from the rest of the permit stuff, we don't think that we need to separate that now. Our position right now is that let us make a decision on that with the draft permit decision. It's more appropriate now for us to throw that into the draft permit decision. But at the time in 2022, we were in a different state. We weren't ready with the permit decision. And so it made sense for us to issue that approval back then.
Thank you. So while we have you, one other question. In the administrative record, there was some reference to how the unit was perhaps expedited to coincide with the planned shutdown that Quemetco had. Can you just address this and tell us, was the unit approval, was the unit installed during the shutdown? If yes, was the temporary authorization rushed in some way to allow that to happen? And was this somehow the basis for why a full community engagement wasn't considered?
Well, I can most definitely say that it wasn't rushed to coincide with the planned shutdown, for sure. I mean, usually the case with us is that we're delayed more than we think that we are going to be at the time. So it's usually we're falling behind. But I do remember that planned shutdown. It was an opportunity. There was a discussion about using that opportunity to perhaps install the equipment at the same time, but it wasn't coincided with our approval at all.
Thank you. Georgette?
All right, this is to DTSC once again, and this will be the last that I can try to ask and see if I can get a different response or shed a little bit of light. You keep mentioning we're ready now to go through the proper process, but in 2022 we weren't, which is why we approved the temporary authority. I'm still not understanding the why in 2022, aside from you weren't ready for the full process.
Okay.
Can you speak more to that?
Yeah, and I'm sorry.
And I understand the health and safety aspect of it. I think what I'm hearing, we could have accomplished that with the proper process. So hopefully we can insert more, because I'm not hearing it.
Okay, and I'm sorry, that's my fault. I know you keep asking the same question, and
Thank you. I'm sorry, I'm asking
All right, wait a minute.
DTSC, so thank you so much.
Just going to ask for order. This is a hearing. I know everybody has thoughts and feelings, but let's focus on the questions and the answers. We had ample opportunity for public comment. Thank you.
So as far as regret, we're not regretting that decision now. We thought it was very appropriate to do that.
I didn't say regret. I'm trying to understand the rationale that DTSC made in 2022 beyond the health and safety, beyond what you have stated so far. If you can elaborate, because if that's all there is, you can just say that's all there is.
That is.
Okay.
Yeah, it's
Thank you then.
safety.
Thank you.
Yeah.
Alexis. Thank you.
I just wanted to make an observation about how in a facility like this one that in recent years is much more prominent, and there will be others throughout the state that fit this category as well. It's so difficult now that the board has a role in hearing permit appeals that had heretofore been with DTSC. Given the timing that we have, it's so hard to make the process work as good government for a temporary authorization, because temporary authorizations, as everyone has heard, are meant to be something that is quite nimble and affects a good outcome. And in this case, we are running headlong into something that has occurred in recent years and is coming up against a permit renewal, or a permit decision, I should say. And here we are trying to decide something from over a year ago. So I hope that what's at stake here is understandable, but what I'm getting at in a long-winded way is that I think that going forward, using temporary authorizations even more judiciously where it is a facility with quite some community engagement is an important consideration at the front end, because we don't want the board to be at the back end of an appeal and making everything go much more slower than was originally intended. We don't have a good feel on how many temporary authorizations generally get used in a given year or issued in a given year. And Wayne had said very few. So I think it's just something for all of us as we try and wrap our hands around how hazardous waste is managed in the state, how the 72 to 74 facilities may or may not at times need a temporary authorization. This is an example of how the good intention of the regs runs up against a newly created board and a process that has dragged it out. And so I appreciate your indulgence in this regardless of the decision that comes out. But my main message is let's try hardly ever to use them where where it seems that there is a community that's engaged and wants more about the process that can be delivered in a class 2 or 3 permit mod or a full-on permit renewal decision. But that's not a question. It's more just an observation as we've all struggled with this.
No, thank you for that. Any other board questions of each other or of our staff? Linda and Greg in particular, do you have anything you want to add to our thinking before we do a 10-minute mental break and finish our 15 minutes and finish our deliberations? I think no other questions for people? No, okay. No questions from the board for each other or for our staff? Do you have something, Evelyn? Because we're going to take a break now.
Right, thank you. I just wanted to take note of the time. It is now 7:25. Would you like to call for a 10 or 15-minute break? We have some wiggle room with time.
Are we fine with the facility because we're running over?
Yes.
Can we stay here all night? Okay, good.
No.
Okay, we'll take 15 minutes and then we'll come back and continue our deliberations and take a vote. Thank you.
Thank you. The board will be back in a brisk 15 minutes. Thank you. Okay, it is now 7:44. Madam Chair, we maintain quorum by having all members present.
Thank you. Okay, are there any further discussions that board members want to have with each other or with our staff? You're all witnesses to us now. We're not engaging. We're just discussing amongst ourselves. Any other questions, comments?
I guess I can start. I'm not ready to make a motion, but I have
You should make your comments.
Oh, I'll do that then.
Recording in progress.
Okay, I think Lizette has offered to.
No, I have. I'll
No.
I'll wait.
Oh, you'll wait and make your comments
Yes.
when you vote. Okay. Sushma.
It's just Q&A.
I know, but Q&A, there's no Q's and A's.
No.
Pardon.
Okay.
Swati?
Well, there isn't.
For the record, can you repeat that you've reached quorum? I was not recording at the time.
Okay, thank you. So at 7:44, the board returned from break. And we maintain quorum by having all members present. Again, by acknowledging, I'm sorry, you're acknowledging that the meeting you're being recorded by continuing to participate. Thank you.
Thank you. Okay, I understand, Sushma, you are prepared to introduce a motion.
I think before I introduce the motion, if I may just recap where we are, and also thank everyone that's showed up today, all of the community groups, DTSC, Ecobat. I've certainly learned a lot, and I'm sure I speak for the rest of the board that we've all learned a lot and appreciate the complexities of the permitting process and every stakeholder that has to engage in the permitting process, both as community and as permit holders. Clearly, there's a lot more we can all do together to improve upon this process. We've also learned a lot about Quemetco, Ecobat, and how you are continuing to make improvements and how you are committed to environmental and health protection and continuing to operate in the state of California. Today, we are debating something very narrow, which is the appeal made by Clean Air Coalition about the process and the mechanism used to make sure that the process and mechanism of the temporary authorization is legitimate, is health protective, and is also not inadvertently pitting human public health against community engagement. Because that would create sort of circular reference in that if we prioritize public health and sacrifice community engagement is essentially aimed at also driving health protection. So this is the issue we're debating. And based on what I've heard today, I'm ready to make a motion. I move to grant the appeal from Clean Air Coalition because I find that the decision to grant the temporary authorization to Ecobat in 2022 was clearly erroneous because there was not enough evidence to establish the necessity of rapid response.
Is there anyone to second that motion?
This is Member Ruiz. I second.
Do you have any comment with your second?
As somebody who grew up less than 2 miles of the Exide facility, I can understand why the community is skeptical when it comes to anything happening at Quemetco for this reason that I believe that mending community trust and creating a meaningful community engagement process should have been conducted when issuing the temporary authorization. Where is the line drawn when granting a temporary authorization for equipment that is set to protect human health and the environment? Temporary permits need scrutiny, and community members and interested parties need to be heard and included when any permit is issued, especially in a site as contentious as Ecobat/Quemetco. The illusion that Ecobat will be granted a permanent authorization to me seems problematic because I'm questioning how the community input has been taken into account. And to me, the argument that there has been ample public comment opportunities seems misleading, as these opportunities happened after DTSC had already issued the temporary authorization. For that reason, I am agreeing with my colleague, Sushma, and I second her motion.
Thank you for that. We have a motion and a second, Georgette.
Hello. Okay. So I too want to thank everybody in participating in this process. And I'm going to start with also supporting the motion. And really, I tried multiple times in asking the reasoning as to why this process was utilized at the time, and I couldn't find the rationale. I asked, I couldn't hear anything that really justified it, both from Ecobat and DTSC on the temporary authorization request. And because of that, I support the appeal requests from CAC. The permitting process needs to be protected and respected, especially since we're here to protect the health and safety of the residents and the environment. And we're asking residents to participate in this process. I strongly believe in really creating a public process to really be utilized in such way. And because of that, I strongly believe that we should upheld the permitting process, whether it being temporary or regular process, and we really need to ensure that we're creating clear definitions, because I think it's a slippery slope that brings us to where we are right now based on personal rationale. I don't think is a good reason, and I hope that DTSC will hopefully take this opportunity for future to really define a stronger understanding on how these processes are being utilized and not leave it up to interpretation just because that is really risky. And it's not the right way to make decisions. So this time around, I think we really need to upheld a process and really ensure to community members that the department is here to protect the health and safety of the community. And these processes are going to lead to that if we're asking them to participate in trust. So because of that, I support this motion.
Thank you, Georgette. Alexis?
As everyone appreciates, we have a narrow issue on appeal here. Was the 2022 temporary authorization decision appropriate? Was it appropriate at that time based on the record that we have? Was there a clearly erroneous use of that temporary authorization authority? It's, as DTSC noted, it is different than the question of what would be appropriate now in November of 2023. I do agree with the approach and the temporary authorization that DTSC issued, and I do not feel that there was a clearly erroneous use of the temporary authorization. Thank you for your hand gestures. Continuing on, the way forward is certainly vexing, and I'm hopeful that the forthcoming permit decision, the draft permit issuance, will be an appropriate way forward. I do think that equipment to better manage the liquids is a very important part of this operation, and it needs to be done in a way with all of the considerations that have been mentioned with regard to community engagement. So I do support the action that DTSC took, and am not in support of the motion, but with all respect for the consideration that my colleagues have given it and that the parties have presented to us tonight.
Okay, thank you. I support the motion to endorse the appeal. And so I think we have 4 votes in favor of the appeal. And yes, we should call the vote. I think we heard from everybody. All those in favor of, what's the language I'm supposed to use?
Sorry.
I am.
Madam Chair, would you like to call?
I want to restate the motion. Okay. That's what I'm looking for, to call the vote.
Go ahead and restate the motion, and then I'll call roll from left to right for the vote. Did you want to restate the motion? Or
I would like somebody to repeat the
Board
motion.
Member Batia. Okay.
I can't remember what the final order says. Here's the final one.
So the motion is to grant the appeal from Clean Air Coalition. I made a motion.
The motion is yes. To, right.
Do you want me to read the whole thing? Go ahead. Yeah. So I move to grant the appeal from Clean Air Coalition because we agree that the decision to grant the temporary authorization to Ecobat in 2022 was clearly erroneous because there was not enough evidence to establish the necessity of rapid response.
Thank you. All those in favor of that motion, Georgette? Obviously, Sushma yes. Made the motion.
Yes.
Okay. And I vote aye, yes. And
I vote no.
Okay. Thank you. So that is 4 ayes and 1 nay.
So the motion passes. Okay. Thank you. All right. I hate to call you back to order, but I think I have to. There is a draft final order that I'm directing the staff to complete the final order with the rationale. The draft final order was posted with the 2 options for either adopted or not. And so we've adopted that motion. and the staff needs to augment that with the rationales that were given and post it on the website.
Right. Yeah. So
within 30 days.
Yeah. Let me just, if I may.
Oh, please correct me.
So for all those here, we had a draft final order that was put out before this hearing, and in there is basically a placeholder where we're going to be dropping in findings. Those are going to basically summarize what you heard here today. And we're going to do our best to get that out as soon as we can. We likely will have that out before the 30 days, but you'll be seeing that from us, and that will be obviously what you heard here today with put in more written format.
But the final order goes into effect immediately. So the vote has been taken, the order is in, and now the paperwork will commence from here. And I know for some people, this is just disappointing. For others, it's just the beginning of the next process. And so I'm really hoping that in the next process, our level of participation and engagement, and hopefully the board won't have to hear another appeal because that the process on the permitting will now proceed. So I want to thank Ecobat, DTSC, and Clean Air Coalition Earth Justice for this day, this very deep and robust participation, and all of you who attended, who were really mostly very well behaved. So I thank you for that. We've had a few Donnybrooks at our meetings, so I'm really grateful that everybody was pretty contained. And it was a long day, but we heard you, and we heard you. And I hope everybody appreciates that we're doing what we were designed to do, which is to hear from everybody. So thank you very much. The meeting is...
Can I get a motion to adjourn, Madam Chair?
Oh, yes. I want to acknowledge our staff. Please join in. You've cheered for a lot of things. The staff from CSUS, the DTSC staff, Cal Recycle, the interpreters that you... Pardon? And the community center staff. So let's thank everybody. It was a big day. Thank you. And and I hope you all come back tomorrow for a really exciting Board of Environmental Safety Day where there's a lot of information and a lot of presentations that I think stay engaged with us, okay? We came to your community. We'd like to see you come back. So the meeting is adjourned. Thank you.
The meeting is adjourned at 8:01 p.m. Thank you.